have a problem. Whom
No.
you want to blackmail?
No, I do not have the only problem with them.
Don't waste court time
They,
unnecessarily.
they have been misleading this honorable court. They have
No case to
they have hide the fact.
There is an habit of filing one after the other frivolous petitions, including some contempt petitions which have already been dismissed. No case to entertain this petition without dismissal.
No, sir, this is not the frivolous.
All right, thank you. Item 2.
Yes,
Yes, please.
Lord, this is coming from a refusal by the Honorable High Court to appoint an arbitrator in Section 11.
Absolutely. Issue notice, justice.
I'm obliged.
Lordship, please.
Your 9 was pending. How could 11.6 be rejected?
That's right. That's the limited issue.
My lord, item 3, my lord. This is,
Yes.
my lord, physiological reality of large population, my lord. Twice I have come before and the orders have been passed. They have not even
First,
responded.
tell us what is the substantial difference between the earlier petition and this petition?
My lord, because they are not acting. That's the problem. 2 orders have been passed. If your lordship sees page 148,
First, we would like to know
my
what
lord.
is the difference between the earlier petition which we had.
My lord, first petition was filed to point out that this is the problem. The order was passed to say that the government of India will look into it. Now I filed representation. They did not respond to it. Then after 1 year, I again filed the petition here.
This issue has been, I think.
No, my lord. The issue is in Jaya Thakur.
Supreme Court, second time.
There is at least one state which has notification, my lord, a state of Bihar. 2, Karnataka has also come up with. Odisha. And in
Equality, on women empowerment. These petitions are very deep-rooted design behind these PI. These are not bona fide petitions. These are basically only to create a psycho impression in the young women that you are still inferior. You have some natural issues that you cannot be at par with the male person, and therefore you cannot, during a particular time, you cannot work like that.
my lord,
Where the women platforms coming before us?
my lord, at least on that issue, on the issue of locus, my lord, at least women.
Please understand the long-term
I understand.
adverse impact of these
Yes,
things.
yes, my lord. See,
You want to create them that again.
no. That's not the intention.
Why are they? They are.
That is not the intention. That is the reality of the society. That's the Your lordship. This in Jaya Thakur, the coordinate bench of this honorable court.
Is this we are completely in agreement with you,
My lord.
and perhaps affirmative action is always recognized. Affirmative action in respect of women
Yes.
is recognized, constitutionally recognized. But look at the practical reality in the job market.
My lord.
The more unattractive the human resource, the less is the possibility of consumption in the market.
My lord, that
These
is
are also factors to be looked into.
these may be factors. I am not saying, your lordship.
We see it only, and you're right, absolutely right. We will see it from the rights regime. But look at it from the business model. Will an employer be happy with competing claims of other genders.
At least it, my
You
lord,
understand?
in the
If
right
someone-
regime.
If someone create a right of taking 3-4 days leave in a month, according to you, who is
2 days. 2 days
2
have,
days, yes.
this is the state
106,
of Bihar, my lord, it's 2 days.
106.
the
106.
Your lordship
private
may see-
sector, the entire private sector, you are creating such a
In the
structural,
beginning, my lord, because it will happen stage wise, my lord. So in the beginning, it could be confined to,
Till now.
yes, from 1992.
That we
The state
see.
of Odisha has, Karnataka has come up. Kerala gave this relaxation in the schools.
to their growth, to their understanding, to their maturity. You do not know the kind of the mindset that stands created in the workplaces and how
Lord,
then
may
the
I
authorities
suggest,
start behaving.
your
them.
lordship may be absolutely correct on this. I am not getting into this. Since twice this matter has been referred to the central government, at least they could speak with the stakeholders. Number one. Number
All
two,
right, they have understood it
my lord.
for them to decide.
Number two, at page J, I have given instances, even private companies voluntarily they have given considering the problems.
Let them do it voluntarily. If they are doing excellent,
Yes, my lord.
that's a very good thing. For that, let social
I am on public,
awareness,
I am,
some campaigns, some sensitization programs can be done if they do it voluntarily. The moment you introduce as a law, as a compulsory condition, you do not know the amount of interest and damage you are going to do their career. Nobody will take them in the big responsibilities. Nobody will in judicial services, people will not assign longer trials even to them.
my lord,
That kind of
at the
impediments
same
will
time, the kind of problem they undergo.
Absolutely. Again, we
As
are saying
it
that
is-
there is
For that, your lordship may at least ask them at least to respond. I will not go beyond that.
Why should we? You have done your job, that's all. You should sit at home now after informing everyone.
send it to the
Lord, may-
earlier ministry.
This was given, your lordship may see the second order, my lord.
The
If,
petitioner has already, and if third time he comes, at least that will I'm there, then we'll take some action. Why they unnecessarily become the proponents and the spokesperson for a community who himself have not come before us? Unnecessarily projecting themselves as if they are the harbingers of. The petitioner has already brought to the notice of the authorities the issue sought to be raised in this petition. It seems to us that whatever was required to be done at the end of the petitioner, that he has done in the presumably in the interest of for the welfare of the young women, of young working women. It is not necessary for the petitioner to approach the court time and again and seek a positive mandamus. Positive mandamus, sir. Kya बोल रहे? To doubt that the competent authority will earnestly consider the observations already made by this court in an order of April 24th February 2023
And
passing
87,
with petition serial number 170
724.
and 8th July 2024 in writ petition number so in writ petition number 172 of 2023 and 327 of 2024
Framing the model policy after taking.
the model policy for consideration by all stakeholders. By all stakeholders.
I'm deeply obliged.
They should understand this will have.
I understand this, my lord. I am not going there.
Our fear
Difficult
is
to
that
wade
what
into
will happen.
policy, sir. Very difficult to wade into what is weighing with the government in not coming up with a policy which is of an affirmative nature. It's for the government to take the call.
Deeply obliged.
Your Lordship, I seek a short pause. Your Lordship, I seek a short pause in this.
Yes.
Lordship, I seek a short passover in this matter. A short passover in this matter.
What is password? Who is to argue?
The Union Senior Counsel is in his selection court
Huh?
4. Court 4.
Who is the counsel?
PV Dinesh, sir, senior advocate.
Call him. Why you are auctioning the residential house if that hotel itself is sufficient?
But that's what had happened is we had put this hotel for auction on 5 different occasions. So far, no buyer has come forward. In fact, I wanted to make a suggestion, Madhaj. Now we have taken possession of the hotel last month. We can put the hotel for auction again because we have a possession, hoping that a bidder may come. If we are not able to sell, then we may have to proceed against the residential property, Madhaj.
Very you right.
That's why. So
Do that.
Lordship may record my undertaking that we'll put it for auction one more time. If we don't succeed,
Now,
then
earlier the hotel was probably in your possession. So obviously, who will come to give the bid? Now that bank has taken possession and now if they will auction most probably they will succeed in selling the hotel. So they are making a fair statement that if they are able to sell the hotel, they will do it. And if they are unable to sell it 5 times, they have already done it.
yes, Madhaj.
They have not succeeded. So if they succeed and they sell it, good and fair enough.
And also, Madhaj, I must mention just one on the conduct, Madhaj. In the earlier proceedings, they had given an undertaking before your Lordship that they make the payment. That's why we handed over the possession of the property.
And then
They could not make the payment. They did not hand over possession. We had to take
That's
steps.
also not good.
We had to take steps to take hand over possession. 8 months is lost during that process, Madhaj. But still, we stand by the undertaking that I'm giving to your
So this
Lordship.
application has been filed seeking modification of the order dated 14th November 2025. Learned counsel for the respondent bank, whom at the outset submits that 5 times auction was conducted to sell the hotel, but no bidder came, as the possession of the hotel was with the petitioner alone. Petitioner borrower. After the petitioner failed to honor the undertaking given before this court, the physical possession of the hotel has been taken by the bank. There is now a possibility that some bidder may come forward to purchase the hotel. Land counsel further state that The endeavor shall be made to firstly sell the hotel to auction. And it is only if no bidder comes forward that the alternate second mortgage property, namely the residential building shall be auctioned.
Yes, Manoj.
In our considered view, the stand taken by the bank is just and fair. They shall abide by the above stated responsible.
Manoj, let them also attempt to bring a buyer, my lords. They can also attempt to bring a buyer, my lords. Yes, Manoj.
It goes without saying that the petitioner may also bring a buyer for the hotel as soon as fresh auction is conducted by the bank.
Great from Manoj, great.
Well, it's in item 5, we are requesting your lordships to look into this issue. Now, there's a very, very important constitutional element over here, because we have a 6th schedule, which is a very potent provision and a provision which has, unfortunately, according to us, not been permitted to work out at all. We have annexed, which your lordship will find towards the end of the petition, a list of 16 statutes. They begin, my lords, at page 1068. And there are 16 statutes. Now, when we use the expression statutes, the 6th schedule itself contemplates 3 types. One takes uses the expression laws, but it also uses the expression regulations and rules. So this is,
Heard by the other bench, are you?
sorry?
Is there any other matter, somewhat similar matter that has been heard by some other bench?
So there is.
Yes, that is, Manoj, I might just indicate to your lordships, that's absolutely true. We have mentioned that. It's not similar. It's similar in the sense it's a direct approach under Article 32 of the petition. It deals with elements of election rules, etc. And this court has entertained and issued interlocutory directions. Your lordship feel that this should go before that bench? I mean, I don't have any problem at all.
This was
Justice, yeah, no, I have a copy of the order. It was a bench headed by Justice Manoj Mishra and Justice Manmohan. I can just give.
it seems from the report that some related matter has been heard by the bench presided over by Justice Manoj Mishra. That this matter be also listed for the same bench. Maybe next week. Because,
Did your lordship say it's a similar matter?
no, related matter.
Yeah, it's a, it's,
We have used the word related matter.
yeah, related to, okay, that's correct. I'm grateful.
Please, Your Lordship. Your Lordship, this public interest litigation raises a grave constitutional issue concerning the failure of.
Yeah, you tell us, you keep your first petition and this petition. What is the substantial change?
Your Lordship, and we have got the first petition also, but Your Lordship, now we have done more research and we have find out what authorities are doing. But Your Lordship, except very few occasions, there are hardly any policy on the part of the government or agencies, authorities to take some steps, so there should not be further litigation and people should.
Word to word, the same petition has been replicated. That is the now innovation in the law of pleadings. Because you push a button and the same petition will come out wherever you feel 2 lines, some paragraphs to be added.
Yeah.
Barring few paragraphs more have been added. The petition is complete replica of the earlier one.
Your Lordship, may I just submit one thing? Your Lordship had told, directed me to do some more research. So Your Lordship, we have done more research and we have come up.
Search in the sense that particular instances and you will then suggest what should be the remedy to them. You are asking for sweeping arguments. How can such an
No,
argument?
no, Your Lordship, we have given, Your Lordship, in the prayer, we have asked for this also, that what should be the now accountability and what mechanism should be adopted. Your Lordship, state can also suggest some mechanism. There should be at least SOPs which they should follow. And
Every state, madam, will have a different kind of SOP.
please, Your Lordship.
Every state have its own financial constraints. Some states are revenue surplus. Some states are in a very
Please,
pitiable condition. They
please,
are
Your Lordship.
borrowing and borrowing. They borrow money and pay salary to their staff. Huge recruitments have in the past been made.
Please.
Unmanageable and not even really required. The kind of employments have been done and they need money for paying their salary. So all those states, the moment you ask for formulation of a new policy, welfare policy, they say we don't have money.
Your Lordship, we don't want anything in broader way. Your Lordship, only if there have been some direction from this honorable court that at least all the authorities.
Direction, the appropriate course would have been, you can go to respective high courts. The high courts are the best suited platform to understand the financial conditions of the state, or every day-to-day litigation, they would come to know what is the existing policy that may require some suitable amendment, some incorporation, some revision of whatever they are providing to. If you go like this, maybe that you are in a better to help these poor victims.
Your Lordship, may I just submit one thing? Your Lordship, in this, we have given the data. Across the country, situation is the same.
Across the
There-
data is fine. Across the country, there cannot be a uniform direction.
That's true, but Your Lordship, at least there should be some major guidelines from this honorable court that at what stage, what authorities are supposed to do. At least if they do their duty, even then this problem will be solved. Right now, there is electric department, they are not doing the wiring properly. So many electrocution cases are there. Your Lordship, in one of the bus, many passenger died. Your Lordship, these are very small work which they are supposed to do to their own. In fact, there is no need for guidance or for any direction from this honorable court.
There you may be right, no guidance is required. For
No.
enforcement of law, it is their duty. It is their
That's true, Your
responsibility.
Lordship, that's
So
why.
wherever they have not done it, please, it might call for a cognizable offense to be registered through an FIR. For that, some directions can be sought. One can file a complaint under the new code. There are remedies available.
That's true, but Your Lordship may just say, Your Lordship, in case there are some directions from this honorable court.
Directions of what?
To the authorities, at least they should
Policy.
have some
Give us
SOPs.
example.
Your Lordship, at present, Your Lordship, we have tried, we have looked,
Everything is.
discussed with the
not initiative.
authorities. Your Lordship, we met some of the authorities and
Let
we
the high court
discussed.
also understand, and high courts
Your Lordship, may I just submit one thing? Your Lordship, just for example, Your Lordship, we have visited some of the officers who are executive members of this organization, Your Lordship. They approach and they came to know that in fact there is no standard operating procedure. So they don't follow any guidelines, Your Lordship. At least they should make some.
Who are they? Who are they? You are saying they are not.
Your
following. Who
Lordship,
are-
even officers, concerned
Officers of
officers.
one state, two
Yes,
states.
please, Your Lordship, but Your Lordship, the whole difficulty is they are having no such mechanism where they should think that, yes, this is our responsibility and we should do something. Your Lordship, the whole difficulty is this.
That is very unfortunate. If the-
That's true,
They
it's
have
very
to try.
unfortunate. But Your Lordship,
The officer, that what is their duty?
please, but Your Lordship, one direction from Your Lordship will change the situation, Your Lordship. And now, Your Lordship must just see that across the country, citizens are losing their lives due to preventive negligence of the public authorities.
One direction which you are asking for is a manageable direction.
Please, Your Lordship. Your Lordship, they should make SOPs, Your Lordship, standard operating procedure. The respondent, they should be direction.
Who are the
Please,
respondents?
the ministry should give directions to all the
Under
authorities,
which provision-
all the departments.
Under which provision the ministry is competent in a federal structure of ours?
Please, Your
There
Lordship.
are certain powers with state only.
But Your Lordship,
If the ministry says that you start paying this much, say, let us say compensation for a particular thing, they will say, all right, we will do it, you give money,
Your
give
Lordship,
us money.
I'm right now not only on compensation. I'm only saying they should give at least some
You are testing your-
directions
You are
that.
testing your, the list of reliefs that you are asking. You want us to run the administration,
No,
the
no,
entire
Your-
country.
not Your Lordship. I have given Your Lordship the broader prospect, Your Lordship. But Your Lordship, at the present, Your Lordship, I only want that at least there should be some directions to the ministry, Your Lordship. They should give directions further to the authorities and other departments that they should have at least some SOPs, Your Lordship. If they will make some standard operating procedure,
You want
all
Union
this.
of India, you want Union of India to
Union-
ask the state governments, direction
Lordship.
number B, that you repair your potholes, you repair your
Your-
roads,
Please.
and you complete your unfinished public structure such as bridges and flyovers.
Some
They
places.
will say, we will happily do it, please give us money.
Your
We are
Lordship,
short of
Your
funds.
Lordship, it's not, there is no money, it's not, there is no shortage of money. Your Lordship, there have
no
been
shortage of
some occasion where
money.
they have spent huge amount on the infrastructure, but it has gone total waste because it has not been done properly, Your Lordship. Your Lordship, this is quite, Your Lordship, this is a case where, you know, unsafe infrastructure is there. And just because they have not taken any action against those authorities and there is no SOPs, what action should be taken? Your Lordship, again and again, such incidents are being repeated. And this honorable court has repeatedly awarded compensation. And that's also now, if these would have been prevented, we would, the state and government has saved so much money, Your Lordship. There have been many cases where people have just gone in the pit holes and even whole vehicle has gone, but there was no such preventive action was taken earlier. Later on, they started doing all the precautionary measures. In case there would have been some directions from some authorities or from this honorable court, at least they should have looked into all these things. And then at least we would have minimized, if not eradicated completely, minimized these incidents where people are dying every day. Your Lordship, there are number of incidents. Your Lordship, just see, I have given the list and so many annexures are there, Your Lordship, which as annexure P1 is, Your Lordship, about custodial death. Then another incident is collapse of the bridge, Your Lordship. Man falls
Your
in,
petition is as good as like a showroom or a shopping mall, right from pothole to police brutality, to non-completion of bridges, non-completion of underpasses, everything is available there. You name any relief on the earth, everything is mentioned.
Your Lordship, that's true, but Your Lordship, here I'm only seeking, at least right now there is no authority to check whether people,
Civic infrastructure.
whether they are doing the work as per
Uniform
what they are supposed to do, they are not doing.
open drain, potholes, unsafe, unfinished bridges, electrocution, unattended high voltage cables, fallen electric lines.
Your Lordship,
The
I may
entire
just,
country, everything is to be run by the Supreme Court.
Your Lordship, may I just say one thing, Your Lordship? I've given a prayer 5, Your Lordship, issue appropriate direction to frame and enforce a statutory code of civil safety standard and emergency response protocol.
All right, thank you very much.
Oblige, Your Lordship.
The instant petition has been filed purportedly in public interest, seeking series of the following directions. Next paragraph. It may be seen from the very nature of reliefs that these are neither interrelated nor they pertain to one state or the Union of India. It is also difficult, it is nearly impossible to issue directions. It will be completely unmanageable affair until and unless the issues raised are specific to a particular state or its agencies. We therefore decline to entertain this petition, leaving it open to the petition to approach the jurisdictional high courts, whom I so advised, along with by way of appropriately drafted petitions. It is clarified that we have not expressed any opinion on merits.
Oblige, Your Lordship.
We are challenging the UGC guidelines.
How many times you will challenge?
There is one difference here now. After this honorable court was pleased to pass an order,
It's only that everybody wants to be there on the scene.
there is one difference here. After this honorable court was pleased to pass an order staying the 2026 regulations, the state of Madhya Pradesh has passed a new circular saying that you enact 2023 regulations.
So?
We are challenging both. Both are unconstitutional, both are contrary to law, Your Honor. And similar to what the honorable court was pleased to pass earlier ordering.
No, what has been done by the state of Madhya Pradesh?
State of Madhya Pradesh, after this honorable court invoked 142, there is annexure 5. Kindly come to annexure 5. Here. That happened after this honorable court.
First,
They
because
annexure 5, page 122. They bypassed this honorable court's order. This circular was dated 2nd February 2026. Direction to Vice Chancellor, Principals and Secretary. Subject, in accordance with the UGC Regulations 2023.
If there is earlier regulation, new regulation has been stayed, there has to be something, there can't be a vacuum to deal with the cases in between. Suppose if caste-based harassment takes place, where will the victim will go?
No, my only point is that.
Your
the
point, we are not concerned about your point. Answer the simple question.
Yes.
If 2026 regulations have been stayed by this court,
Yeah.
if an unfortunate incident of caste discrimination happens, caste harassment happens, where the victim will go?
As per 2012 regulations, Your Honor.
There are 23 regulations. Why should they go to 12 regulations?
Because 2023 regulations is also discriminatory, just like 2026.
That we will see what is to be done.
Dis-
But 2023, why didn't you challenge it earlier then?
Because we challenged it, but it was in objections. My
The-
apologies.
Enough petitions have already been entertained by this court. There is no need to repeat.
Yes, may it be tagged with others because I have more documents and to rely upon in this case, Your Honor. This is a very serious matter and that is why we have come up with very due diligence in this case.
We are not inclined. Yesterday and day before, we have told and strictly warned everyone.
No, we have filed way back, Your Honor. There were objections. That is why it could not come before this.
Then you are made confined to 2026. And if you want to challenge 23, then file a
We
separate.
have challenged both, Your Honor, because both are
We
discriminatory.
will not allow to challenge both. 2023, you are coming after 3 years. Then you owe an explanation.
No, Your Honor, we are coming because MP has,
Standard petition has confined challenge to two.
2023 has applied now, Your Honor.
2026 and 2023. We are not inclined to entertain such a petition. The same is dismissed with liberty to file separate petitions with respect to the 2023 regulation and 2026 regulation. Since we have not expressed any opinion, this order does not mean that the petitions to be filed by the petitioner shall necessarily be entertained. That's,
May my 2026 regulation challenge at least be entertained in this case.
we will see. What
That is the only request. Because may my petition not be dismissed and tagged along with others where I am challenging the 2026 regulation.
Yes, yes. Next item.
My lord, in item 8, my lord, in the first round, it was animal fat, my lord. On 30th September 24, your lordship's restrained.
Tell all these
My
things.
lord, all these are chemicals, they are using this bathroom
No,
chemicals.
who is asking you why you have become an expert on it? Who is telling you to tell this, all these things?
No, it is
If
public.
there is, you go and tell the authority.
Place 340, my lord, place 340 for a moment, my lord. On 30th September 2024, para 11.
Animal fat is not there, toilet use is not there. You are only filing your, this is defense you are taking.
It happened because SIT has found no animal fat, my lord. Now
Therefore, SIT
can
will find out. We have already told that as CBI matter has been entrusted to CBI.
Yes, my lord.
They are holding investigation. We have said that CBI investigation and administrative issues are altogether different.
Yes, my lord.
Whatever CBI will conclude in the report, in the
Yes, ma'am.
investigation report, court will proceed
My lord,
accordingly.
we will help CBI, but this is creating law and order problem, my lord, there. Coming from a high constitutional functionary, my
The
lord.
problem is that you want to,
Page
you
340.
will come to the right, real point.
My lord, page 340 for a moment, my lord.
Something else, we understand that.
No, my lord, page 340 for a moment, my lord. It is coming up, page 340 for a moment.
PIU.
No, in the sense, my lord, September 30th to 2024,
Yes.
para 11, my lord. May I read page 89 for a moment? First page 340. 340, you can see, my lord, this is after the SIT report, which is silent on animal
This
fat.
has already been taken notice by this court. Matter has therefore been taken away from the state police, given to CBI.
No, it was the 24, my lord. This is 26,
So what?
February 26, my
After
lord.
that 26, this matter has been given to CBI.
But in public domain, these comments are being made, my lord.
All right, next.
Liberty, bro. May I seek liberty?
What is next point?
This is the main point, my lord, and then
Yes.
for a moment, my lord, just for my satisfaction, page 89.
The writ petition, the instant petition purportedly filed, the instant petition filed under Article 32 of the Constitution is nothing but an attempt to reinforce the defense plea in a criminal case that has been registered against the suspects and investigation whereof has been entrusted by this court to CBI. we are not inclined to entertain this petition, from especially when the investigation is still going on. The petitioner, or for that matter, any other interested person, can submit the material in their possession to the CBI for the purpose of taking the ongoing investigation to its logical conclusion.
But my lord, CBI cannot restrain them from making public statement, my lord.
All right, thank you very much. Next.
This is item 9, if Lordships may see, my question was not pertaining to delimitation. Also, on that day, what has happened that first two petitions was pertaining to
Whatever your question is there, you, at that time you didn't point out, you can raise your question also there.
Well,
You
if
can
not-
add 4 line.
That's your question. And
That Smiti itself has been now non-existent. Where is the question of your continuation on that?
if Lordships may consider that aspect, my lords, that
there is
therefore,
no aspect to be considered, sir.
my lords, there are,
You are very kind to us. We should take away the leave.
Leave.
You are right.
In-
Should not be given the leave because those were cases of shift of the headquarters. So we felt that if the people feel that the headquarters shifting is detrimental for the local body function
Yes.
and their facilities, they should again given. But look at your situation. You are a office bearer of a Panchayat Samiti. You were elected from a particular ward which is no longer within the Panchayat Raj
My lords.
institution.
my lord,
So where is your right?
my lords, that's what I'm submitting.
If a post, the primary principle, if a post is extinguished by operation of law, is a vested right created in the holder of the post.
Well, that's what I'm submitting, lords. If Lordships may see the second issue,
Fine, we will take away the leave.
That
The
means
leave should
whatever
not be given to you.
well, my second grievance, I have two grievance, twofold, my lords. First is that removal, and second is the appointment of the administrator, my lords. There is no provision under the statute, my lords. 101 does not talk
Elections are
about.
about to take place.
If Lordships may see for a minute, 101 for a minute, my lords. Section 101, there is no provision with respect to the appointment of
Until
administrator.
and unless you have a vested right in continuing in a post, you are not concerned, apart from a public interest litigation, to challenge the appointment of administrator.
Also, I will just demonstrate to you, Lordships, that the provision statute itself says that by following the due process of law, only I could have been removed from the post, my lords.
Due process of law is the legislative exercise of delimitation.
No, but if Lordships may see that, the statute does not say. Statute says that it is only by way of a resignation, there is a removal. Otherwise, there is no removal, my lords. The
Whatever
fixed tenure.
arguing.
I leave to you, Lordships, but that is
Try to
the point I
convince
just
yourself.
wanted to make out, my lords.
You can't be.
Now, case to recall the order 26, 2026.
All right.
My lord, I appear for CBI. I support the interpretation given, my lord, though respondents need to be investigated.
Yes, Mr.
My lord, I appear for the CBI. I support the impugn order insofar as it gives interpretation to the act, though respondents need to be investigated. No, that's my case.
No,
Why we are here, my lord, I must first say that. My lord, there is an interpretation issue and the three judgments rendered by the same bench, my lord, there are contradictions. Now, for the functioning of our, my lord, the Lokpal, we need a authoritative pronouncement so that our procedure is, my lord, put intact by your lordship judgment, my lord. That is our purpose for coming here. Not, my lord, we have said so in our first opening para in our list of dates. We have said in our grounds everywhere. That is the only purpose why we are coming here, because there are certain issues regarding the interpretation of the sections which have been made by the honorable judges. And, my lord, so therefore, our main purpose here, my lord, it should not be misunderstood that why we are here, my lord. We are not here about any first one individual or two individuals. It's about not the interplay of the different parts of the section.
I don't know that one.
Just-
May I just say this?
Wait,
Yeah.
just sorry, before my friend says that, one thing more. Because there is a direction in the first case for a compliance that you must comply and issue the order, composite order under section 20, subsection 7 and
Yes,
subsection 8 together.
Status quo, and status quo, status quo.
Saying that.
Well, there should be a status quo then. Because otherwise, it should not be that, the judgment is in abeyance. Then, they'll go ahead, dehorse the judgment. I have a judgment in my favor.
That, my lord, I will be
So
opposing.
Status
my
quo,
lord.
status quo, so that they don't take a
Lord, can I
decision.
show 3 provisions if your lordship permits?
On that.
I'm sorry, Malaj.
We will not open our mouth on that.
Malaj, I have, on merits, I'm just saying, Malaj, let them not pass any order then.
I'm Lord in 10.1. There is a small issue in 10.1. Lord,
Malaj,
10.1
10 before
is
that,
the
Malaj, I'm in 10 minutes.
defense secretary Mr. Rajesh Kumar Singh,
Let's-
where
if
CBI
your
has
lordship
also
wants to
supported
consider,
not
Manoj,
on
we have no
facts.
difficulty. Of course, Manoj, there's a legal issue
10.1
here.
can be
Although the
discussed,
judgment is
that
very
is-
clear, in my most respectful submission, this is a sanction which contemplates, Manoj, pre-charge sheet and prosecution.
Mr. Gupta,
Yes.
we will want to examine the findings in paragraph 78, 76, where the judge says that the power of the Lokpal is circumscribed till investigation. It does not have a role in prosecution. This we require to examine in light of section 12 of the Act.
I'm not on that. That doesn't trouble us. We are more concerned. Yes. Well, yes.
Because that is the foundation of his interpreting that 20 clause 7 and 20 clause 8 need to converge.
May I just add one thing, Manoj?
It says after 27.
Manoj,
The
may
word
I,
used in the section is clear, my lord.
Manoj, may I just say one thing?
After 27, then thereafter.
What the judge has done is that the High Court, he has made a purposive interpretation of the two provisions and said that although the word is after, but we do not find in the scheme of the Criminal Procedure Code that how can the filing of the charge sheet and the prosecution be split. But then that we would like you to address us because we have our reading of the law, which naturally will be
On that, my lord, if your lordship want to-
That's my-
initial.
My concern is this, Manoj. Dehorse everything that your lordship has said, Manoj. That is one part. Section 20, subclause 7 says, you will take my comments, consider, and then consider closure. The learned Lokpal says, I will consider that at the stage of a second sanction for prosecution. I am saying this, your lordship wants to consider, no difficulty. I did not interrupt my learned friend. Please kindly see straight away,
In
Manoj.
fact, asked you to put in your papers.
Then says, well, let's kindly see page
That is
19.
that is why the High Court finds the Lokpal at fault.
Now, let's kindly see page.
Go and ask for hearing.
Let's kindly see page 19. I'm reading from the Lokpal order. Let's kindly see the categoric observation made. Yes.
We are not permitting the prosecution as of now. The order has been set aside. What Mr. Kumar wants is the direction upon his client to pass a composite order,
Yes.
which, as per the interpretation of Lokpal, which prima facie we agree, may be an incorrect reading of 20
That's all I'm
subsection 7 and subsection 8.
So therefore, status quo, let them not pass any order. Therefore,
That is exactly
yes,
what
yes,
is
no difficulty.
You are asking for status quo, he asked for an order of injunction.
The problem, my only concern is, if your lordship passes a stay, they should not go back to status quo ante and then proceed there. That's my concern.
Para 89 need not be complied with. by the
Need
local.
not be
That's
Lord,
right.
may I, my lord, come in, my lord, if your lordship permits.
We can only say that para 89 of the judgment need not be complied with by the London Lokpal.
Please, my lord.
That takes care of it.
In the other two cases,
My lord, may I have, my lord, 2
No
minutes?
difficulty.
My lord?
No difficulty.
Lord,
My
may I
concern
have
was
2
not going
minutes?
back to the earlier position. That's all.
We will take up one by one.
May I have 2 minutes, my lord, for the CBI?
Honorable on so and so date, then so and so accepts notice on behalf of the respondent.
Am I audible, my lord?
my lord, my friend is a peripheral.
We are on caveat. We are in caveat. Manoj.
Solicitor wants to make some.
My lord, can I have 2 minutes, my lord?
Yes,
Yes, my lord, my lord, the real, according to me, my lord, the real interpretational exercise is in para 61 and 63. My lord, if your lordships can come for my satisfaction. Your lordships have seen section 12.2 and 12.3. The question is, my lord, can there be a second round or not, my lord, for the purpose of grant of sanction? That's the essential question. Please come to, my lord, page 31, para 61. This, my lord, is the real interpretation, my lord, which in my submission is a correct interpretation. Your lordships have 61. My Lord Justice Bagchi has 61.
yes,
Yes.
yes.
What is significant to note is that the said investigating agency delineated in section 20, subsection 3 is a body that is unconnected to the Lokpal, since the Lokpal only has an inquiry wing and a prosecution wing. The investigation, therefore, in appropriate cases is consigned to scrutiny by an independent external body as an additional safeguard and to obviate any taint in the event the inquiry has been conducted by the inquiry wing of the Lokpal. It is further relevant to note that once the learned Lokpal decides that its prosecution wing shall file the charge sheet and conduct the prosecution before the learned special court, section 12.2 and 12.3 empowers its prosecution wing to file the charge sheet strictly in accordance with the findings of the investigation report, etc. Now see 63. We are of the considered view that learned Lokpal has completely erred in treating section 20 subsection 8 of the Act as providing for a second round of sanction. The language of section 20 subsection 8 is clear and unambiguous and does not in any manner confer discretion upon the Lokpal to grant another sanction once a sanction has already been accorded under section 27 small a. That is by Lokpal only. Please see 7 and 8. This is the limited scope of this controversy. As I see it, please see.
Correct, Mr. Solicitor, correct. Because if you see the two provisions, apparently they overlap. But there are very fine distinctions between the filing of the charge sheet and the conduct of prosecution.
Exactly.
And when the conduct of prosecution comes into interplay, just see the statutory history of Lokpal Act. The Lokpal Act is an act to ensure and insulate, create public confidence in inquiry, investigation, and prosecution
Correct.
of public servants, where public servants are highly placed and therefore there is a real or a perceptible fear that he or she may disable these agencies, namely the investigating agency and prosecution agencies, from fairly conducting their statutory duties. So does the Lokpal not apply his mind when he gives sanction at 20 clause 7a that he is satisfied with the nature of investigation, the fairness of investigation, and the proposed conclusion in the investigation report, and gives a sanction to submit the police
My
report?
answer is yes. My answer is yes.
Ordinarily, it would have been, as soon as it is filed, it would be the duty to conduct the prosecution through the prosecuting agency, which is aligned with the investigating agency. But in 20 clause 8, the Lokpal takes the second call that this investigation fairly done with appropriate application of mind should not go to waste by an indolent prosecutor.
Exactly.
So we will withhold the prosecution from the investigating agencies, prosecuting agency, and make continue direct prosecution through my agency. How will Mr. Solicitor General, we didn't want to express our mind on this because lest the independent views of the erudite councils are to a certain extent slanted.
Please see 23 also. Please see 23 is also very interesting.
23 subsection 1.
That is why, section 25 talks of the supervisory
And
The expressions in 23, 27, and 28 are all different kinds.
And 23 is talking of sanction.
This is
23 is talking of sanction for prosecution under 27.
for the first time before this court.
Yes, exactly.
Let us examine the interplay of these sections in light of the BNSS and Prevention of Corruption Act.
Although
Lord,
this is very
before your
separate
lordships,
and notwithstanding.
before your lordships dictate the order,
Your
10.1 is
lordship is
different.
staying 89, para 89. That's not different.
Can I, my lord, make a point with regard to 10.1, my lord? 10.1 is a matter where the respondent is, that's a different order, my lord.
Mr. Singh,
10.1 is a matter where, my lord, the secretary DPIIT, who's presently the defense secretary, is alleged to have only with regard to some promotions. Now that CBI has found to be not frivolous, and CBI has twice over made a report saying that there is no
We are coming
criminality
to
at all in this.
10.1, Mr.
Well, a 37 can go with
10.1
10.
is separate, bro.
37
That's
is
that's
still-
what I will.
37 and 10.
One we are taking separately. First, we are passing in 10, item 10. Then say accept notice on behalf of respondent one.
One
With
is-
assistance-
Well, it's my learned friend.
Anyone,
Samudra Sarangi is there.
anyone, then say, Mr. Solicitor, who is from your office? accept-
Mr. M.K. Maroria.
MK Marodia.
M.K. Maroria is the government, your.
And anyone for this Nishikant Dubey?
No, but that notice will have to go, Milord.
Huh?
The
Notice
complainant
will
is not here.
All right.
So notice will have to go.
Let respondent 3 complainant reserve to the notice pursuant to date. The sub-respondents may file their counter affidavit within 3 weeks. Within 3 weeks. Then say meanwhile, then Lokpal need not to comply with the directions contained, comply with para 89
Please.
of the impugned judgment dated 19th December 2025 of the Delhi High Court.
Lordship, very grateful.
37 is with 10 millets. 37 is a subsequent order millets.
Now comes 10.1.
The 37 and 10 are connected. 37 and 10 are connected.
My friend is
Item
right.
37 and 10 are connected millets.
All right, 37.
We had not for a, Lord, we had gone for a clarification and modification. Lord, some.
Oh, that time.
So both order will be in 37 as well, Milord.
10
and
No, in
37.
37, the 37, the order of the High Court shall remain state.
Lord,
Here that within 2 months also comes.
please.
There it will remain state.
Yes.
Will remain state.
Now the second matter.
And notice may come to us because we are not on caveat in 37 millets. Yes. Obliged.
Item 10.
Number 1 is on caveat, Milord, is what I am told.
Not in 37. In 10 we are, not in 37. Yeah.
37 will serve.
Yes,
In
that's,
37, you are not accepting notice.
no, we are millets. We are accepting notice. We are not on, yes, yes.
Will serve them.
Sure.
All right, now.
10.1, my lord, CBI is not joined as a party.
No,
It may be joined, my lord. There is no criminality in 10.1, my lord.
Only because Lokpal. All are different matters.
Yes, my lord, I am in
The sections
10.2.
are different, but I'll tell you, Lordship, what is the procedure. Here, what has happened is that the preliminary inquiry found that there is not enough substance in prosecuting. The Lokpal sat on the bench and said that we'd like to give issue notice because we filed that we need to hear them. We find there is some substance. So the High Court said that you have prejudged the issue before issuing notice. You could not have prejudged. Milord, Milord, I am differing with the preliminary inquiry and I need to give some reason why I want to hear the other side, and then, Milord, after hearing them, decide whether the preliminary inquiry is right or wrong, Milord. So that is the position. The High Court says you could not have done that. You have prejudged the issue. So therefore, Milord, the High Court has quashed that order.
Lord, please see
And
the
the
preliminary
notice-
inquiry, my lord. There is
The
nothing
notice was
criminal
issued
about it.
To the Milord, to the respondent public servant. Only a notice was issued to show call and to come and present their case. So the interpretation. the-
10.1, Lord, I had gone to the public servant, went to the Lokpal.
Nothing is required. It has been quashed. So let status quo be maintained. That's about all.
No, Lord, can your lordship just hear me, Lord? In 10.1, the High Court initially didn't grant me an interim order. High Court said you go and represent before the Lokpal. So the public servant went before the Lokpal and explained that here in the complaint there is no criminality mentioned. Even the complaint as required to be filed in law is not filed because there is no offense mentioned at all in the complaint. It's a promotion matter. It's a purely promotion matter, service matter, my lord. So the Lokpal second time also, in spite of the Lord representation before him, still goes ahead with the matter and says that I will hear further. It is at that stage the High Court is finally quashed.
That's why we are not passing any interim order, Mr. Vikasing. We are only now that comprehensively want to explain and lay down the powers of the Lokpal and the areas or might be the statutory restrictions or limitations, whatever are there. We just would like to lay down that. Otherwise, in para 28, 29 is only discretion of the Lokpal. If any action taken against you, you will be entitled
No,
to.
there is no action taken against us. Nothing,
No
Lord.
action taken so far, and probably they will not take also.
The fact that they filed the appeal is, Lord, I don't know why they filed the appeal, but in any case, if your lordship was simply examining the issue, Lord, I can't have any
In the
objection.
beginning, we have come here for an interpretation by your lordships, my lord, so that for the future it is concluded that how the, my lord, the procedure as prescribed has been correctly done or not done. Lord, I made clear from the beginning, my lord. And my
only
friend
one
said
request,
that there was
Lord.
no criminality involved.
Are you
That is
accepting
wrong.
notice on behalf of 1, 2, 3, all the three?
Please, Manoj.
Lord, only one small request, my lord. Since he is the present defense secretary now, the respondent number 1, your lordship should indicate that your lordships are not examining the facts, because otherwise it will give a wrong, my lord. It gives
My lord,
your lordship knows.
I join my learned friend, my lord. It would have a ramification. Your lordships may say only on interpretation.
Only on interpretation.
Notice is being issued in this case only for the limited purpose of for limited purpose of interpreting.
Section 20. Subclause 2 and 3.
Actually, your lordship can decide it in the other matter. This can go ahead. This can be dismissed also.
This case was, my lord, that while granting promotion, people who were 15, 20 years junior were superseded, my lord, and that's how the, my lord, the departmental promotion committee was held, and that's how he, my lord, as secretary DOPT or DPIIT, my lord, some that department, my lord, he approved that and said, no, this is the way it should be done. So
It's
therefore,
not a
that is
crime.
the
It's
basis
not
of
a
this.
crime. It may be
Actually,
wrong,
also,
but
it's not
not a
right. I was
But
not even
I'm
the
only
secretary
saying,
there.
Lord, today I am not saying that I want to proceed or anything. I want an interpretation from your lordships on the 23A power, whether I was required to give some reason for the purpose of going against the preliminary investigation and find out, my lord, that from the person who has been called, my lord, the RPS. So that's the nature of my petition.
Can I just make one line submission, my lord? In this case, I was not even the secretary when the promotions happened. I was a secretary when somebody, my lord, made a complaint, and I.
Since the notice is being issued only to determine the scope of powers exercisable by the Lokpal
Petitioner.
within the statutory framework,
Please.
this order shall not be construed as a permission by this court to proceed against this member.
Now, my lord,
Only one small request, my lord.
Status quo, my lord, because the records are required to be kept, my lord, under the act. So therefore, status quo only, that's all.
How the status quo should be maintained?
Please.
Only for record. Only for record.
Yes.
Because of
Only for record purposes.
Preservation of the record. Preservation of the record.
preservation of the
Only for preservation.
Lordship.
my lord, now
Your
10.2,
lordships, my
very
lord, a
different
small
facts.
request. A small
10.2
request, my
very-
lord. My lord, if your lordships can consider joining Union of India as a party, it's an interpretation issue. Here in the second matter, even CBI is not a party, my lord.
That's it. Oh, only CBI is party.
CBI is also not a party in the second
They
matter.
only made Lokpal a party. Lokpal was heard, my lord, by through counsel.
That's okay, that's okay. I'm not complaining that why.
In the High Court, the writ petition was filed only against the Lokpal.
I understand it's not your fault, Mr. Ranjit Kumar.
Investigate or the Union of India a party.
We can say like this, that
That's entirely for your lordship. my lord.
keeping in view the importance of the issue involved, we
Please.
deem it appropriate to include Union of India through the Secretary Department of Personnel.
No, my lord, actually, this Lokpal is under the Ministry of Justice and DOPT both. my
Through
lord.
the Secretary
So therefore,
of
my lord,
Law and Justice.
that's how I have understood.
party
I may be wrong, my lord. I don't know.
As a
The learned SG would know better.
Mr. Marudia will accept notice on behalf of Union of India also in both the cases.
Please,
Then we request Attorney General for India and Learned Ministry of India to assist.
I am appearing, my lord. Learned attorney may have some conflict, my lord. I'll be appearing.
Learned Ministry of India will assist the court.
Yes.
Item 10.2.
Yes, no, it is
very
10.2.
different
Let me explain what happened. In the
You should understand.
no, then, my lord, if your lordship don't want to know the facts just now, my lord,
No,
lordship,
actually that this person was not named with the complaint.
Yes, my lord.
yes.
No, he was named in the complaint, yet no notice.
सर आपका ब्रीफ पढ़ के आए हैं हमें थोड़ा हमें अपनी सैलरी जस्टिफाई करनी है.
My lord, During the course of investigation, he was found to be the beneficiary of the misdeed, my lord, and therefore, my lord, a notice,
No, but then you can't pass some order against someone without.
No, my lord, the order was passed against the others also and him also, but it was an order to be passed under section 20 subsection because the investigating agency found his involvement.
You need not to, and he is a small level employee,
No, but he was the chief locomotive inspector.
driver of the train, that's all.
Chief locomotive inspector now. And only what happened, my lord, I am just telling you. So for the purpose, my lord, what happened, my friend's case is the High Court has said you go back and start from the preliminary inquiry stage of hearing him. So, my lord, that preliminary inquiry and a further inquiry would be not necessitated because what will they do now, my lord, after having come to a conclusion? So, therefore, my lord, on this aspect, we have come here, my lord, that to say to go back. Supposing, my lord, an accused is fined during the course of inquiry.
Case where the complainant does not implicate him, the investigating agency does not.
He was named as a
Only
beneficiary.
you want to prosecute him.
The investigating agency found him. He was made in the FIR. Can you see the FIR? No? He was respondent number, accused number 6 in the FIR.
No, initially there was nothing was found against him.
No, my lord,
only
it
with
was-
your intervention that.
Something was found, my lord, the OMR sheets. My lord, the OMR sheets between the carbon copy, the CFSL report.
What is the date of the FIR?
The date of the FIR, my lord, is at page number 98, 11/3/2025.
Exactly. Before that, you passed an adverse order against him on 21st February 25. That's why CBI registered FIR.
Not pass an adverse order against him.
Hmm.
Because that was a preliminary order for the purpose of under section 20 subsection 3 for the purpose of investigation. The High Court says you did not hear him at that stage. At that stage, my lord, I did not hear him because, my lord, in the complaint, in part C, my lord, under the rules, there is a part C. In part C, you have to name who are the persons. 5 officers were named. He was not named. That is correct. So we heard those 5 officers and thereafter issued notice.
But exactly we are pointing out, Mr. Kumar. He was not heard at all. His name was not there in the complaint. And that's why rightly you did not hear. We are not blaming you.
Please.
You rightly did not hear because his name was not there in the complaint.
Yeah, but in the FIR, my lord,
Indeed, because once you pass the order, in the FIR his name is added.
No, my lord, no, not because, my lord, I just kindly just come to page number 98 first, my lord. Kindly allow me, my lord, if your lordship don't mind, 2 minutes. Page 98.
If tomorrow the CBI finds any incriminating material against him and they come to you to seek necessary permission, you may do so. But today he is being implicated only because of only misinterpretation or in purported compliance of an order passed by you.
No, with all due respect, my lord, in the preliminary order, it is not said so. Preliminary order only passed, my lord, under section 20 subsection 3 was, after hearing those public servants and the competent authority, that you
Read your order of 11th February. Please read your order of 11th February.
Yes, my lord. Please, my lord, kindly come to page number 83, my lord. It's also extracted in the judgment. If your lordship like to read that, my lord, at page number 9.
If you come to page 99, the FIR,
Yes, my lord.
see the opening line itself.
Yes, my lord.
Para 12.
Yes, my lord. 12, my lord. The Honorable Lokpal of India, by order dated in complaint number so and so made before it has directed CBI to conduct investigation. In the said order, the Honorable Lokpal of India has also directed to keep the identity of the complainant and the RPS, respondent public servant, confidential as per the provisions of such and such. Copy of the order dated so and so is enclosed herewith. Therefore, in compliance of the directions of the Honorable Lokpal of India, a regular case is registered against so and so, so and so. And in that, my lord, in serial number 6, on the next page, 100, my lord, line 5. Designation Chief Loco Inspector for the offences under so and so. Now, he is the beneficiary of the OMR sheets, which are manipulated as per the CFSL report, which came out in the investigation conducted, my lord, and thereafter the report was filed. When the matter came at the stage of 20 subsection 7, the notice was issued. He challenged it on the ground.
Now comes to
his reply also.
Now comes to page 88 of your order.
Page 88. Please.
Para 9.
Para 9, Lord.
You heard one XYZ?
Sorry, Lord.
In para 89 and 9.
Yes.
You have heard one XYZ?
Yeah, my lord, we heard all of the five,
Uh,
all the five.
Not him. And the directions ultimately apply to him also. If tomorrow you can hear and pass an order.
No, my lord, I don't mind, my lord, hearing him now. If your lordship will not say so. But what I am respectfully submitting is whether, my lord, any fruitful purpose would be served for a re-investigation of the entire inquiry. Once again, after hearing him, because it is, my lord, suppose I ask myself this question, my lord, if your lordship permit me, that if during the course of an inquiry, an accused is found, Lord,
Clause 7 stage, you have given him hearing.
no, I have called him
23
for.
you have not been heard.
He has
He has
called it.
replied.
Malad,
He replied to that also, and he simultaneously filed a petition in the High
All
Court.
right, now you hear him at 20 clause 7 stage.
Yes, that is the order, my lord, no other
That
thing.
is the order of the High Court also.
No, High Court doesn't know. High Court said.
High Court goes to 20
You
clause
go to
3.
20 subsection 3.
FIR se karo.
If your lordship see the direction.
That's an impractical order.
My lords, please have a look at, my lords,
That is an impractical, all these niceties have no meaning.
I bow down, my lords.
If your
There
lordship.
will not be multiple FIRs.
My lords are right.
So the FIR has merged into an investigation report.
My lords,
And once such a situation has come,
my lords,
20 clause 7 hearing, we will consider as a post-decisional hearing
my lords are right.
for the FIR
My lords are right.
and a pre-decisional hearing for filing of the police
My lords,
report.
just have a look at
That's
page,
still all. But
page 22, para 35, my lords. Please have a look at it. My lords, very different facts.
I am with reference to.
Because other cases involve, my lords, 20 subclause 7. Now, here is a case, my lords. There were 5 persons. They were given notices under 20 subclause
that's why I
3.
pointed out page 88 to
Yes, my lords,
29,
my lords,
each one of them when heard.
my lords.
That was 23.
That
Right?
is pre,
That was 23
my lords.
hearing, which was not accorded to you.
Yes.
Now you are being heard only at the stage of 27.
Yes.
To be heard, my lord.
To be heard.
Notice has been
In
got.
20, because 23 now practically not possible. FIR has already been registered.
But my lords, against others. But maybe if I am given that opportunity,
FIR is registered against an accused or an offence, sir.
my lords are right. But my lords, my lords, please have a look at para 35.
Will it be every time
No.
a new accused comes, a new FIR will be registered?
My lords, not like that. My lords, maybe, my
You
lords,
are
purpose.
interpreting like that.
My lords, there is pre-stage, there is post-stage. Now, this is a case where there is a violation of
We
pre-stage.
will not apply the law with our eyes folded.
No,
We will apply the law in a pragmatic manner where your rights are not affected. At the same time, the carriage of proceedings do not become an absurdity.
My lords,
You're creating an absurdity.
now, my lords, may I respond to this? My lords, just may I respond to
The
this?
situation
Just-
will create complication for you as well as for.
My lords, I appreciate. Now, my lords, may I respond to that, my lords?
Right?
Please.
Because every time this will happen. sir.
No. If I may respond to that, allow me to respond to that, my lord, just 2 paragraphs of the High Court order, my lords, because my cases. Now, my lord, the
We'll give
scheme,
you an example
My
which
lord.
will help you to respond.
my lords, my lords.
An FIR proposal is before the Lokpal saying a corruption ring has been unearthed in preliminary inquiry. A, B, C, and unknown others
Yes, my lord.
are involved.
Yes, my lord.
Lokpal gives notice to ABC. Unknown others, Lokpal is also not clear.
My lord.
Investigation commences. Materials transpire disclosing the identity of these unknown others.
My lord.
Is it your case that the Lokpal again goes back to 20 clause 3, gives notice to those unknown others identified now, and if separate investigation and FIR commences? This will
My
be
lords.
against the entire tenor of.
My lords, I appreciate what is falling. I appreciate. But my lord, the very purpose of subclause 3 in this case is that if I had given an explanation and if the Lokpal is satisfied, then maybe the proceedings are dropped against me there. That is a very important stage for me.
Close the case.
You can't even plead this argument because it is not a case where 23 benefit has gone to your co-accused. Their stand under 23 has been rejected. They are facing trial.
My lords, one fact. No, my lord, that's not the case. There were 5 given. Only one has been, only against one FIR has been registered. Only against one, 4 have been dropped. Now, my lords, had that opportunity been given? Because, my lords, in the scheme of the act, that is why, my lords, I am beseeching, my lords, please have a look at 35. And now, my lords, what is the direction in this case? My lords, please have a look at page 30 to answer what was falling from Justice Bakshi, my lords. Yes, he can give me notice. I may convince him that you don't have to proceed. That's an important stage.
Go and convince. We are adding something in your favor. Being heard London Senior Counsel on behalf of the appellant Lokpal and then counsel for the respondent. We modify para 48 of the improved judgment dated 14th November 2025, passed by the Delhi High Court, to the extent that the learned Lokpal shall accord an opportunity of hearing to the respondent in terms of section 20 in bracket 7 of
3
Lokpal Act. So since the respondent was could not
Has already gone, my lord, and he's replied.
My lords, with,
And he has to be heard only now.
no, my lords, with respect.
Gone to him, he has replied to it, then filed the writ petition.
So
He is only
we are saying only a hearing only to be accorded.
Only has to go
No,
on.
my lords, with respect. Then, my lords, this is.
Then it's squashed,
that-
I can't do it.
Since the respondent could not be heard at the stage of 20 in bracket 3, he shall be at liberty to raise all the
No,
complaints.
my lords, with respect.
Were available, which
My lords,
could be available
In that case,
under 23 of the Lokpal Act. We request the land Lokpal to consider all such all such submissions that may be made by the
my lords,
respondent during the course of hearing.
my lords, with respect, my lords, just consider this, my lords. My lords, just consider this, my lords.
If you are
Now-
not considering what we can do, there is no other way out.
27, my lords, the point is that there is, my lords, I have to go back to 20 subclause 3 stage. Now, my lords, what is happening is, then, my lords, let me accept notice, I will assist, my lords, because, my lords, I'll show the facts. Let me accept notice, and then, my lords, let me assist, my lords, because, my lords, other cases involve 20 subclause 7, which is a post stage. Now, in the pre-stage, my lords, how can I be, now pre-stage, they have not heard me before registration, because other 4 have been dropped.
Of this act that prima facie corrupt people are now taking undue advantage.
My lord,
And
with respect,
simple state law,
my lord,
they have arrested by now.
my lord, with these kind of consequences, my lord, these kind of penal consequences, registration of FIR, I'm at least entitled, my lord. This request, my lords, I accept notice, then let me assist, my lords. Because, my lord, this is against me. At 20 subclause 7 is a different stage. 20 subclause 6 is a different stage. My lords will interpret it.
What will happen in that event, we will stay operation of the order and you will be arrested immediately. Because
lord,
there is an FIR against you under the.
My lords are putting that, my lords are putting me towards very tough situation, I appreciate.
Consequences.
My lords, I appreciate, but my lords,
Today, if you stay operation of the judgment, you will have.
my lord, the liberty has been given.
Arrest you.
They can start, my lord, because other 4 have been dropped at the pre-stage, my lord.
That is why you will take this plea now before. We have said all ground available 23 also you will be entitled to raise.
But, my lords, the procedural safeguards, my lord, 20 subclause 3, kindly have a look at for a moment, my lord. Please have a look at it.
You can't be prosecuted now because of the technical.
No, my lord, I bow down, my lords. I bow down.
If complainant will come before us, we will direct to register the FIR immediately, dispense with the all protection under the PC Act.
My lord, against me, there is
Every
nothing.
person will come to the court and say, no, I am entitled to like this.
My lords, against me, there is nothing, but please have a look at page
We are
24.
not saying that. Sir. That's why we said you will be heard.
Your rights are fully protected. Lokpal has ample power to direct closure.
My lords.
So if Lokpal has power to create closure, then where is the question of prejudice? we are testing principles of natural justice in procedural law. So we'll test it on the anvil of prejudice.
My lords,
On the other hand, your argument becomes completely absurd under the scheme of investigation as envisaged under ordinary law.
my lords, will kindly have a look at 20 subclause 1 and 20 subclause 3, my lords.
We have.
And my lords, now this is my lords, because at this stage, as my lord pleases, as my lord.
Obliged to your lordship.
16th February, Lordster issued notice returnable on 23rd March and some other matters. I'm just one. Lords, I'm praying for also notice on interim relief, because there are certain coercive processes.
No, we are not granting any interim
Your
relief.
lordship may just issue notice on interim relief. I'm not.
No, there is no. We have not issued in the first case. What is so special
No,
for them?
I'll tell your lordship what it is.
No,
There
there is
are
nothing.
several other grounds which have been raised.
Sorry.
I'm only requesting notice, Lords, because
No,
there are certain coercive
When
processes.
we will consider interim relief, we will consider for the first petitioner who has come.
Quite so. The question is only, Lords, this petition raises several additional
There is
grounds,
nothing special in
which
this.
I'll address on that.
They accept replication.
I'm sorry, Lords.
There is nothing special in this petition. Already petitions are there.
No, quite so. We have, Lords, raised, there are several.
All right, thank you, Mr. Singh.
When my Lord see my prayers, several additional grounds.
They are issuing notice, that's all.
My Lord.
Tagging with the.
And tagging that, deeply obliged. I'll address your lordship on that.
Please, Malad. I'm led by Mr. Datar in this matter, but he's. Malad, I'm led by Mr. Datar in this matter, but he's on his legs in another matter. If I could get a passover.
No. I've logged in, Lord. I've just logged in.
Malad, Mr. Datar is here. I'm led by him.
Similar matters we passed orders.
Yes, well, all matters are tagged along. Lordship may direct that it should be tagged along with SLP 19366.
For the pronouncement of judgment. Coordinate bench, Mr. Datar, is reserved the judgment.
Yes. So what has happened is, after reserving judgment, whatever notices were issued, their lordships were pleased to stay and keep it pending the judgment. We are expecting the judgment anytime now. But incidentally, the other matter came before your lordship 2 days ago on banning. That's a different issue, Lord.
That's it. The same order as 16th February.
Same order.
I'm most grateful. Malad, that is the order regarding stay, right? I'm most grateful.
May it please, Malad. 13 is a matter, Malad, where I had filed a PIL in the Bombay High Court. After that, I repeated another PIL. First PIL was dismissed by the High Court. Subsequently, there was a SLP filed by me. I've disclosed all of that before the High Court, Malad. A review also dismissed by this Honorable Court. I filed a curates.
Person, I think there is something wrong. Why has not been taken to some, he needs poor fellow treatment.
I'll just
He should be provided medical care immediately.
I'll just point out two things, Malad.
But seriously about the way he's helped this poor fellow.
Well, this is a qualified architect. He's done some good work in social surveys. My only concern today is this one. I'll just point out, and I'm not pressing it. At the outset, let me make this submission. I know, Manoj, I don't want to waste judicial time also. 2020, the first one was dismissed in 2022. There were certain amendments which were brought in, contrary to Manoj, the constitutional structure, etc. We had challenged that also in the new PIL.
As far as judicial time is concerned, that is the only time which is free for, without cost, free up to everyone. Even priceless personalities who are such an eminent person, they come here and.
Manoj, at least as officers of the court, Manoj, the least that we can do, Manoj, is to ensure that, Manoj, we don't take your lordship's time beyond a certain this thing, Manoj. We are always reasonable and, Manoj, we understand the pressures under which your lordships operate. So, Manoj,
people living 7-star lifestyle, they come for distribution of free food for ration card holder, poor persons, poor laborers, poor bonded laborers, poor this.
I know.
If they can do some social justice with their own richness.
So it was in this spirit, Manoj, that I made at the outset a statement, Manoj. I'm not pressing it.
So everything is distributed.
I don't know. So, Manoj, there was a cost of 1 lakh which had been imposed. Manoj, I have advised him, I've counseled him yesterday. I was only on that cost, yes, which is why I at the outset, I said, I'm not going to take more than 2 minutes of the court's time, Manoj. Only in that limited aspect, Manoj, consider.
1 lakh for, yeah,
1 lakh, Manoj, he said.
Counsel for the petitioner at a considerable length, and on reason of the report, we are not inclined to interfere with the judgment of the High Court. Judgment dated 2nd February 2026 of the High Court. However, upon consideration of certain mitigating circumstances, which Land Senior Counsel has very passionately raised before us, being modified para 7 of the impugned judgment to the extent that the cost amount of ₹1 lakh is reduced to ₹10,000.
This is Manoj, a genuine person. He's done some good work. He's got some good orders. Sometimes, Manoj, they get over passionate about things, Manoj.
Impose on Schwab to donate to some good cause.
Any amount on me, Manoj, whatever your lordship say, Manoj, I put on, Manoj.
Right.
I'm Manoj at your lordship service.
Imposing cost on the petitioner, subject to our the condition that the petitioner will not indulge in frivolous litigation before the High Court of this state.
Very deeply, extremely grateful. Extremely grateful.
May it please the lordship, my lord. Now, this is a case of the Foreigners Tribunal in the Assam, my lord, in this case. So your lordship is that in 2019, there's a judgment passed against me, my lord. So what happened, my lord, I filed a written statement. Thereafter, due to some non-communication with the lawyer counsel is concerned, so we could not pay, I could not file the evidences is concerned, my lord. So in view of that, my lord, due to lack of evidence, I was declared, my lord. So I came before lordship, before the Honorable High Court after, it is on record after 5 years, after 6 years, my lord. So my only submission is a village rustic woman, my lord, in this case. Only prayer before lordship, if I be given the opportunity, because to give all this evidence, because if your lordship kindly see para 18 of the Honorable High Court judgment, my lord, page 8, para 18. Because they say that the
also para 19.
Yes, my lord.
We have seen the intrinsic merit.
My lord.
And they say that even if grandmother in 1970 is seen, linkage between grandmother and
the problem is that, my lord, because I've not been able to put any cross-examination.
We examined the documents and we find that there is some merit in paragraph.
Yes, my lord. Only problem is that, my lord, because I have to.
There is not even a single link document of the petition and of parent.
So in this
case, how long we can interfere? I think we have to be.
In this case, my lord, village rustic man, because this only submission before lordship is that because those document is concerned.
No, sorry, please.
Honorable High Court.
We have to close this chapter. Otherwise, you see, very constitution of tribunal and the entire exercise taken by the High Court.
Otherwise,
that becomes meaningless.
My lord, the problem is that, my lord, if lordship, if that order has to be sustained, my lord, without giving any opportunity regarding, because I have not been able to give those documents.
Counsel for the petition, we see no ground to interfere with the number 2025. As per the amendment of the Guwahati High Court.
Obliged.
8 years after reservation of the judgment.
भाई कभी कुछ करते हैं कुछ 17 में उसने रवि रंजन ने सुना था bench or it's lying on unattended?
We kept mentioning, and in 2025, April 2025, it came before a bench which directed the registry.
April, May. Happened.
After April 25.
There was a direction that you approach the Honorable Chief Justice for assignment.
Milords, we approached the registry and the matter was assigned to a bench, Milords, after 3 months of April 2025.
Correct.
And after that, it is being carried forward. It is not coming before the bench, Milords.
That assignment.
Now it is not listed anywhere.
Yes, Milords.
The bench is there.
Yes, Milords.
Or the judges have.
Milord, the bench which reserved the judgment is not there.
We know, but
Yes, Milord.
assigned in 25 to which bench? Not the Honorable.
Milords, I can. The bench is Justice Bibek Chaudhary, Milords. He is.
Justice Chaudhary.
Yes, Milords.
Dispute. Who are truly under compelling circumstances. She was married to risk number 3. There arose matrimonial dispute. Risk number 3 sought divorce on the ground of cruelty, which was granted by the Family Court Patna by the judgment and decree dated 29 September 2012. 28 September.
Just check it.
Next, the aggrieved petitioner has filed miscellaneous appeal number 759 of 2012 before the Patna High Court. There is a checkered history of the appeal. A division bench of the High Court heard it finally on 6th December 2017 and judgment was returned. However, meanwhile the presiding judge was transferred to some other High Court and hence the judgment could not be delivered. After waiting for more than half a decade, the petitioner seems to have applied for early hearing, sought an early hearing, not applied, sought an early hearing, and an order was passed on 11/4/2025, and a division bench passed an order on 11/4/2025, requesting the acting Chief Justice of the High Court to list the matter as per roster. Next, according to the petitioner, nothing has been done. As the facts would speak for themselves, the matrimonial appeal is pending for last almost 14 years. The agony of the petitioner, including as well as of risk number 3, can be well understood. If the High Courts fail to, if the high courts are not enough sensitized to take up the family matters on out of turn basis or rekindling some hope for the parties either to live together or part ways. Is there any child, etc., out of wedlock?
Sorry, my lords?
Is there any child
Yes, my lords. There is one child.
that is with mother?
That is with my lords. I need to that clarify, but I don't have information.
These are the basic thing a council should always ask for.
Absolutely.
Next problem. So although ordinarily we do not entertain this kind of petition, however, in light of the unprecedented, our light of the exceptional circumstances noticed above, we request the Honorable Chief Justice of Patna High Court to list matrimonial appeal, that is miscellaneous appeal number 759/2012 at number 1 before an appropriate bench for its final hearing. We request the assigned bench to make an endeavor to decide the appeal within 3 days.
Much obliged, my lords.
My lords, I'm only paying, my lords, similar matters are coming up on 18th, my lords. There's only one submission, my lords, that in 2018, after 2018 policies, my lords, we.
GPA कौन है? Property dealer.
Not the property dealer. But we only tag it with them, those cases, my lord, those cases have started, hearing in those matters have started, my lord. Those matters are parted for 18th, my lord. I'm praying.
I will consider petition at a considerable length, no case to interfere with the improvement of the activity.
Please, my lords.
My lords, we've been led by Dr. Menka Guruswamy in this matter. She's on her legs in court 13. My lords, may grant a Passover. On her legs in court 13, my lords. My lords, may grant a Passover.
Yeah, what is the matter? Is there any urgency?
My lords, this is that FT matter in which the High Court had taken a unique position that because lineage has not been established to the paternal side,
There is nothing in this case.
my lords, may kindly grant a Passover.
We will see whether turn will come up to pass or not.
My lords.
सारे फिर turn पर लेने लग ठीक है. 18 item 18.
18. So I appear in item 18. Now, my lords, 18. There has been, my lords, 34 rupees. These are all villages, my lords, in Noida.
You want to place on record some additional documents?
Additional documents have been filed. Additional documents have been filed, my lords.
Have been filed?
They have been filed. On 11th of March, my lords, we filed it. Take it. Even if we stick to the SLP, my lords, I'll just show two things. My lords, my village, the name of my village is Ghijor. My lords, one judgment of this honorable court, my lord, in the matter of Harchand.
Harchand we have.
Correct, your lordships. Now, my lords, from that only I'll just point out. Please see, my lords, 124 is Harchand in the main SLP paper book, my lords. Harchand is a different year's notification, but my lords, I'll just take your lordships to this, my lords.
No, indeed, what is your village?
No, my lords, my village is Ghijor. Your lordships will find it at 126. 126, your lordships will see. Paragraph 6, my lords, right on top of that, your lordships will see.
Why don't you show in the side plan?
Side plan, my lords. My lords, we filed a map, my lords, as your lordships have indicated in that earlier order, my lords, it's not in that form, but the map is there, my lords, in the additional. Where is it? Where is it? Where is this one? Well, it's at page 8 of the additional documents.
Gijor is Gijor.
Gijor on the extreme right side.
Gijor is on the middle right hand side.
Right hand
extreme
side,
right.
there is a box, Manoj, that I have made.
And Harchand land is which?
Manoj, Harchand deals directly with Gijor also. At 124 of the SLP paper book, deals with Gijor village and says that Shalira Bangan and Gijor, same principles will apply. So that finding I wanted to show to your lordship. So, Manoj, at 124 is Gijor, if your lordships, is Harchand's judgment. Your lordship's judgment, Manoj, if your lordships will kindly have that.
Only Harchand is 1990 notification, yours is 82.
But when you
That was the point last time we.
I pointed it out. Now, please see, now the discussion with respect to the village of Gijor is with respect to notifications of 83 to 88. That is what I wanted to point out. Now, please see, it starts from 126. Name of my village, Gijor is given. Facts at right at the top of paragraph 6, if your lordship see. Facts of village Gijor.
The point is.
Please.
One is that you apply the accelerated promotion.
Annual escalation.
10%, 12%.
I'm very
annual.
The
If you
reverse
apply
of
the
that.
reverse side.
I'm only asking for that, Malaz. Now, please see 131 for a second.
Now, what will happen?
So, Malaz.
How much we will be entitled to?
So, Malaz, 34 is what I have right now. 31 is what I have. Malaz, 34. 297 is what has been given for the year 1983, 1989 to the adjacent village, to which your lordships have said same principles are going to apply to my village. My village is Gijor. Chalera Bangan is the other village at 131.
So that's why we are asking you that if 89, 90, 297.
Well, 83 to 19. My notification is of 5th of January 1982. Point number 1.
82.
82.
So which is the nearest one to you?
83 to 88 here itself in this judgment. 83 to 88, your lordships have given 297 for the adjacent.
You have got at what rate?
31. 34. That is the.
Returnable on sources. This you should have argued on the very first day. We didn't require documents for
We get wiser, Manoj. I wanted to point it out from the back.
When we apply principle of 10%, 12% escalation.
Please, Manoj. The same way it can be.
Same reverse escalation.
Very grateful. That is what I'm asking, Manoj, in my request.
And the difference is very huge.
Huge, Manoj. Huge difference. Very deeply applied. There is something else also against me. I'll point it out on the next date, Manoj, when the opposite side is there. In all fairness, I'll put it before your lordships. Very grateful. Dusty on the standing council, if your lordship will permit. Dusty on the standing council.
Liberty to serve through standing council.
Very grateful.
Please, my lords. On the last date, lordships had sought to understand the basis of the Gaubura's authority to issue the certificate. Plus, the Gaubura is a subordinate of the revenue officer under the Assam Land and Revenue Regulations of 1886. There are executive instructions issued under the regulations. I'll hand over a copy, my lords. Under
The way to place on record document.
I'll place it on record, my lord. I'll place the complete copy on record.
Issue notice.
I'm so grateful, my lord.
The mediation is pending minutes before the mediator.
This matter, the mediator met with the parties twice, once together and then individually also. There's a visit slated, my lords, to the temple itself by the mediator on 28th of March. So we were going to request that the matter could. That's correct. He met with us twice, my lords. Both the parties, once online, both of us, and then individually also he met again both the parties on the second occasion. They are taking the assistance of experts also. Experts on both sides have been nominated. And third is, my lords, he has scheduled a visit to the temple on 28th of March, now, my lords, next week.
about 10 days time. So in the light of that, perhaps we'll need some more time, my lords. Just only one request I had.
We are informed that mediation proceedings are going on. Post the matter for further consideration on so on today.
I had one other request, my lords. There's an application we have filed for impleading one particular society, my lords, which is a family called Tatacharyas. They are one of the main representatives on the other side. In fact, the other side had marked them also for the mediation proceedings, but they are not appearing. Their presence will be necessary, whether it be settlement, my lords, or ultimately adjudication, they have to be there. So their impleadment has to be ordered. My IA is there on that, my lords. The other side, I'm sure, will not have an objection on that, my lords.
In fact, I had marked them in the mediation.
They had marked them, they themselves had marked
What is the number of that?
76593.
76593.
593, my lords.
I guess 76593 2026 is allowed. No, but it is on behalf of some.
Yes, my lord, it's a-
Raja Masam.
No, it's a Sabha, my lord, which is an association of the family.
That is filed by us to implead that Sabha and the secretary of that Sabha, my lords.
Oh, I see. And the Patta de Sikar, Thiruvan, Sudan, Subha, so and so.
And the secretary.
As well as Sampata Kumaran are ordered to be implemented as December 2022. Let they be also served through the trustee notice and be requested to join the mediation, ongoing mediation. Then main case posting.
Lordship, my implead petition is also there, Lordship.
We will see later on.
31643.
Mediator and all had.
I was actually a party to the Madras High Court order, Lordship.
It's all right, it's all right. We will see first of all. Mediation is going on right now. Let's not.
That's right.
Mediator, my lord, had in fact suggested to us that it would be had in July because he wanted to make a full-fledged attempt.
It's already appearing before us in a matter, learned fellow. We will see it.
No, my lord. Mediator, my lord, had suggested to us to request and in July.
He suggested a longer date.
No problem, no problem.
Very well. Deeply obliged.
My lord, I beg to appear for the petitioner. My lord, at the last occasion, my lordship had directed me to furnish all the materials and also give an estimate as to what shall be the cost per se. My lord, the first answering my lordship's first question, there is no monopoly, there is no kits. It is just a different way of testing the blood. Wherein my lord,
Go and represent the authority competent.
no, my lord, we have been representing my lord, the problem here is, my lord, it is a state subject. My lord, can I take my lordship to some of the communications between the ministries, my lord? For a moment, can I request my lordship to.
It is not our subject. We can't opine anything. We will only refer to the minister.
My lord, for a moment, my lord, it is a matter of some significance. My lord, because it happens to be a state subject, what is happening is, my lord, different testing protocols are being adopted. Now, my lord, number of questions have been also asked in the parliament with regard to the implementation of NAT testing. My lord, what it essentially does is it shrinks the period wherein.
We are definitely not expert on this subject. We will not entertain.
No, my lordship.
Our choice is either we outrightly dismiss it or we relegate them to go to high courts and seek your relief.
My lord, I'll tell you the difficulty with high court, my lord. It will be then we'll have to go to all the different high courts.
It is very difficult to go to high court because everything is ready-made available in Supreme Court.
No, my lord, I take my lordship to kindly indulge me with a couple of pages in my additional.
We don't want because this is not a subject we can understand. Why should we?
My lord,
why should we pretend that as if you know medical science? When we don't know.
My lord, it is my submission, my lord, it would not be an adversarial litigation. A nudge from my lordship would essentially get it to a large number of people.
You must have been instructed, you must have been apprised by somebody who is behind the scene. All this.
My lord, in fact, my lord, they are essentially the directors of Thalassemia India, who happens to be a nodal agency and advisor to the government. I take my lordship to the representation and the response given by the central government. For a moment, my lord, I take my lordship to the additional document. If my lordship is not convinced, I leave it at it, my lord.
To be registered NGO. Committed to the cause of thalassemia, a genetic blood disorder, owing to which the patient requires regular blood transfusion.
My lord, may I take my lord?
So we are creating some way for you. Let us understand. The petitioner also seeks to highlight the spread of transfusion transmitted infections such as HIV, hepatitis B, C, malaria, so and so, which are often contracted by the thalassemia patients, especially children, while receiving blood transfusion. According to the petitioner, these diseases are often transmitted owing to inadequate screening methods utilized to test blood prior to transfusion. In this regard, the petitioner is said to have sent several representations to various states of the Union of Territories, highlighting specific concerns, including one, non-availability of blood unit transfusion, two, need to implement NAT testing as the sole screening procedure for blood. Having found that no effective action is being taken, the petitioner has approached this court purportedly in public interest, contending that NAT testing is the gold standard for early direction of transfusion transmitted infections, as it can clarify, as it can identify the presence of such diseases in a window period of 7-10 days, as compared to the ELISA. What is this ELISA?
HIV test.
It takes 60 days.
ELISA method, which has a window period of 55 to 60 days. It is pointed out that NAT testing is not mandatory under Drugs and Cosmetic Act 1940, even though it is recommended by the National Blood Transfusion Council and the National AIDS Control Organization. It is claimed that NAT testing is mandatory in some Western countries. It is, however, acknowledged that NAT test blood is more expensive, and patients from economically weaker sections of society who are likely to contract infections from contaminated blood, are not in a position to afford the same. Next paragraph. As the facts would speak for themselves, the issues sought to be raised have nothing to do with the interpretation or enforcement of any legal regime. What the petitioner wants is to introduce certain new technologies for the purpose of preventive to prevent the transmission of infections and diseases during the process of blood transfusion. In the absence of any specialized knowledge or information about the availability of the tests which the petitioner wants or their cost component, we have no reason, we are satisfied that no desired direction can be issued by this court. The nature of the relief sought entails financial implications, and every state, has its limited resources, and every state has its own limitations in the matter of allocation of, and every state has its own financial limitations. So in such circumstances, especially when the petitioner itself has acknowledged that NAT testing blood is more expensive, we are not inclined to issue any direction except that the petitioner submit a comprehensive representations to the secretaries of health department of all the states and union territories, who may, with the aid and advice of the domain experts, take an appropriate decision in that way.
All right. Can I seek one indulgence for it? My lordship had put a question as to what shall be the cost. the state of Karnataka, state of Kerala says the total cost for the state for the entire year is 22 crore. My lord, by official
We
communication.
understand that manufacturer is very keen to.
There is no question of any manufacturers here. My lord, there is no question. Nobody is going to be a beneficiary. It is only a modem of test.
Do you think PILs are not funded from abroad? Do you think so?
My lord, it is not the case in the instant case. My lord, for a moment, my lord, can I take 2 pages? Then I leave it to my lordship, my lord. Because these are intergovernmental communication.
We could read. Unfortunately, our parents did not send us to medical colleges. We were only sent to some law schools from where rightly or wrongly we have obtained degree, and now allowed to us only deal with legal issues. That's all.
My lord, here, only 2 pages, my lord.
The moment we try to project ourselves experts of so many things,
that is not the
we'll create complications for those.
The central government says we are ready to support the same subject to the request being made by the state. My lord, two pages, my lord, then I leave it to my lordship because, my lord, here what happens is,
yes,
my lord, the total, it is cost
Thank you very much. We have given enough time to a PIL.
My lord,
it doesn't, and no PIL deserve more than that. That's all.
My lord, here, as far as cost is concerned, my lord, it is minuscule. My lord, the effect it would have on a large number of people, especially people whom I represent, who suffer from thalassemia, who are, my lord, they go from one infection to another infection.
Thank you very much. Item 22.
Please, close. The counter affidavit has just been filed yesterday, the counter affidavit has been filed yesterday evening. Your Lordship's permits us to file our rejoinder on the matter. Interim orders. No, in the interim to continue.
Item 23.
For interim orders to continue in item 22.
Yes.
Any fixed statements?
My lord, in item 23, we are seeking amendments to the guidelines for issuance of OBC certificate, so that the children of single mother belonging to the OBC category can get the certificate on the basis of the certificate of their mother, not only on the basis of the certificate of their father.
Possible.
How it can be?
The constitution bench says that the caste is from the father.
No, my lords,
Yes,
the same benefit has been given to SC/ST also. The single mother from the SC/ST category has given the benefit that their children can take the certificate on the basis of the certificate of their mother. If my lords can have the, and even the Union of India is supporting our case. In their counter affidavit, they have supported our case. If my lords can have.
First of all, you argue which case?
Santosh Kumari, the main matter. Item 23.
I'm appearing in 23.1, those series of matters from
the
Union Territory of Puducherry. There the question.
Are those matters also listed today?
They're listed today. I think you also put them on sometime in May. I'll put in a note of argument and say why Union Territory of Puducherry is certain concern about the High Court's order. There's something which about migrant women getting married. All those issues are there. There are special.
My lords, with due respect, that issue is totally different from the main matter.
It may have some bearing. I'm not saying no.
So post these matters for final hearing on some sort of.
Maybe 23 can be heard separately, 23
Yes.
point. But I think there could be some overlapping. I don't know. Maybe.
There's no.
You lost his,
My lords can detag those matters. Detags 23 with the other matters because the issue is different.
But where are the other matters?
Let it be detacked. I don't.
This item 23 Santosh Kumari matter may be detailed.
Yeah, please.
Rest of the other matters listed in May and this matter on some other days.
My lords, may item number 23.2 also be detagged from the rest of the matters?
You can file your complaint.
No.
My lords, 23.2 deals with an intercaste marriage, whereas the rest of the batch of petitions deals with children of parents born from the same caste, my lords. So the considerations in the two cases will be different.
No, that's right. That we will examine. Intercaste also one of the issue it will be there.
My lords, in intercaste marriage, there are also concerns of appropriation of the mother's identity, who may be SC, ST, OBC, when the father is an upper caste and the child has been brought up in the father's culture and society and is therefore has access to those privileges. So then in that case, if they're misappropriating the mother's
Let
identity
it come
to
together.
claim that benefit, that's a different consideration, my
These are
lord.
all different categories. Suppose there is a widow mother, there may be divorcee, there may be intercaste marriage, there may be inter-religion marriage. All these issues will be, individual matters will be heard.
My lords, this is a list of cases with the
So great hurry to argue today. Have you filed counter?
only to detag, my lords, not to argue. Since it's a different question of law, we're only requesting for detagging of the matter.
No, there is no separate question of law. These are all overlapping issues. We'll consider together.
If I may show this chart, my lords, of different issues.
Let it be shared with
You
me. I
want
will
to
also.
file reply? Have you filed reply counter affidavit?
We'll file the reply, my lord.
You have filed or you want to
We
file?
will file the reply, my lord. We're seeking time to file the reply, my lord.
File the reply, then don't argue in piecemeal only because somebody is.
Simply to detag the matter, my lords.
Don't keep the mic alone with you. Mic, use the front mic, not the.
Apologies, my
You, this one you can use to argue the cases. But somebody is pushing you from behind, don't go by that. File the counter affidavit in whatever case you want to file. That will give an idea to us that suppose you are filing, you have 20 matters. We don't know it's a batch matter. In one case, it might be a case of, as you are saying, intercaste. In the other case, maybe same caste. The third case may be, unfortunately, a divorcee. The fourth case may be something else.
All the other cases are similar, my lords. It's only the 23.2.
Only you know it because you are the master of the facts. Because you are dealt with the facts. We have not dealt with.
All right.
We will only be able to find out when you file counters.
If my lords can fix a date in item 23, the pleadings are complete, the written submission has been filed in 23.
They are listing your matters separately. You appear to be in great hurry. We will hear separately. इनका पहले लगा दो भाई.
Very well.
Next, Philip.
Lordships, great.
This 24, my lord, is regarding this is regarding the import of those yellow peas, where your lordship had issued notice. One, of course, slight effect of your lordship issuing notice was that the government has now imposed, earlier they had allowed free import without any duty. Now they have imposed a duty of 30%, 10% on import of yellow peas. But my lord, that is hardly of any consequence for the reason, if your lordship just sees the page 509, where we have, this is the report of the Hindu, which gives you what is the MSP of these dals.
Mr. Bhushan, do we have any official kind of information or at least a reliable say, exercise undertaken by some genuine platform that how much is the product our in country and what is the total consumption? So the demand and supply principle.
So actually, my
Para
lord,
6
this,
of our counter
there are
says-
two organizations.
Para 6 and 7 of our counter addresses, my lord, this is a decision taken collectively by the Ministry of Consumer Affairs, Ministry of Agriculture, and Ministry of Commerce. The lordships comes to para 6 of our counter affidavit. There has been a steep decline in the production because of a disease, El Nino phenomena. So, my lord, in 2021-22, it was 273 lakh tons. 22-23, it came down to 261 lakh tons. And in 23-24, it came down to 242 lakh.
Venkataraman, is there any in the Department of Agriculture? Have they examined that why it is declined?
What?
So,
There's no, because of the erratic,
in fact,
erratic monsoon.
Rainfall. No. Lord,
the only
CACP, the committee, the Commission on Agricultural Costs and Prices, has given two reports on this very recently in 2025. The first report, my lord, we had annexed in our petition, which is of
3 developments have happened.
2025, where they say, this is what they say, ensuring remunerative prices to farmers is one of the important pathways to achieve.
Mr. Venkataraman, we don't need even this report. The point is very simple. You have an MSP for wheat, you have MSP for rice, paddy, you have MSP for some of the now
dals also.
millets are also now included.
Pulses also.
The moment you make sure that the farmer will get this much price, you will see that how it right. Unfortunately, this aspect probably has not been really addressed. We don't want to pass any order to that way because it's a matter of policy. But if you have true subjects experts who know the pulse of the farmer without knowing these pulses, if they know the pulse of the farmer, he will do it. The reason is to a very simple reason. One is that per acre productivity of these pulses is far less as compared to wheat or paddy. So if I have 10 acres of land, it's very difficult for a farmer to spare 2-3 acres out of it and to divert it for pulses, because he knows that if he will get only 10 quintal out of it, the wheat will be not less than 90 quintal, 100 quintal out of it. And for 100 quintal wheat, he has a dedicated price. He knows I will go, I have ready-made marketing available, I will get the money will come to my account. About these pulses, he will go like a poor fellow running from one shop to other in the grain market. He may not get it. And unfortunately, rain come, he spoiled.
That's precisely what the commission said.
Limited said like
exactly this, what your lordship is saying. Exactly this.
That is the only difference.
But three steps, I'll just place it and I'll come back, whatever I'll take. 3 steps we'll place it.
Please ask your Ministry of Agriculture to constitute some, and don't take these experts, so those who are having, again, we have nothing prejudice against any foreign degree or this degree or that degree. Somebody who has worked in the ground level, who knows that the psyche, the reason, the compelling circumstances of the farming community. He has to use electricity, he has to use divert water, he has to use all these things, and then he knows at the end of the day how much I will get.
This commission, my lord, is exactly that kind of body which your lordship is referring to. This is a government's commission on agricultural costs and prices. This commission advises the government on what should be the agricultural MSP, etc. Now see, my lord, what they said in their report of this year of 2025. They said at page 153, ensuring remunerative prices to farmers is one of the important pathways to achieve Atmanirbharta and pulses and edible oils. And pro-farmer trade policy mechanism will help ensuring better prices to farmers. However,
one thing more, I'm not sure whether they have added it or not.
Yes.
Because that might be, there is now, not now, in fact, last so many years, there is a lot of campaign from the government side to diversify.
Correct.
The agriculture, right?
Yes.
And diversification, the biggest challenge is now becoming in North India particularly is the paddy crop. You start because you have to now sow it somewhere in May itself. You cut off, you fix a date of cut off 15 June. They notify it, they make it an offense. But farmer knows very well that right now some water is available. He will go, whatever you may say anything, at the risk of even inviting a penal action, he will do it somewhere May. And entire May, June, July you may get, you may not get the adequate monsoon. And you have to keep water always intact there. So the maximum the ground water level has gone so down only because of this reason. And paddy, again, the other related aspect. Do we require for the purpose of consumption as much paddy as we are producing? Barring, we need some good quality for export also, like basmati or export. Let it be, because that's, do you earn FDI, you get an export. But in the normal paddy, probably the production is much more than what is our consumption. So if you divert and the paddy plantation is area is reduced and that area is diverted for pulsing, it will balance that.
That's exactly what the commission said. What your lordship said just now, they say, promote balanced production pattern. This is the title. And then they say, therefore, the commission recommends a comprehensive diversification strategy. An action plan should be prepared with a special focus on technological innovations and remunerative prices to pulse and oilseed farmers. Exactly this. And here they say, on this pulses, they say, aligning import duty structure with MSP will ensure remunerative prices to farmers and encourage them to increase area and production of oilseeds and pulses. The Commission recommends that imports of yellow peas should be banned.
I have a dedicated price available in the, and the moment I will reach grain market, I will get this much. That will definitely.
But what we have done, well, we are now talking of a policy which has happened, and whether there is any malafide in the policy that has happened. Three things we will place it at the moment. 3 years, there was a continuous drop from 272 lakh tons to 242 lakh tons, down by 30 lakh tons. As a result of which, let me put it, second step. Ministry of Agriculture, as a matter of statistics, found because there is a shortage, the domestic prices started to shoot up. So
we understand that.
One minute. So we had to balance the consumer. So first step, what we did was in December 2023, based on the downfall of 30 lakh tons, the first step ministry did was, well, it was originally a free import. Then we made it into a restricted import. So it has to be regulated. That's the first step. Then, my lord, we still found out the gap was wide. We have put it in an affidavit. This is happening based on a constant monitoring, balancing two communities. Lord, Ministry of Agriculture takes care of the farming community, and Ministry of Consumer Protection takes care of the consumers' protection.
No doubting at all.
And therefore, Lord, they recommended in December 20, Lord, in October 20, on 29th October, when the committee recommended, you have to now balance it in terms of price also. So impose 30% duty. On the very same day, notification is issued by DGT. Very same day, 29/10/2025, 30% duty we have imposed it. We'll certainly take forward the policy of your lordship.
So, please don't take it as an adversary litigation. Ministry of Consumer rightly thought of, because when you know that you require 3 lakh tons, suppose in the market consumption, and market available is only 250, you can't allow the poor person to be exploited in the name of price. There, you understand. Therefore, you will get the import. There is no other way.
We moved it into free.
But we are only talking of a long-term plan. Only if there is a coordination between the Ministry of Agriculture and Ministry of Consumer and other stakeholders.
In fact, my lord, the pulse farmers were not even getting in the open market. They were not even getting the MSP. Government had fixed MSP for pulses. The farmers were not even getting. We have filed evidence to that the farmers were getting about 25% or 20% less than the MSP fixed by the government. Even though, my lord, that MSP, that's another petition coming before your lordship soon, where we have shown that the MSP that is being fixed is not even taking care of the actual cost of production of the farmers. Swaminathan Commission said cost plus 50%, forget 50%.
The point is,
even the cost C2 is not being taken care of by MSP. But today the situation is that even the MSP fixed by the government for dals.
So there should be a guaranteed platform to sell it.
Yes, at least at MSP. This is the government's own MSP.
Protection farmer will have to be provided. Then only you can increase the area and
the import is at half the price, even with 30% duty. It is half the price of the MSP. Import of this yellow peas, which is a substitute for these dals and for chana, is at half the price of the MSP.
As he say, I don't know from
even after 30%.
I'm not seeing it anywhere. He is making statements. But he can continuously make statements. We are now on data. Based on shortage of 30 lakh tons, we have done 3 things. We removed restricted, free, and made it into restricted. We started to impose duty, and we are constantly monitoring it. Whatever needs to be done, we undertake it. We have been doing it. We have periodically, my lord, this committee is meeting it quite periodically and trying to balance. Now to say, my lord, this is where it stands. It's my word. I put it on an affidavit. My friend says something else which is not there in the affidavit. How do we address it?
Last couple of years, we are not encouraging wheat crop so much. For the simple reason, because wheat as such is having a lot of health issues.
Yes.
It may not be a suitable as
in fact, the government is promoting these millets.
In lieu of that, rightly so. Because millets are our original, our natural product.
Yes.
And that's why our body is not, in this region, it is not meant for, like in South, rice is the natural food.
Staple food.
And that's why the variety of rice will be altogether different if you consume. So it is now not being encouraged to. There can be, the moment you create an alternative option, which is as lucrative as, if not lucrative, at least which is as much assuring as you do it for
The
wheat.
cost at least of the farmer.
Lucrative, there is nothing for the farmer, but for the assurance, it will have its own impact.
I'll take it.
Ask, you call the concerned heads of these ministries, hold a meeting and see that what is the deliberations and what is the outcome.
Sometime
In fact, my lord, one of our prayers was that their duty should be commensurate with seeing that then the import should be at least at the price of the MSP for the prices that, for the things that this is being substituted for. Yellow peas is a substitute for these three dals and also chana. So at least the price at which it is imported should be commensurate with at least the MSP. Only then will the farmers be able to sell it at something close to the MSP.
We'll file.
Examine this aspect
Deep.
also, Mr. Venkat,
Extremely obliged.
because
it's a learning exercise. Deeply obliged.
They will, and it might then lead to some hoardings also. It can have very adverse impact on the consumer ultimately.
But we'll get back on this.
Yes,
Sometime
yes.
it will be
These
granted.
yellow peas, my lord, there is a problem, health problem also.
Problem also, yes. It may be, we do not know whether it is really good for our, this reason of the.
It's not good. In fact, that's why CACP has been continuously saying ban the import of yellow peas, ban the import of yellow peas. Again and again they have said that.
So the matter has been heard for some time. During the course of hearing, it was highlighted that the different ministries of the Union of India need to have a better coordination from understanding and establish some mechanism under the aegis of the Ministry of Agriculture and Farmers Welfare to promote the crop of, to promote pulses as a substitute of wheat or paddy in the northern part of India, and maybe for as a substitute for any other crop in the southern part of it, in the north and middle part of India, and maybe a substitute for other crops in South India. It was realized that the absence of an incentivized MSP, this should at least be sufficient enough to meet with the expenditure a medium or small level farmers incur in producing pulses, along with a guaranteed timely sale of the product, coupled with the fixation of post price of yellow pea, which is being imported in such a manner that it does not become, that it does not harm, that it does not adversely impact the homegrown pulses by the farmers, etc., have been discussed, highlighted. We have therefore impressed upon the Additional Secretary of India to convene a meeting of the different stakeholders and explore revisiting, and don't say explore, and to so as to revisit the existing policy structure, policy framework, and explore a better substitute under which the farmers are incentivized for diversification of the conventional crops from conventional crops to pulses, along with certain benefits for assuring benefits as illustrated above. We hope and expect that the ministries will be able to resolve this issue, for which will effectively resolve this issue with a new policy regime. Post this matter on 7 to date for the council. The deliberations that may take place among different stakeholders be placed on record. उससे पहले जहाँ पर कमेटी का लिखा ना it goes without saying that interdepartmental deliberations will keep in mind the recommendations made. What is that recommendation?
Commission on Agricultural Costs and Prices.
By the Commission on Agricultural
Costs and Prices.
Cost and Price. Yes. Then she post this matter on today.
We are very grateful, my lord. This is a very salutary order. It should have a great beneficial effect for our farmers.
And we have sufficient lands, to my mind, not that we can meet with the.
Yes.
The homegrown product can take care of.
This commission is the expert body of the government only, and they have been repeatedly saying that this is what you need to do. You need to ban the import, or at least have an import duty structure which will make the cost of import equal to the MSP, at least
Some
equal.
of the agriculture universities are also doing commendable job.
Yes.
Because they have, like Agriculture University, Hisar and Ludhiana, I know, they have, it's not that academic part only. They have enough agriculture land with them where they keep on testing. So based upon the ground results that they ultimately make.
Your lordship is absolutely right about wheat and rice. I agree 100% with your lordship's perception on that. That we have just placed total emphasis on wheat and rice and just neglected all the other millets and other things, etc. This is unfortunate.
Psyche of the farmer, no? Because he feels paddy and wheat I am absolutely safe. Estimate production value is also now known because it has gone so deeply into their mind. They know it 90 quintal, 100 quintal, this month will be the estimate product and the rate also.
Absolutely right, my lord. Absolutely. This is what is happening.
We have to offer them some good alternative.
Yes. I am obliged.
I'll do something about it.
25, I'm requesting for some more time, my lord, because there's some data to be collected.
All right. Thank you very much. We are also eagerly waiting if somebody sees time because
4 weeks.
Please, my lords.
After 8 weeks.
This was a partnered matter, my lord.
8 weeks. Some notification has to be issued by Telangana with regard to that.
Item 26.1, there are similar matter pending.
Two orders. Earlier, my lord, the lordship wanted to verify, is it ecologically fragile land or not is the question. Tribunal says it's not. High Court also dismissed, review also dismissed the concurrent finding. But your lordship had a doubt because OA number 23, which is between one of the land and forest land.
All the matters together.
Both the matters together, my lords, called today.
The other matter is also.
Other matter also has come, my lords. It's a part and it's a short point.
Do we need to file any reply in this matter?
Well, we have filed, every pleading is complete.
Like post these matters for one hearing on so day.
Short date, my lords, 15, 20 years we are waiting to get back.
We will fix.
Very well.
Item 27.
That's obliged.
Your lordship, I filed my wakalatna yesterday on 27.
Statements and material.
Your lordship, 4 weeks time we granted to us.
Not I appear for R2. I seek 4 weeks time to file my counter.
Your lordship, I'm for R1. I filed wakalatna yesterday.
2 weeks time only to file counter. Post the matter on day. Item 32.
Grateful to my lords.
Sorry. Lord, can I just? 26, sorry. Lord, 26, your lordship, already.
Any bar association left where there is no 30% representation?
Sorry.
Please, my lords.
I just
In
want to
fact,
make.
few high courts are remaining.
I wanted to make a mention on 26. The matter is in here.
Item 26.
Sorry. No, I'm not in a hurry. The Lordships are giving a date. We only pray that it may come up after the constitution.
Thank you, sir.
This is the ecologically fragile land which we are mentioning.
In the other case, there is a protection grant.
Ecologically fragile land which I was.
Just keep the same.
No, that he was mentioning.
He's asking for a date.
Otherwise, there is no intervention.
It should be not give a date.
Date we are giving, we will list it.
I was only requesting that the date.
That date of your choice, not you. And Jerem stay check, so before stay was granted.
Item number 28.
Item 32.
Please, my lords.
My lords, Ms. Jaina is online, but she's not, then I can appraise my lords. My lords,
My
few high
lords,
courts are
most
yet
of-
to submit their
Yes.
reports.
Most high courts have submitted some compliance. We are yet to review because we have just been served. Some more high courts are yet to submit. If they can be directed to also submit compliance, my lords.
We will do it
No,
once within
that
a
we
week or
will do, but we just want to know, madam, we hope that the positive reports are coming, Madam Kothari. That
Yes, my lords, not all positive. Frankly, I must say, my lords, all are not positive. In fact, if my lords can direct that all high courts should positively ensure that 30% women and the treasurer is there, because in some high courts, they have said that they don't say 30% women. They just say, for example, out of 15, 20, one woman is elected. That is not strictly following. So we will compare all the reports. But if some positive message from my lords can be reiterated, my lords, we ultimately want that all bar associations all over the country can
how
comply.
many high courts have sent the report? 11 high courts have sent.
Yes, 11.
Actually, the office report is not complete. Besides what is mentioned in the office report, few other high courts have also
My
filed.
lords,
For
office
example,
report says
Jharkhand,
18.
Tripura, they have all filed.
18. Office report says 18. But,
Chhattisgarh has
but some high court reports are very sketchy, my lords. They some are detailed and some are extremely sketchy. So we may have to review.
My lords, may I mention one thing? My lords, with permission, my lord. My lord, there is one Nanded Bar Association in Maharashtra. Nanded is a district place. But despite my lord's order, the term is over, but still they have not conducted the election. So I have prayed for.
Because that will be an issue slightly different. So that we cannot go into.
My lords, at
Lord,
least,
only one thing to bring it to your lordship's notice.
Controversy in these cases.
For the High Court of Bombay, we have filed the response.
Don't say controversy, the issue that pertains, that the issue that arises for consideration in this batch of matters pertains to ensuring 30% representation of the women lawyers as office bearers, stroke executive members of every bar association, including taluka, stroke district, specialized bar associations like tax, RERA, etc., as well as the High Court bar association. It may be noticed that such representation has already been ensured with the active support of the members of the bar in the Supreme Court Bar Association. In some of the high courts also, like Delhi High Court, the members of the bar have been very supportive and graciously that representation has been ensured. Next paragraph. However, I have ensured, and thus many such bar associations have given effect to our order dated 24th March 2025. Next paragraph. However, it was brought to our notice that in some of the states, the benefit of representation to women members was not percolating at different types of bar association like tax bar, tax RERA, stroke, NGT, stroke DRT bar association, as well as at the subdivision level. From this court, wide order dated 16th January 2026, sought a report from the Registrar Generals of all the high courts with an assurance to ensure adequate representation of all the bar associations. The separate direction was issued to the Registrar General of High Court of Karnataka along with other Registrar Generals that they will forward the details that they will forward a status report with respect to representation of women advocates in the governing body stroke executive body of the various bar associations.
That has been filed.
Next paragraph. In reference thereto, 11 registrar generals of, say, 11 High Court registrar generals have submitted their compliance report. They have responded to the issues as to 1I, whether the bar associations, their jurisdiction have adequate representation of women in the executive body. 2I, whether the bar associations have included a requirement of 30% representation for women in the bar association. And 3C, what are the remedial measures that have been taken to taken by such bar associations where the directions issued by this court could not be complied with. Be that as it may, next paragraph. 14 high courts have yet not sent their responsive stroke compliance reports. Next paragraph. We accordingly direct the remaining 14 high courts to firstly ensure that in all the bar associations in their respective jurisdiction, ensure 30% representation to the women members of the bar in the election of governing body stroke executive body of such bar association. So where, however, where the women lawyers enrolled with such bar association are far less than to ensure the representation of 50%.
Yes.
In that case, that whosoever will may be put in the governing body. Next paragraph, where sufficient women members are available and for some reasons they could not contest the election, the district judges will be entitled to are hereby authorized to nominate women members on the executive committee of committee of the respective bar associations within their jurisdiction and send compliance report to the Registrar General of the High Court. So the Registrar General then will collate such reports and place in the and forward to this court. Next paragraph. We make it clear that these directions will have to be complied with, and in the event complied with, especially when our experience shows that most of the bar associations in the country have wholeheartedly accepted the policy decision taken by this court, on judicial side. So, in any case, if there is any reservation at the level of any particular subdivision district, comma, the details thereof shall have to be forwarded to this court for suitable directions that may be required in the particular facts and circumstances of each case. The Registrar General of the 14 High Courts who are yet to submit compliance reports are directed to do the needful in time 2 weeks. Within 2 weeks, post this matter for further consideration on so and so date.
My lords, only one humble submission, my lords. I'm on behalf of the Madras High Court Registrar General, my lords. Our compliance report will be filed shortly. It is ready, my lords. Only one humble request is my appearance may be taken on record, my lords, for today's hearing.
Why not? Why not?
Much obliged.
When we are talking of women members of the bar,
Yes.
do you think you will not mark your presence?
I'm highly obliged.
How can we commit such contempt?
Grateful, my lords. My lords, this will really make a big impact, my lords, grateful.
इन सब बच्चों की बार करो presence में.
Like I did note that for Jharkhand High Court report was submitted yesterday. I was one among the 14 High Court. For Jharkhand High Court, my lord, report was submitted yesterday. So I was one among the 14 High Court. So it is only.
Jharkhand High Court. You have applied.
Yesterday, my lord, I've submitted them.
Jharkhand High Court should be the lead High Court in this country. Madam Ritu Kumar is the president of the Jharkhand High Court Bar Association. From last 9 years, most of the time elected anonymously. That is one example which should be followed by the High Court.
Submitted my report yesterday.
My lord, similar is the case with the Chhattisgarh High Court. We have filed it yesterday, my lords, and
Delhi High Court.
Chhattisgarh High Court, my lords. We have filed our compliance report, my lords.
We hope that you are complying with.
Yes, my lords. We have made the reservations in the post, my lord.
अभी तो हमारा सॉफ्टवेयर चल रहा है. इसलिए जब तक सॉफ्टवेयर है तो दे दो सबको 30%. हार्डवेयर स्टार्ट हो गया तो फिर मुश्किल हो जाएगी. इसलिए डायरेक्शन कंप्लाई कर दो. अच्छा हाई कोर्ट्स का. You see, that's why we keep on telling that look at the male members most of the time, the male-dominated bar association. None of them have seriously opposed it. Some problems we have faced only from the thanks to women members of the bar. They are saying it should not be resolved like this, it should not be resolved like this. But we understand their predicament also.
Yes.
As far as male members are concerned, very graciously, whether Supreme Court bar, Delhi High Court bar, all of them have accepted it. And we will always be thankful to them. Once we close these proceedings, we are going to acknowledge this is a very, it's not a small thing, it's a very revolutionary and very pragmatic and visionary change in the mindset.
Yes.
Very progressive judgment.
Yes.
Very progressive.
Wholeheartedly acknowledged by everyone.
Yes. And my lords, it will lead to a change really for the bar and for the lawyers, my
Order
lord.
to bring in systemic changes. So therefore, we are all extremely grateful to.
We are also expecting that bar councils also, if it goes hassle-free, as of
Will
now,
come.
there's not a serious challenge. So if the women get representation there, Madam Radhika is there. So we will hope that instead of creating problems for the women candidates, we will help them.
Never, your lordship. We will help them. No problems at all. We with your lordship's guidance, we agreed. We convinced everybody. It was an order and consent by the Bar Council of India also, where your lordships took the initiative. Definitely, your lordship.
Good.
Obliged, your lordship.
Grateful, my lord.
After notice,
Item number 28, my lord.
All rest of the matters are all post-notice matters, so we list them on non-miscellaneous.
No, item number 28, can your lordship give me some time? Because yesterday they filed a counter. We like to put a.
Granting time.
2 weeks if your lordship.
All right, 2 weeks.
28. 28. Rejoined at 28.
It's item
28, 20.
Item.
Denied not only the transfer from Gurgaon to Delhi.
You find the counter is not on record, where
The counter has been filed.
My lords, item.
We are informed by the Additional Solicitor of India that counter has been filed. Counter affidavit has been filed yesterday. It seems the same. Have your office got Mr. Vikas?
Lordship, item 31.
Transfer is concerned that
A copy whereof has been supplied to the office of Sri Kasim and Senior Counsel for the Petitioner. Registered to beg the counter affidavit with the paper book. post the matter for hearing on same. Do we need that to file any affidavit?
Not lordship, at least stay the, because if the Gurgaon continues not in the meantime, it will be creating a very, very lot. Everything is. No, this is 10 petitions filed in the Delhi High Court. Where.
You can take next week if you want.
Lordship,
My lords, item
31
30, my lords, item 30.
31, I'm praying for.
30, may I, sir? Kunal, may I? My lords, item 30, if I may be given liberty to file written submissions on a short date.
Item 30 is what?
30, my lords, 30. My lords, it was challenged to an arbitral award. My lords, my lead ground was with respect to the specific relief act to be considered with retrospective, 2018 amendment. I quite see my predicament. It has been settled by this honorable court.
Item 30 is regarding what?
30, my lords,
30?
Yes, my lords,
Item
that's the
regarding
issue.
what?
My lords, it's an arbitration matter.
Post notice arbitration. File a written argument. So that is file the written.
You can submit meanwhile you can.
Written submit, my lords, a written submission.
Submission can be maybe submitted by both.
On a short date, my lords.
Both sides within 1 week. Post the matter on so and so. Like within 10 days, and post the.
I'll be grateful, my lords.
Lordship, item 31, I'm praying for 2 weeks' time to file counter affidavit. It's also an arbitration
Time
matter.
we are granting to everyone.
Lordship, in fact, in 31, if Lordship kindly observes, we would try to explore possibility of settlement through mediation because it's a international arbitration where the notice has come from a foreign lawyer, which according to us, that Bar Council rules prohibit such kind of notice in India. But still, we would like to do that. If case it fails, we'll file the counter. Lordship may kindly refer to.
In so and so item, the council seeks and granted. It is not necessary for the petitioner to approach the court time and again and seek a positive mandamus. Positive mandamus, sir. To doubt that the competent authority will earnestly consider the observations already made by this court in an order of 24th February 2023
and
petition C number 172 and 8th July 2024 in petition number so and so in petition number 172 of 2023 and 327 of 2024
framing the model policy after taking
the model policy for consideration by all stakeholders.
I'm deeply obliged.
They should understand this will have.
I understand this, my lord. I'm not going there.
Our
difficult to wade into policy, sir. Very difficult to wade into what is weighing with the government in not coming up with a policy which is of an affirmative nature. It's for the government to take the call.
Deeply obliged.
Your Lordship, I seek a short pause, sir. Your Lordship, I seek a short pause over in this.
Yes.
Lordship, I seek a short pause over in this matter. A short pause over in this.
What is password? Who is to argue?
The arguing senior counsel is in his selection court
Huh?
4. Court 4.
Who is the counsel?
PV Dinesh, sir, senior advocate.
Call him. Why you are auctioning the residential house if that hotel itself is sufficient?
But that's what had happened is they had put this hotel for auction on 5 different locations. So far, no buyer has come forward. In fact, I wanted to make a suggestion, Madhaj. Now we have taken possession of the hotel last month. We can put the hotel for auction again because we have a possession, hoping that a bidder may come. If we are not able to sell, then we may have to proceed against the residential property, Madhaj.
Right.
That's why. So Lordships may record my undertaking that we'll put it for auction one more time. If we don't succeed,
Now, earlier the hotel was probably in your possession. So obviously, who will come to give the bid? Now that bank has taken possession, and now they will auction most probably they will succeed in selling the hotel. So they are making a fair statement that if they are able to sell the hotel, they will do it. And if they are unable to sell it 5 times, they have already done it.
Yes, Madhaj.
They have not succeeded. So if they succeed and they sell it, good and fair enough.
And also, Madhaj, I must mention just one on the conduct, Madhaj. In the earlier proceedings, they had given an undertaking before your Lordship that they'll make the payment. That's why we handed over the possession of the property.
And then
they could not make the payment. They did not hand over possession. We had to take steps.
Also not good.
We had to take steps to hand over possession. 8 months is lost during that process, Madhaj. But still, we stand by the undertaking that I'm giving to your
This
Lordship.
application has been filed seeking modification of the order dated 14th November 2025. Learned counsel for the respondent bank, whom at the outset submits that 5 times auction was conducted to sell the hotel, but no bidder came, as the possession of the hotel was with the petitioner alone. Petitioner borrower. After the petitioner failed to honor the undertaking given before this court, the physical possession of the hotel has been taken by the bank. There is now a possibility that some bidder may come forward to purchase the hotel. Land counsel further state that the endeavor shall be made to firstly sell the hotel to auction, and it is only if no bidder comes forward that the alternate second mortgage property, namely the residential building, shall be auctioned.
Yes, Madhaj.
In our considered view, the stand taken by the bank is just and fair. They shall abide by the above stated step.
Let them also attempt to bring a buyer, Madhaj. They can also attempt to bring a buyer, Madhaj.
It goes without saying that the petitioner may also bring a buyer for the hotel as soon as fresh auction is conducted by the bank.
Great from us. Great.
Well, it's in item 5. We are requesting your lordships to look into this issue. Now, there's a very, very important constitutional element over here, because we have a 6th schedule, which is a very potent provision, and a provision which has, unfortunately, according to us, not been permitted to work out at all. We have annexed, which your lordship will find towards the end of the petition, a list of 16 statutes. They begin, my lords, at page 1068. And there are 16 statutes. Now, when we use the expression statutes, the 6th schedule itself contemplates 3 types. One takes uses the expression laws, but it also uses the expression regulations and rules. So this is
heard by the other bench.
Sorry?
Is there any other matter, somewhat similar matter that has been heard by some other bench?
So there is. Yes, that is, Manoj. I might just indicate to your lordships that's absolutely true. We have mentioned that. It's not similar it's similar in the sense it's a direct approach under Article 32 of the petition. It deals with elements of election rules, etc. And this court has entertained and issued interlocutory directions. So, Lordship feel that this should go before that bench. I mean, I don't have any problem at all.
This was
Justice, yeah, no, I have a copy of the order. It was a bench headed by Justice Manoj Mishra and Justice Manmohan. I can just give.
It seems from the report that some related matter has been heard by the bench presided over by Justice Manoj Mishra. That this matter be also listed for the same bench next week. Because
Did your Lordship say it's a similar matter?
no, related matter.
Yeah, it's a, yeah, it's.
We have used the word related matter.
Yeah, related to, okay, that's correct. I'm grateful.
Please, Your Lordship. Your Lordship, this public interest litigation raises a grave constitutional issue concerning the failure of.
Yeah, you tell us, you keep your first petition and this petition. What is the substantial change?
Your Lordship, and we have got the first petition also, but Your Lordship, now we have done more research and we have find out what authorities are doing. But Your Lordship, except very few occasions, there are hardly any policy on the part of the government or agencies, authorities to take some steps, so there should not be further litigation and people should.
Word to word, the same petition has been replicated. That is the now innovation in the law of pleadings. Because you push a button and the same petition will come out there wherever you feel 2 lines, some paragraphs to be added.
Yeah.
Barring few paragraphs more have been added. The petition is complete replica of the earlier one.
Your Lordship, may I just submit one thing? Your Lordship had told, directed me to do some more research. So Your Lordship, we have done more research and we have come up.
Research in the sense that particular instances and you will then suggest what should be the remedy to it. You are asking for sweeping arguments. How can such an argument?
No, Your Lordship, we have given, Your Lordship, in the prayer, we have asked for this also, that what should be the now accountability and what mechanism should be adopted. Your Lordship, state can also suggest some mechanism. There should be at least SOPs which they should follow.
Every state, madam, will have a different kind of SOP.
Please, Your Lordship.
Every state will have its own financial constraints. Some states are revenue surplus. Some states are in a very pitiable condition. They are borrowing and borrowing. They borrow money and pay salary to their staff. Huge recruitments have in the past been made. Unmanageable and not even really required. The kind of employments have been done and they need money for paying their salary. So all those states, the moment you ask for formulation of a new policy, welfare policy, they say we don't have money.
Your Lordship, we don't want anything in broader way. Your Lordship, only if there have been some direction from this honorable court that at least all the authorities.
The appropriate course would have been, you can go to respective high courts. The high courts are the best suited platform to understand the financial conditions of the state. Or every day-to-day litigation, they would come to know what is the existing policy that may require some suitable amendment, some incorporation, some revision of whatever they are providing to. If you go like this, maybe that you are in a better to help these poor victims.
Your Lordship, may I just submit one thing? Your Lordship, in this, we have given the data. Across the country, situation is the same.
Across the data is fine. Across the country, there cannot be a uniform direction.
That's true, but Your Lordship, at least there should be some major guidelines from this honorable court that at what stage, what authorities are supposed to do. At least if they do their duty, even then this problem will be solved. Right now, there is electric department, they are not doing the wiring properly. So many electrocution cases are there. Your Lordship, in one of the bus, many passengers died. Your Lordship, these are very small work which they are supposed to do to their own. In fact, there is no need for guidance or for any direction from this honorable court.
There you may be right, no guidance is required. For enforcement of law, it is their duty.
That's Your Lordship. That's why.
Wherever they have not done it, please, it might call for a cognizable offence to be registered through an FIR. For that, some directions can be so.
everyone, welcome to Judiciary by PW. I am श्रीमती श्रीवास्तव और आज मेरे साथ हैं बहुत सारे फैकल्टीज और एस्पिरेंट्स डिस्कस करने के लिए कि क्या हमें इस 3 साल के प्रैक्टिस रूल को हटाना चाहिए या फिर अगर ये 3 साल का प्रैक्टिस रूल हमने लगाया है, मैंडेटरी रूल जो है, इसमें अगर हम लगाते हैं तो एस्पिरेंट्स का क्या होगा। ये जो मुद्दा है ना, ये मुद्दा एक ऐसा मुद्दा है जो बेसिकली सिर्फ एलिजिबिलिटी क्राइटेरिया को ही अफेक्ट नहीं कर रहा है। ये एक लार्जर इशू है कि क्या जब हम बात करते हैं जुडिशरी एग्जामिनेशन में अपेयर होने की या जज बनने के लिए, क्या हमें कोर्ट रूम एक्सपीरियंस रिक्वायर्ड है। सो एक लार्जर इशू पे आज हमारा ऑनरेबल सुप्रीम कोर्ट फैसला लेने वाला है, जो कहीं ना कहीं लीगल फिटनिटी की पूरी नजर सुप्रीम कोर्ट पे इस चीज पे है कि क्या ये 3 साल का प्रैक्टिस रूल हटेगा या फिर हमें कोई कूलिंग पीरियड दिया जाएगा जिससे हम जो है एक रिलैक्सेशन रख सकते हैं और एस्पिरेंट्स अपने सपनों को बरकरार रख सकते हैं और उनको अपने सपने को नहीं छोड़ना पड़ेगा। So for that, we are here for a panel discussion, right? हमारे पास आज इस सेशन में पैनल में है करण सागवान सर, पैनल में है हमारे साथ पुनीत सर जो एडवोकेट हैं, देन वी हैव एमजे सर जिनका बहुत सालों का एक्सपीरियंस है, और आज एज एन एस्पिरेंट हमारे पास है मानसी शर्मा। तो मैं सबका स्वागत करती हूँ इस पैनल में। एक एक करके हम सबसे सवाल पूछेंगे और जानेंगे। मीनवाइल यू नेवर नो कि कब फैसला आएगा, यानी कि जो फैसला पूरी लीगल फेटर्निटी या फिर आप कह सकते हो जुडिशरी एस्पिरेंट्स की जिंदगी बदल देगी, उस फैसले पे आज हम चर्चा करने वाले हैं कि ये 3 साल का प्रैक्टिस रूल पे जो मसला है, ये जो 3 साल का प्रैक्टिस रूल है, ये किस तरीके से अफेक्ट कर रहा है। सो सबसे पहले आई वेलकम यू ऑल द पैनलिस्ट मेंबर्स एंड स्टार्टिंग विद करण सागवान सर। सर, ये जो 3 साल का प्रैक्टिस रूल है, थोड़ा सा हमारे व्यूअर्स को बताइए कि कब से ये लागू हुआ, इसका हिस्टोरिकल एक्सपेक्ट क्या है, यानी कि पहले क्या, जब हम पुराने टाइम की बात करें या कुछ साल पहले, क्या हमारे पास ये 3 साल का प्रैक्टिस रूल मैंडेटरी था, और अगर था तो उस टाइम पे किस तरीके से एस्पिरेंट्स इसको टैकल कर रहे थे। तो हिस्टोरिकली एक बार व्यूअर्स को बताइए, ब्रीफली बताइए कि मुद्दा क्या है, मसला क्या है।
थैंक यू सो मच मैम, थैंक यू सो मच। देखिए, अगर इसके बारे में बात करें हम, जो 3 ईयर का मैंडेटरी रूल है, लास्ट ईयर जो है इम्पोज किया गया, उससे पहले ऐसा कोई भी रूल नहीं था। और कहीं ना कहीं जब से ये रूल इम्पोज किया गया है, काफ़ी सारी प्रॉब्लम्स जो है जुडिशरी एस्पिरेंट्स को आ रही हैं, चाहे प्रिपरेशन को लेके हो, चाहे आपकी प्रैक्टिस को लेके हो। और जो लास्ट हियरिंग हमारी हुई थी, उसमें सीजेआई साहब ने इस चीज़ को थोड़ा सा कंसर्नली मेंशन भी किया है, कुछ पॉइंट्स भी रेज किए थे। और जनरली हम देखें, आई थिंक 2002 से पहले जो है आपका ये रूल था, उसके बाद फिर इसको चेंज किया गया। लॉ कमीशन की प्रॉपर रिपोर्ट आई थी, जहां लॉ कमीशन ने ये रिकमेंड किया गया 3 ईयर प्रैक्टिस की रिक्वायरमेंट नहीं है फॉर एंट्री लेवल जुडिशियल सर्विस एग्जामिनेशन। तो ये इसका कुछ इतिहास रहा है। और लास्ट हियरिंग में हमने ये देखा कि जो हमारे ऑनरेबल चीफ जस्टिस ऑफ इंडिया हैं, जस्टिस सूर्यकांत जी, वो भी इसको लेके इतने पॉजिटिव नज़र नहीं आ रहे थे। उन्होंने भी काफ़ी सारे पॉइंट रेज किए कि स्पेसिफिकली जो वुमेन एस्पिरेंट्स हैं उनके रिगार्डिंग, और जो फर्स्ट जनरेशन लॉयर बन रहे हैं या जो पहली बारी लॉ में एडमिशन ले रहे हैं, उनके रिगार्डिंग काफ़ी सारा कंसर्न जो है रेज किया गया। एंड होपफुली आज उसके ऊपर जो है कुछ हियरिंग होने वाली है। पॉजिटिव है हम सब कि कहीं ना कहीं जो है जितने भी जुडिशरी एस्पिरेंट्स हैं, इनके फेवर में डिसीजन आने की संभावना है मैम।
That's very good, sir. Now मेरे को एक एमजे सर से सवाल पूछना है। सर, आप इस करियर में बहुत लंबे समय से हैं, तो सर अगर मैं आपसे बात करूं कि एक्सपीरियंस वर्सेस मेरिट, किसकी जीत होनी चाहिए सर?
थोड़ा सा इस पर मैं 2 मिनट बोलना चाहूंगा, क्योंकि पहले क्या था, 2002 के पहले बहुत सारे ऐसे स्टेट थे जहां पर में 3 इयर्स जो प्रैक्टिस था वो मैंडेटरी था। पहला जो हमारा जुडिशियल पे कमीशन बना भारत में 1999-2000 में, ऑनरेबल जस्टिस शेट्टी साहब उसके चेयरपर्सन थे, और फर्स्ट जुडिशियल पे कमीशन ने अपनी रिपोर्ट में ये साफ साफ कहा कि 3 साल की प्रैक्टिस जूनियर डिवीजन के जो एग्जाम है उसके लिए मैंडेटरी करना कहीं से कहीं तक ठीक नहीं है। 2002 में सुप्रीम कोर्ट ने अपने जजमेंट में ये बात कही थी पहली बार कि 3 साल की प्रैक्टिस मैंडेटरी करना ठीक नहीं है। इसके परे अभी वर्तमान में, जैसे हमारे करण सर ने बताया, कि सुप्रीम कोर्ट ने भी ये कह दिया है कि 3 साल की प्रैक्टिस होनी चाहिए, जिस पर अभी हम बात कर रहे हैं। मेरी समझ ये कहती है कि प्रैक्टिस होनी चाहिए, लेकिन 5 साल आपने किसी को एलएलबी करवाया, 5 साल के बाद 1 साल आप एआईबी का एग्जाम लोगे, 3 साल आप प्रैक्टिस करने के लिए कहोगे, और स्टूडेंट को ये कहोगे कि जब आपकी उम्र हो जाएगी तब आकर आप जज बनना, तो वो 8 साल 9 साल जीवन में क्या करेगा? बहुत लंबा समय है, और इस समय तक आज की डेट में उसके पास ना तो अर्निंग के सोर्सेस ना कुछ और हैं। मेरे पास एक बीच का रास्ता ही है जो मैं लगातार कहता रहता हूं कि 5 साल की आपके एलएलबी का कोर्स है। आप 5 साल के एलएलबी में बढ़िया काम कीजिए, 2 साल क्लासरूम स्टडी दीजिए और 3 साल प्रैक्टिस करवाइए। कितना आसान तरीका है। ये जिम्मेदारी कॉलेजेस पर डालिए। किस बात की फीस कॉलेजेस ले रहे हैं? फीस क्या सिर्फ कमाई का जरिया है? 5 साल बाद बच्चा तैयार होगा। और मेरे तो एक सजेशन और भी है इन सब के परे, कि 5th ईयर का जो एग्जाम बच्चे का हो रहा है, फाइनल सेमेस्टर का एग्जामिनेशन, उसमें उसमें अगर 10 पेपर्स हैं तो 11 पेपर एआईबी का ऐड कर दीजिए। बच्चा जब एलएलबी की डिग्री लेकर निकले तो उसके पास एआईबी का सर्टिफिकेट और प्रैक्टिस दोनों हो, जिसके बाद वो ये काम कर सके। मतलब ये कि सुप्रीम कोर्ट अगर इसको मैंडेटरी करना भी चाहता है तो 3 साल या 5 साल फ्यूचरिस्टिक अप्रोच अपनाए। आज से इसको लागू कर देना, ये बहुत सारे लोगों के लिए, अभी हम बार बार बात कर रहे हैं कि महिलाओं के लिए सही नहीं है, महिलाओं के लिए सही नहीं है। अरे गरीब लड़कों का भी सोचो जो बेचारे गांव में हैं, और वो बेचारे एलएलबी कहीं से 5 साल कर लिया उन्होंने, लड़ झगड़ करके, मजदूरी करके। अब वो शहर में रहकर प्रैक्टिस कैसे करेंगे? सर्वाइवल कैसे होगा? क्योंकि गांव में तो कोर्ट नहीं है, कोर्ट के लिए तो शहर में आना पड़ेगा। और जूनियरशिप करने के लिए ना तो कोई आज की डेट में सैलरी मिल रही है और ना ही किसी तरह के स्टाइपेंड की स्कीम है। अगर है भी तो दैट इज नॉट सफिशिएंट कि कोई सर्वाइव कर जाए। तो दिस इज माय व्यू पॉइंट ऑन दिस, श्रीमी मैम।
दैट इज सो ट्रू सर। ये आपने व्यक्तिगत बात बताई है कि स्टूडेंट्स सच में सफर कर रहे हैं। बट मेरा सवाल आपसे ये था कि एक्सपीरियंस और मेरिट को हम कंपेयर कर रहे हैं यहाँ पे। देखो
हाँ।
जब पिछली बार सर जी जब जजमेंट आया, जब ऑनरेबल
Correct.
सीजीआई साहब ने ये बात कही
हम्म।
कि भाई एक्सपीरियंस होना चाहिए, क्योंकि
ठीक है।
बहुत सारे रिस्पॉन्सेज आ रहे हैं, बहुत सारा पता चल रहा है कि जो डिमेनर है जो
ठीक है।
सिलेक्टेड कैंडिडेट्स का, वो कुछ ठीक नहीं है, या बिहेवियर टुवर्ड्स द एडवोकेट, लीगल फर्टिलिटी, या जो भी आप कह सकते हो, कि ये समझ में आता है कि जो नए जज सेलेक्ट होके जा रहे हैं वो तौर तरीके से काम नहीं कर रहे हैं।
ठीक है। एक सजेशन मेरे पास, एक सजेशन और है इसमें कि आप क्या कर सकते हैं, आप फॉर्म भरने के लिए सबको एलिजिबल कर दीजिए। जैसे अभी एमपी एडीपीओ की वैकेंसी आई है, फॉर्म कौन भर सकता है? एलएलबी ग्रेजुएट। लेकिन जिनके पास 2 साल का एक्सपीरियंस है उनको वरीयता दी जाने वाली है। मतलब 2 लोगों के समान नंबर हैं तो एक्सपीरियंस वाले को ज्यादा आप वरीयता देंगे तो सिलेक्शन लेंगे। ये क्राइटेरिया यहां भी आ सकता है कि आप एग्जाम सबको देने दीजिए। अगर 2 लोगों के समान नंबर हैं, करण सर और चतुर्वेदी साहब के अगर समान नंबर हैं, इसमें चतुर्वेदी साहब 3 साल का प्रैक्टिस करके आए हैं तो उनको ले लीजिए, किसने मना किया है? एग्जाम देने से ही बाहर कर देना ये तो आर्बिट्ररी है, इनजस्टिस है स्टूडेंट्स के लिए, सबके लिए। इवन समझिए आज की डेट में 33% पोस्ट वैकेंट हैं लोअर जुडिशरी में। अगर ये पोस्ट नहीं भरे जा रहे हैं, 3 साल का वैक्यूम है, तो ये आम जनता के लिए भी तो इनजस्टिस है जिनको समय पर न्याय नहीं मिल रहा। मतलब ये सिर्फ स्टूडेंट के लिए नहीं, पूरे भारत के लिए सही नहीं है, मेरा ऐसा समझना है मैम।
तो सर मुझे आपके व्यू पॉइंट से एक बात समझ में आई कि आप एक्सपीरियंस और मेरिट को बैलेंस करना चाहते हैं।
करेक्ट है मैम, यस।
तो
दोनों में बैलेंस होना चाहिए।
क्या आज हम किस जो है पॉजिटिव व्यू से हैं कि जज साहब भी जो आज सीजीआई फैसला सुनाने वाले हैं 3 साल के प्रैक्टिस रूल पे, उसमें कोई बैलेंसिंग रिजल्ट आने वाला है, या एब्सोल्युटली फेवर में आएगा कि भाई सब के सब अलाउ हो और सब के सब एग्जाम दे सकते हैं, अलॉन्ग विद दैट कि अब कोई प्रैक्टिस मैंडेटरी रूल नहीं है? या फिर ऐसा होना चाहिए कि 1 साल का प्रैक्टिस रूल रख देते हैं ताकि स्टूडेंट्स को एक बार कोर्टरूम एक्सपीरियंस भी हो जाए और 1 साल के बाद उन्हें एलिजिबल कर देते हैं? इसमें क्या ओपिनियन है? एमजे सर आपसे मैंने अच्छा व्यू पॉइंट लिया है। नाउ आई वुड लाइक टू आस्क पुनीत जैन सर, आप एक वकील हैं,
एक बात मैं रख दूं, पुनीत सर के बोलने के पहले एक बात मैं रख दूं। हम बहुत अच्छा डिस्कशन कर रहे हैं। अगर आर्ग्यूमेंट में सीजीआई के सामने हमारा पैनल डिस्कशन रख दिया जाए तो स्टूडेंट के फेवर में जजमेंट आ जाएगा। पुनीत सर, अप टू यू।
बिल्कुल बिल्कुल सर, बिल्कुल बिल्कुल।
मैं थोड़ा सा इंटरप्ट करना चाहूंगा। जैसे एमजे सर ने कहा कि जूनियरशिप जो है उसमें कोई स्टाइपेंड नहीं मिलता। मैं आई थिंक हम सबको पता है कि जूनियरशिप कम होती है, क्लर्कशिप ज्यादा हो रही है आजकल जो कोर्ट में है। तो बाकी पुनीत सर जो है हमारे साथ वो और इसको
बहुत सही बात कही है आपने कि आजकल जूनियर्स को कोई भी वकील नहीं पूछता, और अगर पूछ भी रहा है तो फाइल ले लेके बस आगे पीछे घूम रहे हैं, सीखने को कुछ नहीं मिल रहा है। एंड इट विल टेक मोर टाइम टू लर्न द कोर्टरूम एक्सपीरियंस, और यू कैन से प्रैक्टिसिंग और लिटिगेशन सीखने में टाइम लगेगा। यू एज एन एडवोकेट पुनीत जैन सर, आपका क्या कहना है इसमें कि आप तो वकील है, वकालत कर रहे हैं, क्या जो नए जजेस आ रहे हैं आपको भी ऐसा लगता है कि उनमें कहीं ना कहीं एक्सपीरियंस का लैक है?
मैम एज वी ऑलरेडी डिस्कस, जो अभी एमजे सर ने भी बोला था और ये आपका भी पॉइंट ऑफ व्यू था कि देयर मस्ट बी अ बैलेंस। अगर जो सुप्रीम कोर्ट की जजमेंट अगर आज हमें देखने को मिलती है, यू विल फाइंड दैट द सुप्रीम कोर्ट विल मेक अ बैलेंस की प्रैक्टिस का भी बैलेंस होगा और बच्चों को एस्पिरेंट्स को अलाउ भी किया जाएगा। जैसे मैम आपने करेक्टली पॉइंट आउट किया, अकॉर्डिंग टू यू एंड अकॉर्डिंग टू मी ऑल्सो, Supreme Court can pass an order that the minimum practice year को कम करके उसे 1 साल कर दिया जाए और ताकि बच्चों को चांस मिले. And then this is also the fact we have also seen in the court कि कुछ जो new judges हैं, not all of them, they somewhere lack the basic etiquettes and the basic court work. Because sometimes we have seen that बच्चा 22 years का है, he freshly pass out from the law school, उसने कभी भी लॉ स्कूल से अपनी इंटर्नशिप पे नहीं गया है या उसके लॉ कॉलेज में उसे इंटर्नशिप करने के लिए एनकरेज नहीं किया है. And he was preparing for the exam and he came for the exam and he go through the exam. तो क्या होता है मैम, जैसे वो कोर्ट में आते हैं तो somewhere somehow we feel that उनको जो प्रैक्टिकल एस्पेक्ट है मैम, द थिंग इज दैट जुडिशरी में लॉ हमेशा बुक पे नहीं चलता. यू कैन नॉट प्रैक्टिस लॉ ओनली फ्रॉम द बुक. बुक के अलावा भी आपको चीजों को देखना पड़ता है, क्योंकि आपको ह्यूमैनिटेरियन व्यू भी लेना पड़ता है. कई बार आपको लॉ को ऐसे ट्रीट करना पड़ता है कि ह्यूमैनिटेरियन व्यू भी. सपोज करो कोई मैम मैटर है, मैट्रिमोनियल डिस्प्यूट है. मैट्रिमोनियल डिस्प्यूट में बीइंग अ जज यू कैन नॉट बी हार्श विद द लॉ और मैटर रिगार्डिंग द गार्जियनशिप. तो आपको लॉ को ह्यूमैनिटेरियन ग्राउंड और सोसाइटल पर्सपेक्टिव से भी देखना पड़ता है. तो अकॉर्डिंग टू मी देयर मस्ट बी सम minimum experience also, but I would also say 3 year term is very harsh for them because कोई भी मैम लॉ स्टूडेंट 23 साल की उम्र में 24 साल की उम्र में लॉ पास कर आ रहा है. उसके बाद मैम उसको एज एमडी सर करेक्टली पॉइंट आउट कि 1 साल वो एआईबी के लिए प्रिपेयर कर रहा है, उसके बाद वो 3 साल के लिए प्रैक्टिस कर रहा है. दैट मीन्स ही कैन नॉट प्रिपेयर वेल एट दैट पॉइंट ऑफ टाइम. तो मैम बीइंग अ बॉय और अ गर्ल जो 27 या 28 साल की उम्र तक चला गया है, तो उसके लिए चांसेस और लाइफ में स्कोप बहुत कम रह जाता है. एंड मैम वन मोर थिंग, अगर हम देखें अपार्ट अनलाइक यूपीएससी, हमारे जुडिशरी में जो एग्जाम होते हैं वो बड़ी अनसर्टेनिटी होती है. देयर आर स्टेट जिसमें लास्ट एग्जाम 2023 में कंडक्ट हुआ था. Suppose you are targeting for Delhi. Last exam was conducted in 2023, and the maximum age for general category student is 32. If a student who is eligible in the age of 28 और उसको 32 में सिर्फ एक ही चांस मिल रहा है एग्जाम में प्रिपेयर होने के लिए,
करेक्ट.
तो अकॉर्डिंग टू मी मिनिमम थ्रेशोल्ड कुछ होना चाहिए, बट 3 years इज अ वेरी हार्श.
जी सर. तो सर का कहना भी बिल्कुल सही है कि भाई जो एस्पिरेंट्स हैं वो सफर कर रहे हैं. मैं चतुर्वेदी सर से एक बात पूछना चाहती हूँ कि सर करेंटली क्या सिचुएशन है, अभी क्या हो रहा है? ये जो 3 साल का प्रैक्टिस रूल आया है उसके इम्प्लीमेंटेशन में कोई चैलेंजेस आ रहे हैं? आपका क्या व्यू पॉइंट है इस पे, या किस तरीके से जो है ये अभी तक अप्लाई होता आया, कहीं अप्लाई हुआ है क्या, और हुआ है तो क्या चैलेंजेस फेस किए हैं एस्पिरेंट्स ने?
ये जो 3 year रूल है इसमें चैलेंजेस तो फेस किए जा रहे हैं बच्चों द्वारा. सर्टिफिकेट कैसे बनवाएं, किस अथॉरिटी से काउंटर साइन कराएं, एडवोकेट से ले सर्टिफिकेट या फिर बार एसोसिएशन से सर्टिफिकेट लें, ये सारे चैलेंजेस आ रहे हैं. अभी रिसेंटली जो है बिहार जुडिशरी का नोटिफिकेशन आया है, उसमें भी दिक्कतें आ रही हैं. वो तो एमजे सर का बहुत इंफॉर्मेटिव वीडियो था, उससे बच्चों को काफी सहायता मिली होगी. तो ये सारे चैलेंजेस तो हैं ही. अगर ये बात की जाए कि जो है एक्सपीरियंस जरूरी है, तो जैसा एमजे सर ने कहा कि आप वरीयता दे दीजिए एक्सपीरियंस वालों को, जैसे अभी एमपीएडीपीओ एग्जाम में किया है. या फिर आप ये भी कर सकते हैं कि कुछ जो एनएलयूज हैं जिन्होंने सजेस्ट किया, जैसे सीएनएलयू पटना ने सजेस्ट किया कि अगर ऑनरेबल कोर्ट को लगता है एक्सपीरियंस जरूरी है तो वो जो है एक्सटेंसिव ट्रेनिंग प्रोग्राम के अंदर वो जो है अटैच करते हैं सीनियर एडवोकेट्स के चैम्बर के साथ ट्रेनिंग जुडिशियल ऑफिसर्स को, उसके बाद पावर दिए जाए, डिपार्टमेंटल एग्जाम होने के बाद उनको पावर दिए जाए. तो ये बहुत अच्छा मूव रहेगा. तो देखते हैं ऑनरेबल कोर्ट क्या डिसाइड करती है. वी आर होपिंग फॉर द बेस्ट.
तो सर मुझे ऐसा लगता है कि जब भी हम बात करते हैं एक्सपीरियंस वर्सेस मेरिट की, तो मेरिट में अगर हम थोड़ा सा ट्रेनिंग का तड़का लगा देंगे तो आई बिलीव प्रॉब्लम सॉल्व हो जाएगी.
जी बिल्कुल बिल्कुल. जी बिल्कुल बिल्कुल, मैं इससे
अगर
सहमत
हम
हूँ।
थोड़ा सा जो है बच्चों को अलाउ करें कि आप पेपर दे लो, आप अपने करियर को मत सफर करो, आप अपने सपने को मत छोड़ो, सपना बरकरार रखो, जज बन जाओ, लेकिन जज बनने से पहले एक बहुत बड़ा पड़ाव है, उस पड़ाव को पार करो, ट्रेनिंग। उसमें अगर उसमें कोई टेस्ट रख सकते हैं हम, ट्रेनिंग में
बिल्कुल
टेस्ट
बिल्कुल
कि
हर
भाई
एग्जाम
फेल होते हैं अगर ट्रेनिंग में सर, तो निकाल के बाहर कर दिया जाएगा, आगे कंटिन्यू नहीं करेंगे, कम से कम मौका तो दिया जाएगा।
जी बिल्कुल
क्या कहते हैं सर आप इस पे?
बिल्कुल, मैं पूर्णतः सहमत हूं मैम आपसे। उसमें तो डिपार्टमेंटल एग्जाम होता है, उसके बाद पावर्स दिए जाते हैं जुडिशियल ऑफिसर्स को, ट्रेनी जुडिशियल ऑफिसर्स को। तो आप उसको और ज्यादा एक्सटेंसिव बना दीजिए, रिगरस बना दीजिए, वो जो चैम्बर प्रैक्टिस है उसके मार्क्स ऐड कर दीजिए, वेटेज दे दीजिए। तो ये सारे आप मतलब ये सारे मेजर्स लिए जा सकते हैं। तो बिल्कुल आप सही कह रही हैं।
मुझे एमजे सर की एक बात से बहुत ज्यादा सहमति हो रही है कि यदि हम लोग होते आज कोर्ट में तो शायद मामला और जो है मौसम और माहौल कुछ दूसरा ही होता है एमजे सर।
करेक्ट है।
करण सर, इजंट इट?
बिल्कुल मैम, बिल्कुल वन साइडेड
चलिए
मैम,
अब एक
ज्यादा
बार जरा
मतलब
एस्पिरेंट से पूछें। हाँ हाँ सर, करण सर प्लीज बताएं। हाँ
डेफिनेटली मैम वन साइडेड डिसीजन आता, बट एक प्रॉपर लॉजिकल और रीजनिंग बेस्ड जो है डिसीजन रहने वाला था, क्योंकि हम सब काफी टाइम से इस फील्ड में हैं, हम भी कभी एस्पिरेंट्स हैं, सारी चीजें हमने भी देखी हैं, ट्रायल भी देखा है, कोर्ट प्रैक्टिस भी की है, आपके कॉर्पोरेट में भी वर्किंग की है। तो एज ए एस्पिरेंट के व्यू पॉइंट ऑफ से आप देखेंगे तो ये कहीं पे भी जो रूल है फिट नहीं बैठ रहा है। जैसे एमजे सर ने कहा कि कूलिंग ऑफ पीरियड दे दीजिए आप, एकदम से बम ना फोड़े, जैसे यूएस कर रहा है मैम, उसका मन कर रहा है वो किए जा रहा है, वैसा करना थोड़ा सा उचित नहीं रहेगा बच्चों के लिए भी और हमारे समाज के लिए भी। पेंडेंसी वैसे ही बहुत ज्यादा है, फिर आप 3 ईयर का वैक्यूम क्रिएट कर देंगे तो प्रॉब्लम होगा मैम डेफिनेटली।
लोअर जुडिशरी में 33% पोस्ट वैकेंट हैं और अराउंड 5 करोड़ केसेस पेंडिंग हैं। हमको तो
पेंडिंग है
अभी
जी।
कोर्ट बढ़ाने हैं, जजेस की संख्या बढ़ानी है, और 3 इयर्स का वैक्यूम अगर क्रिएट कर देंगे तो मुझे नहीं लगता कि इट विल बी डिजास्ट्रस। इट विल बी डिजास्टर फॉर द सोसाइटी एज वेल, नॉट ओनली फॉर द
वेरी
एस्पिरेंट्स।
ट्रू सर, वेरी ट्रू। चलिए जैसे हमने करण सर ने अभी जिक्र किया कि एस्पिरेंट का व्यू, सो हमारे पास एस्पिरेंट के तौर पे मानसी शर्मा कनेक्टेड है। मानसी शर्मा, आपका क्या मानना है जो ये रूल आया है उससे आप कितनी ज्यादा दुखी हैं या कितनी ज्यादा खुश हैं, इसके बारे में जरा व्यूअर को बताइए, और जो कहना है आप कह सकती है विद रिस्पेक्ट टू 3 ईयर प्रैक्टिस रूल।
थैंक यू मैम। मैं यहाँ पर सारे एस्पिरेंट्स का ही पॉइंट ऑफ व्यू रखूंगी। मैम मुझे लगता है कि सभी एस्पिरेंट्स को एक ही स्केल पर मेजर कर देना ठीक नहीं है, क्योंकि कुछ एस्पिरेंट्स ऐसे होते हैं जो बहुत सीनियर जजेस के मुकाबले भी काफी कंपैटिबल होते हैं। और 3 ईयर रूल की जो ये जजमेंट आई, इसने उस दिन एस्पिरेंट्स को बहुत दुखी किया। मुझे लगा कि कहीं ना कहीं ये एडवोकेट मतलब बार एंड बेंच का एक क्लैश हुआ है। कई बार ऐसा होता है, कोर्ट में प्रैक्टिस करते हैं तो कुछ कुछ जजेस जैसे डिसरिस्पेक्ट कर देते हैं किसी एडवोकेट को, तो वो बॉयकॉट कर देते हैं उन कोर्ट्स को। इस सब को देखते हुए ऐसा कुछ सुप्रीम कोर्ट को लगा, लेकिन मुझे लगता है सबको सेम स्केल पर नाप देना ठीक नहीं था। और इस एक ईगो क्लैश के चक्कर में सभी एस्पिरेंट्स का बुरा हाल हो गया। पूरा जो बच्चे बचपन से जज बनने का सोच रहे थे, अब एक एक तो पहले तो एलएलबी की डिग्री इतनी लंबी चली जाती है, बीए एलएलबी तो और भी लंबी चली जाती है मैम। और इस बात से आप लोग भी सहमत होंगे कि कोर्ट में जाते ही तो किसी को भी पैसा नहीं मिलता है, और 1 साल के अंदर एक्सपेरिमेंट करना, किसी सीनियर के साथ सीखना, अच्छा सीनियर किस्मत से मिलना, सभी तो नहीं सिखाते हैं काम। एस्पिरेंट्स के लिए बहुत मुश्किल हो जाता है सरवाइव करना। अब कोई ऐसा एस्पिरेंट जो बस देख रहा है कि मुझे शुरू से बचपन से सोच रहा है कि मुझे जज बनना है, अब उसकी डिग्री पूरी हुई, अब उसको और 3 साल वेट करना है, लेकिन उसके सर्कमस्टांसेस ऐसे नहीं है कि वो 3 साल वेट कर पाए, उसका तो सपना बिल्कुल चकनाचूर हो गया इस जजमेंट
वेरी
की वजह से।
अनफेयर, वी ऑल आर सेइंग अनफेयर, यस।
बिल्कुल। और मैम दूसरा देखा जाए तो अभी हाल ही में जेंडर बायस एक रेशो निकला था, सुप्रीम कोर्ट में सिर्फ एक महिला जज है, डिस्ट्रिक्ट कोर्ट में और कम महिला जजेस हैं, हाई कोर्ट में तो थोड़ा मतलब मिडिल साइज में ही नंबर है। लेकिन एंट्री लेवल पर एग्जाम रोक देना, सबके एक तरह से अपॉर्चुनिटीज लेना, ये राइट टू चूज ऑक्यूपेशन को भी मुझे लगता है अफेक्ट कर रहा है सभी
करेक्ट।
एस्पिरेंट की। और मुझे ऐसा लगता है कि सुप्रीम कोर्ट को इसमें कुछ पॉइंट दिखा, तभी इसके ऊपर रिव्यू पिटीशन भी वो सुनने को मान गए, और बहुत बैलेंस्ड वो दे देंगे इसके ऊपर जजमेंट। पूरी तरह नहीं हटाएंगे, कुछ मॉडिफिकेशंस कर देंगे। हो सकता है वो जैसे कि एमजी सर ने सजेस्ट किया कॉलेज लेवल में ट्रेनिंग डाल दें, या फिर ऐसा कुछ लगे जिससे एक्सपीरियंस अच्छा बन जाए एक जज का सिलेक्ट होने पे। जैसे कोई जज सिलेक्ट होते हैं, उनका एक ट्रेनिंग पीरियड चलता है, पहले जुडिशियल एकेडमी में चलता है और उसके बाद उनको एक प्रैक्टिकली कोर्ट में भेजा जाता है, जहां वो एक ऑलरेडी काम कर रहे जज के साथ बैठते हैं, देखते हैं कैसे केसेस आ रहे हैं, ऑर्डर्स कैसे लिखवाए जा रहे हैं। उस ट्रेनिंग पीरियड को बढ़ा दिया जाए कि कोर्ट को कैसे संभालना है। पूरी तरह से हटा देना बिल्कुल ठीक नहीं है, एस्पिरेंट्स के नजर से भी और पेंडेंसी को देखते हुए भी। सोसाइटी में ये बहुत ज्यादा बुरी चीज हो जाएगी, जुडिशियल पेंडेंसी बढ़ जाएगी और इंडिया का जस्टिस सिस्टम बड़ा अफेक्ट हो जाएगा। फिर पार्लियामेंट में डिबेट्स होंगे, नए एक्ट्स आएंगे, तो ये काफी लंबा चला जाएगा। सुप्रीम कोर्ट ने शायद ये सारी पॉसिबिलिटीज देख ली हैं और इसीलिए इसको कंसीडर किया है। एंड आई थिंक एस्पिरेंट्स के फेवर में ये फैसला आएगा, लेकिन थोड़ी मॉडिफिकेशन के साथ।
ओके, तो आप होपफुल हैं, आप पॉजिटिव हैं एज एन एस्पिरेंट कि फैसला हमारे हित में ही आएगा। थोड़ा ऊपर नीचे हो सकता है, जिससे आप सारे एस्पिरेंट्स भी सेटिस्फाई हो जाएंगे उस ऊपर नीचे वाले फैक्टर से, राइट?
एस्पिरेंट्स एज वेल एज एडवोकेट्स, बार एंड बेंच दोनों बैलेंस रहेंगे। सुप्रीम कोर्ट में बहुत एक्सपीरियंस जस्टिसेस बैठे हैं, उन्होंने सारे कंसिडरेशन लिए हैं, कुछ सोचकर ही लिए हैं। सभी को कंसीडर करते हुए दे विल गिव आउट अ बैलेंस्ड जजमेंट। आई थिंक
दैट्स सो गुड, सो गुड, गुड ओपिनियन है। और जो है हम सब यही चाहते हैं। कमिंग टू करण सागवान सर, आज सारे लीगल एस्पिरेंट्स या जुडिशरी एस्पिरेंट्स की नजर है सुप्रीम कोर्ट पे कि किसी भी क्षण फैसला आ सकता है। अब फैसले आने में यह है कि भाई या तो 3 साल के प्रैक्टिस रूल को हटा दिया जाए, या कूलिंग पीरियड ऑफ कर दिया जाए, या फिर लिटिगेशन करने को बोला जाए। मेरा ये मानना है सर कि अगर मान लीजिए मैं एज एन एस्पिरेंट 5 साल लॉ करने के बाद 3 साल की वकालत करती हूं और मेरी वकालत जम गई, तो मैं क्यों जाऊंगी पेपर देने? इजंट इट?
डेफिनेटली मैम, बिल्कुल सही बात है आपकी।
क्या व्यू पॉइंट है कि जब मेरी 3 साल की वकालत, जब मैं पूरी चप्पलें घिस के अपनी जमा ही लूंगी, तो मैं पेपर देने क्यों जाऊंगी? फिर पेपर के लिए मेहनत करूं, तैयारी करूं एंड सो ऑन। तो ये जो रूल है, ये इतनी देर से हम डिस्कस कर रहे हैं कि अफेक्ट कर रहा है। मैं ये आपका व्यू पॉइंट जानना चाहती हूँ इस चीज पे कि क्या लोग अभी भी अपना ड्रीम परस्यू करेंगे अगर 3 साल का प्रैक्टिस रूल लागू हो, जो हुआ है अभी, अगर वही कंटिन्यू रहता है तो?
मैम देखिए, कुछ बच्चे जिद्दी होते हैं कि भाई जज बनना है तो बनना है, 3 साल का हो 5 साल का हो, हम तो इसी में लगे रहेंगे। लेकिन आपकी बात बड़ी सटीक लगी मुझे और बहुत अच्छी बात भी आपने कही कि 3 साल अगर मैं वकालत करने जाऊंगा और मैं वहाँ अपने जूते चप्पल घिसने वाला हूँ, सीनियर के आगे पीछे घूमने वाला हूँ, और 3 साल में वैसे होता नहीं है कि वकालत चमक जाए। अगर खुदा ना खास्ता मेरी वकालत चमक गई तो मैं मैम डेफिनेटली लोअर जुडिशरी तो नहीं करने वाला हूँ। फिर मैं 4 साल और लगा के अपना हायर के लिए एडीजे में बनने के लिए जो है वो ट्राई करूंगा। डेफिनेटली मैम, ऐसा है काफ़ी सारे एस्पिरेंट्स के साथ। और कुछ ही पल हैं, क्योंकि आई थिंक अभी लंच हो रखा है, बहुत जल्दी जो है हमारी बेंच बैठने वाली है और जो है बहुत जल्दी हम लोग देखने जा रहे हैं कि फैसला जो है इन स्टूडेंट्स के हक में आएगा। ऑब्वियसली हक में ही आएगा, मैं ये नहीं कह रहा हूँ कि बिल्कुल ही नेगेटिव नहीं जाने वाला है। अगर नेगेटिव जाता तो सुनते ही नहीं, क्योंकि हमने देखा है सुप्रीम कोर्ट के पास इतना समय नहीं होता है कि फालतू की बातें वो सुने, प्राइमा फेसाली डिस्पोज ऑफ डिसमिस कर देते हैं। लेकिन यहाँ पे सुना है, लास्ट हियरिंग में भी सुना है, और खुद ने सीजीआई साहब ने जो है इसके अंदर एक एक्टिव पार्टिसिपेशन किया, आगे बढ़ के खुद ने उन्होंने पार्टिसिपेशन किया है। तो पॉजिटिव रुख है मैम, बाकी देखते हैं क्या होता है, लेट्स सी।
डेफिनेटली सर, डेफिनेटली सबकी नजर सुप्रीम कोर्ट के इस फैसले पे ही है। और पर्सनली मैं बहुत ज्यादा पॉजिटिव हूँ, होपफुल हूँ, एक्साइटेड हूँ कि फर्स्ट फैसला हमारे हित में ही आएगा। मैं कुछ ज्यादा ही पॉजिटिव हूँ। कमिंग टू एमजे सर, सर पिछली बार जब ये रिव्यू पिटीशन को अलाउ किया तो हमने तो बहुत पार्टी करी इस बात को ही लेकर कि चलो जज साहब ने हमारी सुनवाई कर ली। लेकिन मेरा आपसे एक सवाल ये है कि एक बात कही थी ऑनरेबल सीजीआई ने कि लड़कियां बहुत ज्यादा अफेक्ट हो रही हैं। आपने अपने प्रीवियस, अभी जब मैंने आपसे ओपिनियन मांगा था, आपने कहा लड़के भी तो हो रहे हैं, नो डाउट अबाउट इट, बट समवेयर और द अदर सोसाइटी लड़कों से ज्यादा लड़कियों को प्रेशराइज करती है। उस पे आपका क्या कहना है?
Actually, everyone is talking about the problem that girl or women are facing in the society. So, as a responsible citizen of this country, मुझे लगा कि मुझे लड़कों की बात भी रख देनी चाहिए। बेचारों के बारे में कोई नहीं कह रहा, उनके बारे में कोई बात नहीं कर रहा। और क्योंकि मैं खुद एक लड़का ही हूं, तो मुझे पता है कि लड़कों को क्या प्रॉब्लम फेस करनी पड़ती है। ठीक है, ये बात बिल्कुल ठीक है कि लड़कियों को ज्यादा प्रॉब्लम फेस करनी पड़ रही होगी। यही रीजन है कि वो सिलेक्शन भी ज्यादा लेती हैं। उनके पास टाइम रहता है कि 1 साल में सिलेक्शन प्रोटेक्शन ले लो या तुम्हारी शादी कर देंगे। तो आप राजस्थान का पिछला एग्जाम देखिए, 79% गर्ल्स ने सीट ले गए हैं। तो उसके पास लड़कियों के लिए एडवांटेज भी है, लड़कों के पास दूसरा प्रॉब्लम है, उनको घर संभालना है, करियर बनाना है, पैसे कमाने हैं। और मैं ये बात कर रहा था एक बहुत गांव में रहने वाले लड़के के बारे में, लड़की के बारे में, इर्रेस्पेक्टिव ऑफ द जेंडर, लड़का लड़की थर्ड जेंडर पीडब्ल्यूबीडी कैटेगरी, हम सब के बारे में बात कर लेते हैं। सब एक समान प्रॉब्लम फेस कर रहे हैं। लड़कों के ऊपर बर्डन ज्यादा है, इसलिए मैंने उनको बारे में कह दिया था, क्योंकि लड़कियों के बारे में कई बार ये कह दिया जाता है कि शादी कर लो। लड़के को तो अपनी प्रैक्टिस जमानी है, कैसे घर से बाहर निकल के वो प्रैक्टिस जमाएगा? 3 साल बहुत लंबा समय है सर्वाइव करने के लिए मैम। और जैसा कि मानसी ने, करण सर ने, आप सब ने, हम सब इस बात को जान रहे हैं। हमने भी कभी प्रैक्टिस स्टार्ट की थी और हमारे सीनियर ने ये कह दिया था कि जब वकील बूढ़ा होता है तो उसकी वकालत जवान होती है। तो वकील कब बूढ़ा होगा, उसकी वकालत कब जवान होगी? तो बहुत सारे स्टूडेंट सोचते हैं कि हम जुडिशियल एस्पिरेंट बन करके जज बन सकते हैं। तो सबसे बढ़िया तरीका है, इर्रेस्पेक्टिव की क्या जजमेंट आने वाला है, मुझे लगता है एवरी लॉ ग्रेजुएट शुड बी अलाउड टू फिल द फॉर्म। ये बात और है, एक बार बार हम ये बात कह रहे हैं कि अगर आपको लगता है कि एक्सपीरियंस लोग चाहिए तो आप एक्सपीरियंस लोगों को वरीयता दे दीजिए, कोई बात नहीं। अदरवाइज 3 साल की प्रैक्टिस में, क्योंकि मैंने प्रैक्टिस की है, 3 साल से ज्यादा प्रैक्टिस की है, आप 3 साल में कहीं कोई ट्रेनिंग इंस्टीट्यूट ठीक से ट्रेनिंग नहीं दे रही है। अगर हम ये कहते हैं कि कोई अगर एलएलबी करने वाला ग्रेजुएट कोर्ट में जाकर प्रैक्टिस कर रहा है और प्रैक्टिस में कोर्ट के एटिकेट सिखाए जा रहे हैं, तो झूठ बात है। मुझे नहीं पता दिल्ली के किसी कोर्ट में सिखाया जा रहा होगा, तो शायद पुनीत सर बताएंगे। अदरवाइज मध्य प्रदेश, छत्तीसगढ़ में एटिकेट्स नहीं सिखाए जा रहे हैं। जो आपने कहा कि क्लेरिकल करवाया जा रहा है सीनियर के साथ में, कोर्ट रूम डेकोरम, 2 साल मैंने तो चैम्बर प्रैक्टिस की है अपने सीनियर के साथ में, मैं कोर्ट ही नहीं गया। और तीसरे साल जब कोर्ट गया उनके साथ में, तो कहानी समझने की बात यह है, मैं जो बताना चाह रहा हूं, इट इज नॉट अबाउट क्रिटिसाइजिंग एनीवन, इट इज अबाउट कि एक आम बच्चा क्या प्रॉब्लम फेस कर रहा है। 3 साल में आपने कोई ट्रेनिंग दी ही नहीं। एक काम अगर सुप्रीम कोर्ट ये कह देता कि बीसीआई की जिम्मेदारी है 3 साल इसको प्रैक्टिस करवाना, मनन कुमार मिश्रा साहब भी तो बैठे हैं, तीसरा टर्म चल रहा है उनका, क्या बार काउंसिल ऑफ इंडिया सिर्फ फीस लेने और सर्टिफिकेट देने के लिए बैठा है? ये कह दें कि 3 साल प्रैक्टिस करवाने की जिम्मेदारी बीसीआई की है, एटिकेट्स और मैनर की ट्रेनिंग बीसीआई देगा, तो भी ये जस्टिफिएबल होता। लेकिन आप कहो कि 3 साल की प्रैक्टिस करके आइए, दिस इज शेयर आर्बिट्ररी डिसीजन, मुझे ऐसा लगता है, विद ड्यू रिस्पेक्ट टू ऑनरेबल कोर्ट।
डेफिनेटली सर, मैं इसमें जो आपका जो ये वरीयता वाली बात है ना, इसमें थोड़ा सा डिसएग्री करूंगी, बहुत स्लाइटली सा, कि उसमें भी फिर लोगों को लगेगा यार, मैं अगर एस्पिरेंट होती और मेरे पास वरीयता नहीं होती तो मुझे बहुत दुख होता कि यार मुझे इंटरव्यू में कंसिडर नहीं किया। और अल्टीमेटली इंटरव्यू में ऐसा हो जाता है कि यार जिनके पास एक्सपीरियंस है उन्हीं का सिलेक्शन हो रहा है, जिनके पास एक्सपीरियंस नहीं है उनका सिलेक्शन नहीं हो रहा। तो मेरा अपना, अगर मेरी अपनी राय अगर आप मुझसे पूछें, तो सर मेरा ये कहना है कि सबसे बेस्ट है कि सबको अलाउ करो पेपर देने के लिए। दूसरा, ट्रेनिंग को स्ट्रिक्ट कर दो, ट्रेनिंग
ठीक है, अच्छा आइडिया है, ये भी बहुत अच्छा आइडिया है, करेक्ट है, 200%
हम जो है ट्रेनिंग को और स्ट्रिक्ट कर दें, उसमें 4 पेपर और बढ़ा दें कि ये 4 पेपर क्वालिफाई करोगे, एटिकेट्स के, इसके बिहेवियर के, कोर्ट रूम के, सब उसी में जांच कर ली जाए ट्रेनिंग में, और उसके बाद फिर चमकता हुआ जज जो है बेंच में बैठाया जाए। क्या कहते हैं आप?
बिल्कुल करेक्ट बात है, लेकिन मैं वरीयता वाली बात इसलिए कह रहा था कि सुप्रीम कोर्ट का, एक्चुअली मध्य प्रदेश हाईकोर्ट ने सबसे पहले ये शिगुफा छोड़ा था, और एमपी में ये कह दिया था कि 3 साल की प्रैक्टिस होगी, वही लोग आएंगे। और अभी मानसी जी ने बताया कि जब ये रूल आया था तब लोग दुखी हो गए थे। मध्य प्रदेश में भोपाल में एक लड़की ने सुसाइड कमिट कर लिया था जैसे ही 3 साल की वर्डिक्ट आई, बिकॉज शी हैज अपीयर्ड इन एग्जामिनेशन ट्वाइस शी क्लियर्ड मींस एग्जामिनेशन, एंड शी इज वन हु हैज अपीयर्ड इन इंटरव्यू एज वेल। अब इतना प्रैक्टिस कर, इतना एग्जाम देने के बाद, मींस निकालने के बाद, इंटरव्यू से लौटने के बाद अगर अचानक से 3 साल की प्रैक्टिस आ जाएगी, तो सोचिए उस लड़की ने सुसाइड कर लिया। मैं आपको एग्जांपल देता हूं, जब मेरे पास आज से पहले, कुछ समय पहले, ये वर्डिक्ट आने के पहले स्टूडेंट पूछता था कि सर क्या हमको प्रैक्टिस करनी चाहिए या हमको सीधे प्रिपरेशन करना चाहिए, तो मैं उन स्टूडेंट्स को बार बार ये कहता था कि आपको प्रैक्टिस नहीं करनी है, क्योंकि प्रैक्टिस फुल टाइम जॉब है। आप प्रिपरेशन कीजिए, एग्जाम दीजिए, नहीं हुआ तो आप रजिस्ट्रेशन करवाइए। मैं रजिस्ट्रेशन करवाने के लिए भी मना करता था, क्योंकि रजिस्ट्रेशन भी हमारे देश में फ्री में नहीं हो रहा, थाउजेंड्स ऑफ रुपीज चाहिए। इवन रजिस्ट्रेशन करवाने के लिए आपको चप्पल खींचनी पड़ती है, फॉर्म लेकर आइए, फॉर्म भरिए, जमा कीजिए, फॉर्म भी 1000 रुपए का मिल रहा है हमारे मध्य प्रदेश में। तो चीजें आसान नहीं है, सस्ती नहीं है। और हम बार बार किसी गरीब के बारे में सोचें जिसके पास खाने को पैसा नहीं है, जो अपना ड्रीम देख रहा है जुडिशरी में, उसके तो सपने चकनाचूर हो चुके, बर्बाद हो गया वो तो।
बिल्कुल बिल्कुल
बिल्कुल। श्रीवी मैम, इसमें मैं एक लाइन ऐड करूंगी कि मौका ना मिलना अलग बात है, लेकिन टैलेंट होते हुए मौका छीन लेना, ये मुझे नहीं लगता कहीं का भी
वाह, क्या बहुत बढ़िया बात है,
जस्टिस है
बहुत
किसी भी
बढ़िया,
एस्पिरेंट से।
वेरी गुड, बहुत अच्छी बात है ये मौका छीन लेने के समान है। शी हैज करेक्टली सेड दैट ये मौका छीन लेने के समान है, मौका नहीं मिलने का काम नहीं है, मौका छीन लिया गया है।
मतलब एक तरीके से हम ये कह
अप्रिशिएट
सकते हैं
योर
कि
स्टेटमेंट।
आपके इस स्टेटमेंट से मुझे ऐसा लगता है कि हम इस रूल की वजह से कहीं ना कहीं टैलेंटेड कैंडिडेट्स को डिस्करेज कर रहे हैं।
यस,
हम कहीं ना कहीं मेरिट से कॉम्प्रोमाइज कर रहे हैं।
मैम क्योंकि आज के टाइम पे मैं थोड़ा सा इंटरप्ट करना चाहूंगा, जो बच्चा
बिल्कुल
जो है
बिल्कुल
वो
करण
10th
सर, अपना जरा लाइट इस पे बताएं कि हम जो ये बात कर रहे हैं मेरिट को जो है हमें वरीयता देनी चाहिए और
डेफिनेटली मैम,
डिस्करेज कर रहे हैं हम इसको। आप इस
इसमें
पे
मैं
क्या
कुछ
कहना
चीजें
चाहते हैं?
ऐड ऑन करना चाहूंगा मैम। आज के टाइम पे जो है बहुत फास्ट फॉरवर्डिंग हो गई है सारी चीजें। आज के टाइम पे बच्चा 9th और 10th क्लास में डिसाइड कर रहा है, क्योंकि हम सबने देखा है क्लैट के अंदर मैम बच्चा 10th क्लास में क्लैट की प्रिपरेशन कर रहा है, एक माइंडसेट लेके चल रहा है कि मुझे आगे जाके जुडिशियल ऑफिसर बनना है, राइट। और जब ये 2025 में जजमेंट आ रहा है, जिन बच्चों ने 2025 में भी एडमिशन लिया है उन्होंने भी इसी माइंडसेट से एडमिशन लिया है कि आफ्टर 5 ईयर और जो मैं फाइनल ईयर में होऊंगा तो मैं आरजेएस जैसे एग्जाम्स जो है अपीयरिंग कैंडिडेट्स भी दे सकते हैं। सो एटलीस्ट अगर हम इसको रिमूव नहीं कर रहे हैं तो 5 साल के लिए हम एक्सटेंड कर दें, या जिन बच्चों ने 2025 में जजमेंट से पहले एडमिशन लिया है उनके ऊपर ये रूल बिल्कुल लागू नहीं होना चाहिए, सो डेट आगे जो स्टूडेंट्स आ रहे हैं वो सोच समझ के जो है लॉ में अपना एडमिशन लें। मेरा ये इस पे बहुत सटीक मानना है इस चीज को।
अच्छा, मैं चतुर्वेदी सर से एक सवाल पूछना चाहती हूँ, उसके बाद आई विल कम टू पुनीत सर ऑल्सो। चतुर्वेदी सर, ये जो रिफॉर्म है, मान लीजिए कि 3 साल का प्रैक्टिस रूल आ जाता है, तो ये 3 साल का प्रैक्टिस रूल एक तरीके से हमारे लिए अच्छी चीज होगा या हम रिस्क में चले जाएंगे? और आई थिंक आई शुड हैव आस्क्ड दिस क्वेश्चन टू पुनीत सर, क्योंकि वो जो है वकालत कर रहे हैं ना, उन्हें ज्यादा अच्छे से पता होगा। बट एनीवेज आई एम आस्किंग टू चतुर्वेदी सर एंड देन द सेम क्वेश्चन टू पुनीत सर, कि क्या हम रिस्क में तो स्टेप इन नहीं कर रहे हैं 3 साल का प्रैक्टिस रूल हटा के?
नहीं, 3 साल का प्रैक्टिस रूल कंप्लीटली तो स्क्रैप होगा नहीं, उसमें कुछ मॉडिफिकेशंस होने चाहिए। अगर इसी फॉर्म में है तो वो रिस्की हो जाएगा, क्योंकि तब वो मेरिटोक्रेसी को नहीं, जो है वो क्या कहते हैं, वो आप ये समझिए कि वो जो है क्या मीडियोक्रिटी को जो है वो करेगा, परपिचुएट करेगा। तो जो 3 साल का प्रैक्टिस रूल है, जो अगर इसी फॉर्म में वो उसको कंटिन्यू करता है अगर ऑनरेबल कोर्ट, तो ये बहुत दिक्कत वाली बात हो जाएगी, क्योंकि इससे जो है मीडियोक्रिटी ही बढ़ेगी। 3 साल ऐसा कोई बहुत लंबा समय नहीं है कि जिसमें किसी की वकालत चमक जाए। हार्श रियलिटी बहुत गड़बड़ है, जो प्रैक्टिस रिलेटेड जो रियलिटीज हैं ग्राउंड पे वो बहुत गड़बड़ हैं। पेंडेंसी भी बहुत ज्यादा है। अब यूपी में मुकदमे आप ये समझिए, एक दिन में कोर्ट्स में 150-150, 200 मुकदमे लगते हैं। जुडिशियल ऑफिसर के लिए पॉसिबल नहीं है कि वो सारे जो जितने रिकॉर्ड उस दिन लगते हैं जिस डेट पर, उसको ह्यूमनली देख सके। तो बहुत सारे ऑर्डर्स जो है क्लरिकल होते हैं, टाइपोग्राफिकल होते हैं, साइक्लो स्टाइल्ड होते हैं, फॉर्मेट बना हुआ है, उसमें लिख दिया, जज ने सिग्नेचर कर दिया। तो पेंडेंसी भी एक बहुत बड़ा इशू है। जजों की संख्या का कम होना ये भी एक बहुत बड़ा इशू है। तो ये सारे फैक्टर्स तो हैं ही। अगर इसी फॉर्म में अगर ये 3 ईयर प्रैक्टिस रूल अगर कंटिन्यू कर जाता है बिना किसी मॉडिफिकेशन के, तो उससे बहुत दिक्कत होगी। अगर हट जाए तो दिक्कतें कम है, क्योंकि जो पहले वाली बात थी, एटलीस्ट हमारे पास नंबर ऑफ जजेस तो आएंगे, रेगुलर वैकेंसी आए और नए यंग टैलेंट्स को एनकरेज किया जाए, वो आए जैसे पहले आ रहे थे इस प्रैक्टिस रूल के पहले, तो कम से कम नंबर ऑफ जजेस बढ़ेंगे, हमारे पास जो है पेंडेंसी कम होगी, रेशियो इंप्रूव होगा जजेस टू केसेस का, और उसके बाद हम उनको ट्रेनिंग से स्ट्रेंथन करके हम उनको ज्यादा इक्विप कर सकते हैं, ज्यादा बेहतर बना सकते हैं। मेरा यही मानना है।
ठीक है पुनीत सर, इसमें कुछ आइसिंग ऑन द केक करनी है आपको?
मैम, मैं ये करण सर से एक चीज से एग्री करना चाहूंगा। एज करण सर करेक्टली सेड कि आज लाइफ बहुत फास्ट फॉरवर्ड हो गई है। मैम मैं जब 9th क्लास में था तो मैंने कभी ये नहीं सोचा था कि मैं लॉ करूंगा या किस प्रोफेशन में जाऊंगा। बट स्टूडेंट्स दीज डेज दे आर वेरी एम्बिशियस एंड पैशनेट अबाउट देयर कैरियर। एंड मैम, अकॉर्डिंग टू मी 3 years इज वेरी हार्श फॉर द सीरियस एस्पिरेंट्स. If the aspirant is serious about his career, he is very passionate, then it is very harsh for him to wait for 3 years just to get the chance to appear for the exam. And ma'am, as I already said कि जो यूपीएससी है, अनलाइक यूपीएससी, जुडिशरी एग्जाम में सर्टेनिटी नहीं है। जुडिशरी एग्जाम अगर एक एग्जाम हो रहा है, इवन दो देयर इज अ जजमेंट ऑफ मलिक मजहर सुल्तान जो कहती है कि देयर शुड बी टाइम बाउंड मैनर एग्जाम कंडक्ट होना चाहिए, बट वी हैव सीन एम्पल अमाउंट ऑफ केसेस कि स्टेट्स में कोई भी एग्जाम टाइमली कंडक्ट हो ही नहीं रहा है। कोई भी किसी भी एग्जाम में किसी भी क्वेश्चन के रिगार्डिंग रिट लग जाती है, किसी भी रूल्स के रिगार्डिंग रिट लग जाती है, तो मैटर हाई कोर्ट सुप्रीम कोर्ट डिसाइड करते होते होते उसे इतने साल लग जाते हैं। सर एमजे सर करेक्टली बता सकते हैं, जो 2023 की एमपी हाई कोर्ट की जो नोटिफिकेशन थी जिसमें उन्होंने 3 years एंड 70% ऑफ मार्क्स के लिए किया था, दैट जजमेंट विल टेक 3 years। उसमें 3 साल लिए सुप्रीम कोर्ट तक डिसाइड होने के लिए। तो मैम उसमें क्या होता है, जो एस्पिरेंट है वो 3 साल के लिए लटक जाता है। अनलाइक यूपीएससी, यूपीएससी में क्या है कि आप एक टाइम बाउंड मैनर में, आपको पता है, यू आर क्लियर विद द फैक्ट कि आपके पास 6 अटेम्प्ट है। बट जुडिशरी में ऐसा नहीं है, यू माइट गेट ओनली 1 अटेम्प्ट ऑफ योर प्रेफर्ड स्टेट।
ठीक है सर, ठीक है, आई टोटली एग्री। नाउ आई वांटेड टू आस्क मानसी कि अगर ये रूल इम्प्लीमेंट हो गया, मान लेते हैं कि अगर ये 3 साल का प्रैक्टिस रूल इम्प्लीमेंट हो गया, तो फिर एक स्टेप, आप कह सकते हो एक बेसिक स्टेपिंग स्टोन हो जाएगा कि भाई लिटिगेशन इंपॉर्टेंट है। तो फिर एस्पिरेंट्स क्या करेंगे, या उनका फिर क्या मैसेज रहेगा?
मैम मुझे लगता है कि सबसे पहले अगर ये इम्प्लीमेंट हो गया तो बहुत दुखद होगा उन एस्पिरेंट्स के लिए जिनका एक सपना रहा है कि जज बनना है। लेकिन वकालत को ज्यादा फिर चुनने लगेंगे लोग, क्या करेंगे? करियर तो बनाना ही होता है। अब एलएलबी करके कहाँ जाएंगे? जब लॉ की डिग्री करी, अब लॉ में या तो वो एपीओ भरेंगे, और अगर एपीओ में भी ऐसा कुछ लगा दिया तो रुख ही खत्म हो जाएगा। जज बनने का सपना लोगों का मतलब डिसइंटरेस्ट हो जाएगा बहुत। और
मुझे
इसका
लगता है आप
सारा
मेरे क्वेश्चन से ही खुश नहीं है कि मैम कैसी बातें कर रही हैं कि आप इम्प्लीमेंट क्यों ही होगा। आप मुझे आपकी जो है आपका डिमेनर बता रहा है
मैं
कि
इसमें
भाई
थोड़ा
एक
सा
कैसा
इंटरवीन
क्वेश्चन
करना
पूछा
चाहता
है ये।
हूँ। फिर उसमें क्या होगा पता है, वो जो पुरानी कहानी थी ना, राजा का बेटा राजा बनेगा, फिर जज का बेटा ही जज बनेगा, क्योंकि उसके
बिल्कुल
पास सुविधा होगी, चीजें होंगी। गरीब का बेटा जुडिशरी में नहीं आएगा।
बिल्कुल
ये
सर,
होगा।
बिल्कुल
बिल्कुल
सही
एग्री
कहा
करूंगा
सर।
मैं भी आपकी
वेरी
बात से।
करेक्टली सेड, वेरी
और
करेक्टली सेड मैम।
इसका सबसे ज्यादा इफेक्ट सोसाइटी पे जाएगा। अब गरीब का जो बहुत नीचे से उठ के जज बनता है वो सारे एस्पेक्ट्स को जानता है, समझता है, वो दोनों पार्टीज की तरफ से सोचता है। एक बायसनेस फिर जुडिशरी में दिख जाएगी। ये
बिल्कुल हो सकता है, पॉसिबिलिटीज है।
बहुत तरह से ये सोसाइटी में।
मीन्स इसका लॉन्ग इम्पैक्ट होगा सोसाइटी पर, इतनी सी बात है। इट विल
तो
क्रिएट अ लॉन्ग लास्टिंग इम्पैक्ट।
आप सबके व्यू पॉइंट से मैं ये समझ पा रही हूँ कि कहीं ना कहीं जो ये रूल है ये हमारे जुडिशियल सिस्टम को भी अफेक्ट करेगा, बायसनेस देखने को मिलेगी, जैसा कि अभी आपने एक स्टेटमेंट दिया। तो इस पे करण सर आप क्या कहना चाहते हैं कि ये जो बायसनेस वाली बात है, या फिर राजा का बेटा राजा बनेगा, अभी आप इस पे कुछ कह रहे थे, प्लीज अपने व्यू पॉइंट को शेयर करें।
मैम बिल्कुल बहुत सही बात की है एमजे सर ने कि राजा का बेटा राजा बनेगा क्योंकि उसके पास रिसोर्सेज हैं। ये हमने कोविड में भी देखा। मैम मरता गरीब आदमी है, ये हम सब जानते हैं, है ना, जो एक गांव से निकल के आ रहा है। क्योंकि हम बात करें भीमराव अंबेडकर साहब की, तो उनकी जर्नी जो है हम सब ने देखी है, बहुत इंस्पायर भी होते हैं। तो एक बच्चा जो एक छोटे से गाँव में है, जिसका एक सपना है कि भाई मैं वकालत करूंगा, बड़ा जो है जज बनूंगा, तो वो सपना साकार नहीं हो पाएगा मैम। उसके पास खाने के लिए भी नहीं है, वो सर्वाइव कैसे करेगा 3 साल? बिल्कुल सही बात है एमजे सर की, और टोटली एग्री करूंगा। मेरा तो बड़ा क्लियर है कि इसको रिमूव कर दो, बिल्कुल ही रिमूव कर दो। अगर लगाना है तो 5-6 साल बाद लगा दीजिएगा आप।
ठीक है सर, अब एक रैपिड फायर राउंड खेलेंगे। आपको बस एक एक वर्ड चूज करना है, ठीक है? स्टार्टिंग विद करण सर, रिफॉर्म है या रिस्क?
मैम रिस्क है, और बहुत बड़ा रिस्क है इसके ऊपर। लाइफ रिस्क कहूंगा, थ्रेटनिंग टू लाइफ है मैम डायरेक्टली, क्योंकि सर ने बताया सुसाइड भी अटेम्प्ट कर रहे हैं बच्चे। इट्स
यस।
वेरी वेरी रिस्की मैम।
ओके एमजे सर, एक्सपीरियंस या मेरिट?
बोथ।
बोथ? यू हैव टू चूज वन ओनली।
बोथ साइमल्टेनियसली।
मैम एक्सपीरियंस विद मेरिट।
Experience with married. Thank you very much for putting the words, Puneet sir.
Yes, because I believe when we were taking interview of judiciary aspirants, we were having an honorable judge in the panel. So he always used to say one line, that is, the confidence should go along with the merits. Not
Wow.
only the confidence, but the confidence should go along with the merit.
इसमें एक लाइन में जोड़ दूं, एक्सपीरियंस विद मेरिट विदाउट वेस्टिंग टाइम ऑफ एस्पिरेंट्स।
Perfect, sir. Perfect.
Perfect, sir. Perfect.
Mansi, middle path possible है? Yes or no?
Yes, definitely,
Yes?
no doubt.
No doubt about it. Without
Yes.
hampering the bar and the bench?
Without, yeah.
Without hampering the bar and bench. Okay. Coming to Chaturvedi sir, uniform rule across India, irrespective of any category, gender, yes or no?
नहीं, जो रेस्पेक्टिव कैटेगरीज हैं उनको तो कंसिडर करना चाहिए।
No, this rule of 3-year practice rule either should be removed for everyone or for respective
हाँ
candidates.
बिल्कुल हाँ हाँ बिल्कुल यूनिफॉर्मली रिमूव हो जाना चाहिए बिल्कुल बिल्कुल.
Okay, coming to Puneet sir, young judges are challenged to judiciary.
Not at all, ma'am. Not at all.
No?
They are the future of the country. They cannot be a challenge for the judiciary.
Sure, as an advocate representing the legal fraternity, advocate
Yes,
की
ma'am.
पूरी fraternity
Truly,
represent
ma'am.
कर रहे हैं
Truly.
आप यहाँ.
Lord, I have.
Clause 7 stage, you have given him hearing.
No, I have called him
23
for.
you have not been heard.
He has replied.
Malad,
He replied to that also, and he simultaneously filed a petition in the High
All
Court.
right, now you hear him at 20 clause 7 stage.
Yes, that is the order, my lord. No other thing.
That is the order of the High Court also.
No, High Court doesn't know. High Court said no.
High Court goes to 20
You
clause
go to
3.
20 subsection 3.
FIR se karo.
If your lordship sees the direction.
That's an impractical order.
My lords, please have a look at, my lords,
That is an impractical, all these niceties have no meaning.
I bow down, my lords.
There will not be multiple FIRs.
My lords are right.
So the FIR has merged into an investigation report.
My lords.
And once such a situation has come,
My lords.
20 clause 7 hearing, we will consider as a post-decisional hearing
My lords are right.
for the FIR
My lords are right.
and a pre-decisional hearing for filing of the police
My lords,
report.
just have a look at
That's all.
page 22, para 35, my lords. Please have a look at it. My lords, very different facts.
I am with reference to para
Because
14.
other cases involve, my lords, 20 subclause 7. Now, here is a case, my lords. There were 5 persons. They were given notices under 20 subclause
That's why I
3.
pointed out page 88 to
Yes, my lords.
99.
My lords.
Each one of them when heard.
My lords.
That was 23.
That
right?
is 3.
That was 23
My lords.
hearing, which was not accorded to you.
Yes.
Now you are being heard only at the stage of 27.
Yes.
To be heard, my lord.
To be heard.
Notice has
In
been got.
20, because 23 now practically not possible. FIR has already been registered.
But my lords, against others. But maybe if I am given that opportunity.
FIR is registered against an accused or an offense, sir.
My lords are right. But my lords, my lords, please have a look at para 35.
Will it be every time a new accused comes, a new FIR will be registered?
My lords, not like that. My lords, maybe. My
You
lords,
are
purpose.
interpreting like that.
My lords, there is pre-stage, there is post-stage. Now, this is a case where there is a violation of pre-stage.
We will not apply the law with our eyes folded. We will apply the law in a pragmatic manner where your rights are not affected. At the same time, the carriage of proceedings do not become an absurdity.
My lords,
you're creating an absurdity.
Now, my lords, may I respond to this? My lords, just may I respond to
The situation
Just-
will create complication for you as well as for.
My lords, I appreciate. Now, my lords, may I respond to that, my lords?
Right?
Please.
Because every time this will happen. Sir.
No. If I may respond to that, allow me to respond to that, my lord, just 2 paragraphs of the High Court order, my lord, because my cases. Now, my lord, the
We'll
scheme.
give you an example
My
which
lords.
will help you to respond.
My lords, my lords.
An FIR proposal is before the Lokpal saying a corruption ring has been unearthed in preliminary inquiry. A, B, C, and unknown others
Yes, my lord.
are involved.
Yes, my lord.
Lokpal gives notice to ABC.
My lord.
Unknown others, Lokpal is also not clear.
My lord.
Investigation commences. Materials transpired disclosing the identity of these unknown others.
My lords.
Is it your case that the Lokpal again goes back to 20 clause 3, gives notice to those unknown others identified now, and if separate investigation and FIR commences,
Yeah.
this will
My
be
lords-
against the entire tenor of.
My lords, I appreciate what is falling. I appreciate. But my lord, the very purpose of subclause 3 in this case is that if I had given an explanation and if the Lokpal is satisfied, then maybe the proceedings are dropped against me there.
Explanation
That is a
now,
very
the
important
Lokpal
stage for
can
me.
close the case.
You can't even plead this argument because it is not a case where 23 benefit has gone to your co-accused. Their stand under 23 has been rejected. They are facing trial.
My lords, one fact. No, my lord, that's not the case. There were 5 given. Only one has been, only against one FIR has been registered. Only against one, 4 have been dropped. Now, my lords, had that opportunity been given? Because, my lords, in the scheme of the act, that is why, my lords, I am beseeching, my lords, please have a look at 35. And now, my lords, what is the direction in this case? My lords, please have a look at page 30 to answer what was falling from Justice Bakshi, my lords. Yes, he can give me notice. I may convince him that you don't have to proceed. That's an important stage.
Go and convince. We are adding something in your favor. Being heard learned senior counsel on behalf of the appellant Lokpal and then counsel for the respondent. We modify para 48 of the impugned judgment dated 14th November 2025, passed by the Delhi High Court, to the extent that the learned Lokpal shall accord an opportunity of hearing to the respondent in terms of section 20(7) of
3
Lokpal Act.
Please.
So since the respondent was could not
Notice
be-
has already gone, my lord, and he's replied. My lords, Then he has to be heard only now. No, my lords, with respect. Gone to him, he has replied to it, then filed the writ petition.
So
He is only to
we are
be
saying
heard.
only a hearing only to be accorded.
Only has to go No, on. my lords, with respect. Then, my lords, this is. Then it's quashed, I can't do it.
Since the respondent could not be heard at the stage of 20(3), he shall be at liberty to raise all the
No,
contingencies
my lords, with respect.
which were available, which
My lords,
could be available
in that case,
under 23 of the Lokpal Act. We request the land Lokpal to consider all such all such submissions that may be made by the
my lords,
respondent during the course of hearing.
my lords, with respect, my lords, just consider this, my lords. My lords, just consider this. My lords.
If you are not considering what we can do, there is no other way out.
27.
सो यस, किसी भी टाइम पे हमारा जजमेंट आ सकता है, या जजमेंट तो आना ही है, मतलब एक तरीके से सुनवाई ही शुरू हो सकती है। मेरे साथ है यहाँ पे करण सर। अभी हम एक डिबेट रूम से बाहर एग्जिट लेकर आए हैं। हम डिस्कस कर रहे थे कि 3 साल की प्रैक्टिस रूल बहुत बुरी तरीके से अफेक्ट कर रहा है एस्पिरेंट्स को। देन वी हैव ओपिनियन ऑफ लॉट ऑफ पीपल कि एस्पिरेंट का क्या कहना है, एक एडवोकेट का क्या मानना है, एमजे सर एज एन एडुकेटर उनका क्या मानना है, और करण सर ने भी हमें अपना व्यू पॉइंट बताया। करण सर हमारे साथ यहाँ पे जुड़े हुए हैं। सर, कि जो 3 साल का प्रैक्टिस रूल अप्लाई हुआ है ना, उससे जो मेरे स्टूडेंट्स मुझे मैसेज करते हैं, या जो डिसहार्टनिंग जो टाइम रहा है उनका, ये उस पे अब मुझे लगता है कि वो दिन है जब फैसला आएगा, हमारे हित में आएगा, और अगर कंप्लीटली हमारे हित में नहीं आता है तो कुछ ना कुछ बैलेंस होते हुए आएगा। करण सर, ओवर टू यू प्लीज।
डेफिनेटली मैम, और इसका जो है बेसब्री से इंतजार है। आज से इंतजार नहीं कर रहे मैम, जब से ये उम्मीद उठी थी कि रिव्यू पिटीशन फाइल की गई है, भूमिका ट्रस्ट के द्वारा भी फाइल की गई हैं चीज़ें, तो तब से ही जो है एक उम्मीद की जो है यहाँ पे उम्मीद थी हम सबको कि हियरिंग होगी, कोई ना कोई पॉजिटिव यहाँ पे जो है रिस्पॉन्स निकल के आएगा। और लास्ट हियरिंग पे जितने स्टूडेंट्स देख रहे हैं, एक बार कमेंट कर दीजिए आप लोगों को क्या लगता है, क्योंकि लास्ट हियरिंग पे भी हमने देखा मैम, सीजीआई साहब ने और अदर 2 जजेस ने जो है खुद ने इंटरेस्ट शो किया और काफ़ी सारे पॉइंट्स ऑफ कंसर्न जो है उन्होंने रेज किए। सो दे आर नॉट पॉजिटिवली लुकिंग अगेन दिस 3 ईयर प्रैक्टिस रूल। उनको नहीं लग रहा है कि भाई ये वर्क कर पाएगा, राइट? तो होप तो यही है मैम, मैं भी सुबह से बैठा हूँ और हमारे साथ काफ़ी सारे बच्चे जो है मॉर्निंग से ही कनेक्टेड हैं। यस एवरीवन, कैसा लग रहा है आप लोगों को? सुबह से बहुत टेंस है मैम, टेंशन का बहुत बड़ा माहौल बना हुआ है, आप भी बहुत ज़्यादा टेंशन में, हम भी हैं कि क्या होने वाला है, क्योंकि हम भी कभी जुडिशरी एस्पिरेंट्स थे, हमने ये प्रॉब्लम फेस नहीं की जेन्युइनली। फाइनल ईयर में थे तो राजस्थान में अपियर कर गए, पास आउट हुए तो किसी अदर एग्जाम को जो है हमने अपियर किया।
हमारे मेरे और आपके तो दुख ही अलग हैं, वो तो एक
डेफिनेटली
अलग दुख है। बट अभी करंट एस्पिरेंट्स के दुख अलग हैं कि भाई 3 साल का प्रैक्टिस रूल इंप्लीमेंट कर दिया। मैं देख सकती हूँ यहाँ पे कमेंट में लोग कह रहे हैं कि आज परमानेंटली रिमूव हो जाना चाहिए, आज इसको हटा ही दीजिए। आज मैं सुबह उठी एंड आई शेयर अ पर्सनल इंसिडेंट विद ऑल माय स्टूडेंट्स राइट हियर कि आज मैं सुबह उठी और उठते ही उठते मंदिर के आगे खड़ी हो गई हाथ जोड़ के कि भगवान आज सुन लेना। बहुत सारे एस्पिरेंट्स हैं जो इंतजार कर रहे हैं इस फैसले का, जो अपने सपने को जेन्युइनली परस्यू करना चाहते हैं, जिनमें सच में कैलिबर है, जो सच में मेरिटोरियस है, उनके हक को ना छीना जाए। विद दिस आई स्टार्टेड माय डे टुडे एंड मेरे में पूरी फुल एनर्जी है सर। मेरा जोश जो है ना वो बहुत ज्यादा यहाँ पे हाई है। एंड व्हाट अबाउट योर जोश, एज यू ऑलवेज आस्क टू योर स्टूडेंट, हाउ इज द जोश टुडे?
हाई सर मैम, ऑलवेज हाई। और रीजन ये भी है क्योंकि सीजीआई साहब से जो है बहुत पॉजिटिव चीजें जो है वहां पे सुनने को मिली। बस दिस इज द रीजन कि जोश हाई है और बहुत पॉजिटिवली हम इसको देख रहे हैं कि आज जो है जजमेंट इन सब एस्पिरेंट के फेवर में आने वाला है। मैम बच्चे कह रहे हैं कि सुबह से आज पढ़ाई भी नहीं की है, कि इसी चीज का इंतजार है कि भाई हमारा भविष्य बनने वाला है या वो बिगड़ने वाला है। बच्चों से पूछ लेते हैं मैम इनका जोश कैसा है आज, इनका जोश भी जानना बहुत जरूरी है, क्योंकि मुझे लग रहा है आज ये थोड़ा सा लो फील कर रहे होंगे, पता नहीं क्या होने जा रहा है, क्योंकि इनका जो एक सपना है वो किसी और ने डिसाइड करना है। मैम डेफिनेटली यस स्टूडेंट्स, कैसा है आप सबका जोश?
स्टेक पे है। हम यहाँ पे देख सकते हैं, आप लोग यहाँ पे स्क्रीन पे देख सकते हैं कि बेंच अभी बैठने वाला है। पोस्ट लंच हमारे मैटर की हियरिंग होने वाली है। और लास्ट टाइम जब रिव्यू पिटीशन अलाउ किया था ऑनरेबल सीजीआई साहब ने, तो बहुत अच्छी बातें बोली थी जिससे हम बहुत ज्यादा पॉजिटिव हुए। इनफैक्ट हमने ये सोचा कि शायद अब कुछ ना कुछ ऐसा होगा जिससे आप सबको कोई राहत मिलेगी एंट्री लेवल पे जुडिशरी एग्जामिनेशन की। नाउ ओके, आज क्या एक्सपेक्टेड है? ठीक है, ओके, पीक पे है, ओके, बहुत लो है सर। अच्छा हाँ भाई, लो तो बनता भी है, आपका ही करियर है, स्टेक पे है, टेंशन है, क्या होगा, 3 साल का प्रैक्टिस रूल हटेगा, हट जाए तो अच्छा है, और मन में तमाम सवाल। और इन तमाम सवालों का जवाब देने के लिए बेंच अभी थोड़ी ही देर में बैठने वाली है।
क्योंकि मैम देखिए ऑब्वियस सी बात है, लंच करना भी बहुत जरूरी है ऐसे इतने बड़े फैसले देने से पहले माइंड थोड़ा सा ठीक हो जाता है उससे, तो पेट भर पूजा जो है होनी चाहिए। तो बहुत जल्दी जो है बेंच बैठने वाली, लंच चल रहा है, इसलिए आपको जो है वो कुर्सियां खाली नजर आ रही होंगी जिनके ऊपर आपका बैठने का भी एक सपना है। और उम्मीद यही है कि उस सपने को जो है आज एक जजमेंट या एक ऐसा फैसला आएगा, ऐतिहासिक फैसला होगा, कि वो आपका जो सपना आप लोगों ने देखा है उस चेयर पे बैठने का, वो भी कहीं ना कहीं साकार होता हुआ आज हमें नजर आएगा।
सर आपने अभी एक रिसेंटली यूट्यूब पे सेशन लिया था जहां पे हमने बताया था कि सुप्रीम हाई कोर्ट ने जो है रिकमेंडेशंस दी हैं, उस रिकमेंडेशंस पे कुछ आप जो है टिप्पणी करना चाहें तो?
मैम देखिए मोस्ट ऑफ द हाई कोर्ट्स ने तो यही कहा है कि 3 ईयर मैंडेटरी प्रैक्टिस होनी चाहिए। उसके काफी सारे रीजंस हो सकते हैं मैम, बार एंड बेंच वाला तो एक मेन रीजन बताया ही जा रहा है। और दूसरा ये है कि भाई थोड़ा सा वो जो होता है ना रिक्रूटमेंट प्रोसेस, थोड़ा सा आप कह सकते हैं कि टाइम कंज्यूमिंग भी होता है, तो उनको ये है कि 3 साल होल्ड करो, आराम से निकालेंगे हम लोग, अभी समय है, राइट। और काफ़ी सारी हाई कोर्ट्स ने तो सपोर्ट ही किया है, बट कुछ यूनिवर्सिटीज़ हैं, स्पेसिफिकली मैं एनएलयूज़ की बात करूं, क्योंकि एनएलयू को हम लोग जो है बहुत एक अलग लेवल में कंसीडर करते हैं कि वो अदर देन लोकल कॉलेजेस, लॉ यूनिवर्सिटीज, उनसे बढ़ के हैं। तो 3 एनएलयूज हैं मैम, सीएनएलयू चाणक्य नेशनल लॉ यूनिवर्सिटी, और आरजीएनएलयू पटियाला है, और एनएलएसआईयू बेंगलोर जो वैसे ही बहुत ज़्यादा प्रोमिनेंट है और बहुत ज़्यादा फेमस यूनिवर्सिटी है। वहाँ से यही आया है कि इसको रिमूव करना चाहिए। आई थिंक मैम जजेस जो है यहाँ पे आ गए हैं, बेंच हमारी स्टार्ट हो रही है, सो लेट्स सी क्या होने वाला है।
डेफिनेटली मैं अपने व्यूअर्स को ये बताना चाहती हूँ कि आप जो स्क्रीन पे लाइव प्रोसीडिंग देख रहे हैं उसमें जो कुछ भी होगा हम आपको यहाँ पे बताएंगे कि क्या हो रहा है, क्या कहा जा रहा है, क्या किस रुख पे मुड़ रही है हमारा ही
compilation of the
जजमेंट।
suggestions
सो
of
करण
various
सर,
high courts and
जी
law universities. I've circulated it. I've also
जी मैम,
kept printed sets ready for your lordships. Printed sets ready for your
so this
lordships.
is
So
live
just
from
quickly
the
have a look at
Supreme
it. I'll
Court.
just indicate what they are saying very broadly first, And then, my lord, I'll take your lordship through it. And then, my lord, with your lordship permission, I've made a few suggestions, because what fell from your lordship last time was that we have to certainly look at two categories. One is women, which my lord had put to me, and secondly, also, my lord, the specially abled people to some candidates to some extent. So I've tried to make my suggestions on that. My lord, if your lordship has this note, my lord, the first part of it, which starts at page 1 onwards, deals with what the various high courts are saying from page 1 to 7. Now, very broadly, my lord, the high courts are of the view that 3 years should remain. Very broadly, they're of the view. And then they are also, of course, saying that so far as, my lord, the specially abled candidates are concerned, there should be some, maybe not leeway in terms of 3 years, but accessibility, etc., can be given to them, better accessibility and so on. That is what the high courts are saying. If I may very quickly take your lordship through what the high courts are saying. Page 1, my lord, is the Allahabad High Court. Here, my lord, the Allahabad High Court's view is, in fact, it's on bold. I put it in bold. Presently unable, my lord, where it says High Court is presently unable to offer a definitive opinion. My lord, page 1 of this note.
I'll tell you what
I'm
the
very sorry, my lord.
advocate is saying
It's
here.
at, there's
As
an
Karan sir
index, and
rightly
then, my
said,
lord, there's a
ki
suggestions made by
many
various
high
high
courts
courts
are of the view that
in a table
3-year practice should continue. और
right
जो
at the
हमारी
beginning of the
कैटेगरी है
notebook.
उनको और
The
accessibility
third
देनी
page.
चाहिए, उनको और
It's
facility देनी
page number
चाहिए
1 though.
with respect to
So, my lord, I'll only
PWP
read, my lord,
category.
the highlighted portion. High Court is presently unable to offer a
Karan sir,
definitive
your voice is
opinion
not
on the
audible.
reducing or dispensing with condition of 3 years practice at the bar. High Court defers to wisdom of the Supreme Court on the...
escape route, right?
No, that is because, my lord, they are saying that it's too early for us to come to a view.
Too early because
Yes,
get to experience the difficulty.
it has just happened in 25, so therefore that's the view taken. Correct. That's what I'm saying. Now, my lord, Delhi, on the other hand, which is the next page, my lord. Here, if your lordship would just see, I'm not reading the whole of it. There is
इलाहाबाद
a, my
हाई
lord,
कोर्ट का ये
para
कहना
which
है
says
कि अभी
para
बहुत
6
जल्दी
page
है
3.
हमारा कोई
So
भी
this
व्यू
is what
लेने
the
के
High
लिए
Court's
इस
affidavit at
पॉइंट
para
पे
6
3 साल
page
के
3
प्रैक्टिस
says,
रूल पे.
accordingly, the matter was placed before Rules Committee of High Court of Delhi, which considered the matter. Below the next page. Below, having placed Allahabad now, below the next is Chhattisgarh. Chhattisgarh is only saying eligibility conditions should be uniform for all categories of candidates.
Chhattisgarh
That's number
High
2.
Court says that the
Delhi, which is number 3, my lord,
criteria should
I'm
be
placing before your lordship para 6
for
page
everyone
3, which
same.
is in the middle of the second column. Accordingly, matter was placed before Rules Committee of High Court of Delhi, which considered the matter in detail. It was noted that 3 years practice had been reintroduced as per the judgment directions of the Honorable Supreme Court, vide judgment dated 20th May 25 and so and so. It was also noted that 3 years practice at the bar was a mandatory eligibility condition for becoming eligible to appear in examination of Civil Judge Junior Division, which had to be met by all the candidates. Committee was of the view that providing relaxation in the mandatory eligibility condition to a particular class of persons may lead to disparity or discrimination to other candidates. Similar claims will be put forward by other categories of candidates. It would be appropriate that uniformity in the mandatory eligibility condition may be maintained in order to avoid any disparity or discrimination. The aforesaid view of the Rules Committee was duly approved by the Chief Justice of the High Court of Delhi. Then, my lord, 4 is Guwahati. And Guwahati essentially is saying
दिल्ली हाई कोर्ट का भी ये
that 3
कहना
years
है
should
कि
be kept
हमें जो है
and
कोई भी
uniformity should be
डिस्क्रिमिनेशन नहीं करना
maintained.
चाहिए,
So I'll
यूनिफॉर्म
just
रूल लेके आना
summarize that
चाहिए
in one line.
एलिजिबिलिटी का.
My lord, Jammu and Kashmir, my lord, which is number 5. If your lordship would turn over the page to page 4 of this note.
The High Court will say that we understand. That.
Yes, so your lordships have understood that.
Say that Supreme Court is wrong.
No, I'm not saying that.
Very practical.
No, nobody, my lord. No, nobody is saying that, but
what does the university say?
So for that, with your lordship straight away come to page number 8.
Page number?
8 of this very note. Now here, my lord, there are various views taken by various people, so there's no uniformity here, of course, except what they want. Now, yes, I'm coming to that. I'll show that.
Faizan Milord has come out with a very comprehensive suggestion of a probation for 1 year, Milord. As part of the Micah's observations, what also...
Okay, but we are only on the modalities part. Let's come out with some...
Of course, because we have your lordship, possibly...
Before I say that, these high courts, in fact, had earlier also said 3 years. It's not that, my lord, for the first time the high courts are saying 3 years. In fact, your lordship's judgment is based on the views of the high court of 3 years, not that it was based on any other empirical data. My lord, if you come to a page...
No other view taken, excepting for the high courts, and that also in a limited way, my lord.
I'm reading all of them.
The students, the graduates, the aspirants, not one of the stakeholders has been taken into consideration, my lords.
And the NLUIs are generally against the 3-year rule.
Lord, out of the 17 NLUs, the 14 are in against the 3 years rule, Your Lordships.
So any university also supporting the 3-year condition?
Yes, some of them are supporting 3 years. Some are, in fact, even one has, in fact, said it should be 5 years. That your lordships may not take very seriously. But some are supporting 3 years. Many of them are saying 3 years with accessibility. Many are saying reduce it. Some are saying reduce it from 3 years to 2 years or 1.5 years. Some are saying that also. And what my learned friend just mentioned, I should immediately place is serial number 4, which is Chanakya National Law University through Dr. Faizan Mustafa. He says that you should not have any experience at all. And then, my lord, you should do away with the.
So that the training period for civil judge be increased to 2 years with 1 year training in Judicial Academy and 6-month attachment with district.
That is what he is saying.
6-month attachment Chamber of a Senior Advocate. So they are giving a substituted
views.
Alternative option.
Correct. Absolutely. Now for then, my lord.
Your lordships, you get recruited, then after that you go for the 1-year training, intensive training. So
Now-
the same thing for the ladies, your lordship, especially because of their childbearing age, and there are many other factors which are.
Let the person make a complete yes.
See his suggestions because they are excellent suggestions.
So, my lord, serial number 4 is since I'll mention it. There's no problem at all. Dr. Faizan Mustafa's suggestions are, my lord, in fact, they are set out that the summary of it is at the bottom of page 10. So he's suggesting that there should be comprehensive data collection till the aforesaid data is collected and presented before this court. This court may kindly put the 3-year rule in abeyance, as many law graduates who graduated till the academic expectation of being eligible to write judicial services session have legitimate 24-25 have legitimate expectation this should be. In fact, ideally all law students admitted to a law course till 2025 are to be exempted from the 3-year rule, as they would not have joined law if the option of writing judicial services after graduation was not available to them. Sudden imposition of 3-year rule is neither just nor fair. But he's one of the few people who's saying it should be totally done away with. For instance, the next one, Christ Law College, is saying it should be continued. 3 years should be continued. Similarly, Dr. Babasaheb Ambedkar School of Law also says it should be continued. Similarly, my lord, Hidayatullah National Law University, Raipur said you can have some relaxation for specially able candidates, but don't do away with it totally.
One of the law university has said that it has affected candidates from marginalized and economically weaker sections, socially and educationally backward communities, as well as women candidates.
Right. Your lordships are reading which particular? I'll just open that. I'm sorry. Yes, correct. Right, absolutely. So, and then, my lord, there's also a suggestion by Ms. Jaina Kothari, senior advocate, which is page 13 is the summary of that, where she says.
Bangalore says 3-year practice is not required at all. 3-year, they say organizing the,
NLUs.
Sir, you're not audible.
Yes, I hope I'm audible.
Now you're audible, sir.
अभी जो पॉइंट्स रेज किए गए हैं वो उसी को कंसीडर किया जा रहा है कि जो डॉक्टर प्रोफेसर फैजन मुस्तफ़ा हैं, वाइस चांसलर हैं CNLU के, जिनके बारे में भी कल हमने डिस्कशन किया था कि ये चाहते हैं कि इसको टोटली कंप्लीट वो रिमूव कर देना चाहिए. और ये भी पॉइंट आउट किया गया है कि जो मैक्सिमम NLUs हैं, आउट ऑफ 17 में से 14 NLUs इसके अगेंस्ट है, चाह रहे हैं कि रिमूव कर दीजिए. बट जो हमारे काउंसिल हैं दूसरे वो अपोज कर रहे हैं कि भाई हाई कोर्ट तो कह रहे हैं कि होना चाहिए. लेट्स सी क्या हो रहा है, अभी इंटरनल डिस्कशन हो रहा है, राइट? इसलिए आपको वॉइस नहीं आ रही होगी ऑनरेबल सुप्रीम कोर्ट से. यस, लेट्स सी क्या होता है. बट जो कल भी हम डिस्कस कर रहे थे, फैजान सर जो हैं, फैजान मुस्तफ़ा सर जो हैं, उनके जो सजेशंस हैं उनको कहीं ना कहीं कंसिडर किया जा रहा है. और उनकी इस बात को भी यहाँ पे मेंशन किया गया है कि फैजान मुस्तफ़ा सर ने कहा कि डाटा आप लोग कलेक्ट करें, और जब तक डाटा कलेक्ट नहीं होता इसके ऊपर स्टे लगा दीजिए. और लास्ट पॉइंट उन्होंने ये भी मेंशन किया है कि जिन बच्चों ने 2025 में एडमिशन लिया है इस जजमेंट के आने से पहले, तब तक वो जो बच्चे उनको जो है अलाउ किया जाए, वो उनके ऊपर 3 ईयर का रूल जो है लागू ना हो। लेट्स सी क्या होता है, इंटरनल डिस्कशन चल रहा है। मैम कुछ आप पॉइंट शेयर
आई
करना
बिलीव
चाहेंगे?
सर, करण सर, मुझे लगता है कि फैजान सर ने बहुत अच्छी बात बोली है कि जिन्होंने अभी एडमिशन लिया है उन पे ये रूल लागू नहीं होना चाहिए। बट वेर एज वी कैन, एज वी हैव हर्ड, जो प्रोसीडिंग हुई उसमें हमने सुना कि एनएलयूज अगेंस्ट हैं। बहुत सारे एनएलयूज कहते हैं कि हमें रिलैक्सेशन जो है वो किसी को नहीं देना चाहिए, सिर्फ कैटेगरी को देना चाहिए। और बहुत सारे एनएलयूज का ये कहना है कि हमें इस रूल को लागू रखना चाहिए। देन ये जो डिस्कशन अब सारा हवाले है बेंच के।
जी जी बिल्कुल, बेंच के हवाले है मैम। और जैसा हम देख पा रहे हैं, बहुत गहन जो है विचार विमर्श किया जा रहा है। सीजीआई साहब जो है डायरेक्टली डिस्कशन कर रहे हैं और काफी टाइम ले रहे हैं। लास्ट टाइम भी इन्होंने काफी टाइम लिया था। सो बहुत कंसर्न शो कर रहे हैं और कहीं ना
मुझे
कहीं जो है
उम्मीद है सर कि कुछ तो हमारे हित में सोचेंगे और हमारे
डेफिनेटली
हित में
डेफिनेटली।
फैसला आएगा।
सो जैसे ही सुप्रीम कोर्ट से कुछ स्टार्ट होता है तो आपको स्क्रीन के ऊपर शो होगा डेफिनेटली। वी आर
हाँ,
नॉट
डोंट
इंटरप्टिंग बेटा,
वरी।
वी आर नॉट इंटरप्टिंग। एक्चुअली वहां पे म्यूट हुआ है क्योंकि जजेस आर डिस्कसिंग, राइट? इसलिए आप लोगों को वॉइस नहीं आ रही है सुप्रीम कोर्ट की।
हाँ, दैट इज ट्रू। अभी डिस्कशन चल रहा है तो वहां से म्यूट है, तो डू नॉट वरी एंड स्टे ट्यून। ओके, स्टे ट्यून टू द सेशन। अभी ही पता चलेगा कि क्या हुआ है।
यस यस, डेफिनेटली पॉजिटिव आएगा क्योंकि आप देखिए डिस्कशन बहुत लंबा चल रहा है। ऑलमोस्ट 1-2 मिनट हो गया है जजेस को डिस्कस करते हुए।
यस, होपफुली सर, फिंगर्स क्रॉस कि कुछ तो जो है हमारे हित में कहने वाले हैं सीजीआई
लेट्स
साहब
सी
अब।
मैम, आज मुझे लग रहा है फाइनल हो ही जाएगा क्योंकि जो सीजेआई साहब है वो भी इसी मूड में है कि इसको फाइनल करो यार।
दैट्स ट्रू सर, दैट्स ट्रू। इनफैक्ट सर, अब तो मेरी दिल की धड़कनें बहुत तेज
मैम
बढ़ गई हैं।
मेरे खुद स्टूडेंट्स, क्या लग रहा है आप लोगों को, धक धक हो रहा है क्या? अभी आप लोगों
बहुत
ने सबने
ज्यादा।
सुना है कि क्या था?
आई एम स्किपिंग माई हार्ट बीट, आई बिलीव, बिकॉज सीइंग दिस लाइव प्रोसीडिंग आई विल बी लाइक कि प्लीज जज साहब
क्या
हमारे
क्या
हित
क्या
में।
क्या कहना चाहते हो बच्चों? जितने भी बच्चे अभी लाइव जुड़े हुए हैं, आप लोग क्या समझ रहे हैं, जो देख पा रहे हैं उससे क्या नजर आ रहा है कि कुछ हमारे फेवर में आने वाला है या नहीं आने वाला? एवरीवन इन दी लाइव, यस यस यस, फिंगर क्लोज्ड। प्रे प्रे करो भाई, प्रार्थना करो कि जो है डिसीजन आए और हमारे फेवर में आए। मैं मैं बड़ा नर्वस हो रहा हूँ सीरियसली।
मैं सर, टू बी ऑनेस्ट, आई एम नर्वस। मुझे गूजबम्स आ रहे हैं कि भाई अब होगा क्या। बिकॉज ये जो वो पल है, जो पल कहीं ना कहीं हम सबको या तो खुश करेगा या बहुत दुखी करेगा।
डेफिनेटली डेफिनेटली मैम। इतना नर्वस कभी मैं अपना रिजल्ट देखने के टाइम पे नहीं हुआ हूँ जितना मैं आज नर्वस हो रहा हूँ इस चीज को
मुझे
देख के।
ऐसा लग रहा है कि ये सेम फीलिंग है व्हेन आई वाज वेटिंग फॉर माय इंटरव्यू रिजल्ट। क्योंकि मुझे लग रहा है कि भाई क्या होने वाला है, हाँ या ना, हाँ या ना, हाँ या ना। कम ऑन स्टूडेंट्स, जल्दी जल्दी बताओ, हाँ या ना, हाँ या ना। हटा दो
यस
प्लीज, हटा
एवरीवन,
दो।
यस, हाँ या ना, क्या क्या होगा? लेट्स सी आप
हमारी
लोग क्या गेस कर
आवाज
पाते
पहुंच
हैं।
जाए सीजीआई साहब के पास। इसको कृपया करके हटा दें, ये हमारे बच्चों का सवाल है।
मैं चाहता हूँ कि स्टे भी लगा दो, कोई प्रॉब्लम नहीं, 5 साल के लिए स्टे कर दो, कोई इशू नहीं है।
हाँ सर, बिल्कुल सही बात है। अभी
जो
जिन्होंने
फैजन
एडमिशन लिया है
मुस्तफा सर
उनका।
ने जो है सजेशन रेज किया उनको भी कंसीडर कर लेंगे तो भी बहुत अच्छा हो जाएगा मैम, हर एक स्टूडेंट के लिए।
आई बिलीव
नहीं
सर
नहीं,
कि फैजान
फैजन
सर।
फैजान मुस्तफा सर जो है वो सीएनएलयू के वाइस चांसलर है, डॉक्टर प्रोफेसर डॉक्टर फैजन मुस्तफा। ही इज ए
यस
वेरी प्रोमिनेंट जूरिस्ट, राइट? आप लोग उनको सुन सकते हैं, फैजन मुस्तफा सर है। अच्छा मैम,
सर, मैं
सारे बच्चे कह रहे हैं
अच्छे
कि
से
हटा
उन्हें
दो हटा दो
जानती हूँ
हटा दो।
क्योंकि मैं एएमयू से पढ़ी हूँ।
अरे
तो
मैम आप बिल्कुल जानते भी हैं उनको डेफिनेटली।
तो मैं तो चाहती हूँ कि सर की बात को जो है कंसिडर किया जाए सीजीआई साहब द्वारा।
क्योंकि मैम उनसे बेहतर कोई नहीं समझ सकता इस चीज को, उन्होंने पढ़ाया भी, एस्पिरेंट के साथ भी रहे हैं, राइट?
ट्रू ट्रू सर, ट्रू। मुझे
रिमूव
उम्मीद
रिमूव
है कि
रिमूव।
सीजीआई साहब जो है वो फैजान सर की बात को कंसिडर करेंगे और थोड़े से कंसिडरेट होंगे हमारे सारे एस्पिरेंट्स के लिए और उनके व्यू पॉइंट के साथ।
चलिए मैम, बच्चे तो
ओके,
यही करें कि हटा दो यार, हम भी जज
सब
बन गए।
एवरीवन इज सेइंग हटा दो प्लीज, रिमूव कर दो, रिमूव कर दो। ओके, प्रे गाइस, प्रे, कम ऑन, प्रे, दिस इज द टाइम, कम ऑन।
फिंगर क्रॉस मैम। सी देखिए कितना टाइम लिया जा रहा है, ये आपस में डिस्कशन चल रहा है तो मतलब कुछ ना कुछ बड़ा होने वाला है, राइट? जो
होने वाला
सुनना
है,
था
वाला है
समझना था
सर।
समझ
मैं
लिया
बहुत
सुन
ज्यादा
लिया।
पॉजिटिव होपफुल हूँ कि कुछ ना कुछ
एग्जैक्टली
अच्छा होगा।
अब आप देखिए सीजीआई साहब कितने टाइम से जो है डिस्कस करें, आई थिंक मैम 3-4 मिनट हो गई हैं जो इंटरनल डिस्कशन चल रहा है जजेस के बीच में।
ट्रू 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 सर, ट्रू।
मैम आपको क्या लगता है, मैं आपसे पूछना चाहता हूँ, क्या लगता है मैम, रिमूव होगा या नहीं होगा?
सर
से
मुझे
यस
ऐसा
और नो,
लगता है
जस्ट
कि
से यस और नो।
होगा, होगा, रिमूव होगा सर,
होगा
होगा, बिल्कुल
डेफिनेटली,
होगा।
मुझे भी यही लग रहा है मैम,
बिल्कुल
रिमूव
होगा
होगा।
सर।
बिल्कुल बिल्कुल बिल्कुल।
हटा के रहेंगे सर, हटा के रहेंगे।
क्योंकि मैम इतना इतना टाइम तभी इन्वेस्ट किया जाता है जब कुछ बड़ा डिसीजन देना
बड़ा
होता है।
डिसीजन आ जाता है, राइट राइट, आई टोटली एग्री विद यू सर।
क्योंकि मैम ट्रायल में प्रैक्टिस हमने भी की है, जज साहब कुछ सोच रहे होते हैं तो मतलब कुछ पॉजिटिव आने वाला है।
बिल्कुल बिल्कुल हमारे हित में आएगा
क्योंकि
और
अगर
मुझे
अगेंस्ट
पूरी
होता तो
उम्मीद है।
प्राइमर फैसाइली कह देते कि भाई हाई कोर्ट ने कहा है होना चाहिए जाओ, इतना टाइम नहीं देते मैम।
ट्रू।
भाई अब तो टेंशन हो रही है, क्या लग रहा है
बहुत
बच्चों?
ज्यादा सर, बहुत। आई एम गेटिंग नर्वस।
बस ऐसा लग रहा है कि अब फेंट होने वाले हैं।
मुझे तो सर बस उस आवाज का इंतजार है जो सुप्रीम कोर्ट की तरफ से अभी आने वाली है।
वेरी वेरी डिफिकल्ट सिचुएशन मैम, टू द स्टूडेंट्स एंड टू अस आल्सो। बहुत डिफिकल्ट सिचुएशन में हम आन खड़े हुए हैं आज।
ट्रू सर, ट्रू।
बच्चों
एवरीवन इज
कमेंट करते
सेइंग।
रहो, कमेंट करते रहो, हमें तुम्हारे साथ की जरूरत है और तुम्हें हमारे साथ की जरूरत है, और हम आगे
Milords,
आगे
the
आगे।
whole issue, Milords, is not what we are envisioning, Milords, is the improvement of the system, Milords, the judicial and the justice delivery system. We don't want to put a roadblock, Milords, in their actual appointment or to take them away from the profession. Milords, we are encouraging everybody to go into the judiciary, Milords, to say it's a very good line to be in, Milords, and to go away from other practices also. Have this as an avenue. So then, Milords, to have a roadblock by putting in practice which is not even consistent with their roles as adjudicators, Milords. As adjudicators, the skills, Milords, subject to correction, Milords, would be honing some other skills in addition to the practice ones, Milords. So to have such a thing, Milords, is a roadblock A. Career progression itself, Milords, is put a roadblock to, because, Milords, what will be an average age will become of an aspirant to be about 29 years, Milords, once he graduates, another 3 years of practice, and thereafter, Milords, to go into the higher judiciary as an average ladder chart, Milords, is coming for, I'm sorry, Milords?
Say 29.
Milords, I say with 3 years practice, Milords.
23, 26.
Plus 23, Milords.
26.
That was plus 3, plus it takes couple of years for people to prepare, Milords. People don't prepare overnight.
Average age is 24 plus now.
Let's take it exactly, Milords. So roughly about, let's 28 to 29, I'll put it, Milords, another way. But it comes that. That means, Milords, with promotions to the high judiciary, Milords, it would come to about 41, Milords, years of age.
6 years, a meritorious candidate.
Now your lordship.
7 years, you can apply
Milords,
for that.
that is the direct promotion from the bar, Milords, but otherwise from
No.
promotion base. Yes. Yes.
You are not aware of the recent
Suitability.
Constitution Bench decision. Constitution Bench or 3 judges?
No, 3 judges said that even for civil judge junior to senior, you can have a suitability test.
So for fast track in 3 years,
Yes.
that is 32.
That's
Then
fast track.
again a fast track in 3 years.
Yes.
That is 35. But then we said 7 years total.
Yes.
In the lower judiciary and the civil division and also the what do you call the senior division.
Yes.
Then both together 7 years. 29, 35, 36.
Milords, that's, I believe,
Not even
50%.
29.
I believe that's 50%. Milords, 50% would possibly be, Milords, the other age.
Higher judicial service cadre is not a serious problem.
Yes.
That is at the right age, they are taken care. The only issue is of the lateral.
Entry level, Milords. And then you add in, Milords, 1 or 2 years of preparatory work. These exams, Milords, take approximately from what we
That is
understand.
the whole difficulty, senior counsel.
Yes.
When I sat in the Constitution bench also, I said, now the source is the coaching centers.
Exactly.
I don't mind saying that.
Yes.
The open court.
By all means, Milords.
That is the entire problem. I have been a chief justice. I have been a senior judge in the court. I've gone through interviews. We have seen the direct district judges. It's not, don't say that without any empirical formula. From our experience, we are telling you.
No, Milords, that's true. I was only adding to say, Milords, it's possible to do it, as we discussed, Milords, on the last occasion, by other curated measures. For example, Milords, MNLU, Maharashtra National Law University, Milords, has an honors program in adjudication and litigation, Milords. It goes towards justice and specifically towards this program. For example, Milords, your Lordship, my learned friend
As
also
a
mentioned.
lawyer, you will definitely say that you get more training inside the courts than in classroom.
Milords, I'm saying so, but add that. Milords, first you have a course. There should be internships, Milords. My Lord only suggested, my Lord the Chief Justice, was on the last occasion, have a actual practical experience built into the law schools itself, Milords, which is mandatory. No, this internship, but practice as in practice, Milords, within the period.
After visiting at least 16, 17 top national law schools, these all children, bright children, they will go to corporate entity because of this condition.
Yes, yes.
Yes, Your Lordship.
That's a problem, Milords. And women, Milords?
Should have been imposed in phased manner.
Yes.
The first year it should have been 1 year, next then 2 years, then 3 years. That is the way when court imposed, court creative law is made applicable, that is the past practice is also.
That's right.
We have unfortunately thrusted upon directly, because of that there is a lot of hue and cry in the all top law schools.
Yes.
The children are not going to wait for 3 years to waste their time. They are the children who have competed through written exam, through competitive test,
Yes.
a test which is now more vigorous than the NEET or than the medical, and they have got admission as per their merits. Parents have spent a lot of money. Now they are not in a position to wait. That is the crisis we are facing.
That is one in women.
How to balance both?
Plus women also, my
But at the same time, we have in judicial, we all have been at least sitting here now. I have the largest experience in, as a judge, as a chief justice, and then in Supreme Court. I have been chairman of the Junior Division Selection Committee. I have been chairperson of the Superior Judicial Service Committee. Augustine, my brother, knows, he has been with me in the Selection Committee. So
there's a training course, my lord.
We want that slight mature persons come in judicial services. That is also a predicament.
Well, let's have it after the selected. Have it after the selected, my lord.
May I
That is a
request
process that can be in
Yes,
May I say one thing?
We can have a period of 2
Just
years
give me
of
2
training,
minutes.
Your Lordships.
I have circulated, my lord. Please stand, my lord.
That's right.
I have to ask, but my lord, on a serious note, in fact, I should say the moment I circulated this chart, because 3-4 days back, even before anyone read it, it was on the social media. So today I am giving this suggestion to your lordships, and only recent 1 hour ago I've given it to the other side. So that, my lord, it's not that this should be first appear there and then before your lordship. My lord, may I just read these suggestions, and if your lordship feel any of them are worthy, your lordship will consider it. My lord, suggestion 1 is retention of the rule without modification. And I'm just reading it, my lord. The first option is retention of the rule in its current form without modification based on the institutional experience recorded by several high courts. In this regard, 7 out of 12 high courts have submitted affidavits, etc. that your lordships have seen. Now, my lord, para 3. Requirement of 3 years practice at the bar mandated in so and so operates as a condition of eligibility for entry into judicial service and therefore ought to remain uniform across categories. However, considerations relating to suitability of candidates such as evaluation benchmarks, i.e. cut-off marks, examination modalities, or other aspects of recruitment process may permit calibrated accommodations consistent with the objectives of the Rights of Persons with Disabilities Act and gender inclusion. This would also include providing infrastructural amenities in court complexes, particularly for persons with disabilities. High Court of Jammu Kashmir, your lordships have seen, I'm not reading it. My lord, now please come to suggestion 2. Relaxation only for women and persons with disabilities. It is submitted if relaxation in 3 years practice rule is to be granted to any categories of candidates, it should be restricted to women and persons with disabilities. It is submitted that uniformity in eligibility conditions should be retained, as the number of categories who may otherwise claim exemptions and relaxations would be beyond enumeration. While relaxations for age, number of attempts, or cut-off marks may be granted, as regards eligibility of 3 years experience at the bar, it is submitted that these 2 categories may be permitted to complete the requirement of 3 years experience at the bar either prior to or subsequent to clearing civil judge examination. However, quantum of 3 years may be in terms of so on. So I'm saying, my lord, your lordships may permit them to take the examination if they, yes.
This condition is slightly impractical.
Very well, my lord. I'll just.
Very good substitute for it.
Anyway, I'm reading it. Yes.
We can't send a selected judicial officer to bar.
Yes, Your
That is not.
Yes, Your Lordships.
Very well.
What we can do is that in the judicial academy, yes, there can be 6 months training only for practice.
Yes, Your Lordships.
My lord, may I read para 6? It is submitted that in case such relaxation is granted to women and persons with disabilities, they may allowed to, so this your lordship is saying is not very practical, to sit for civil judge junior division examination as a fresh graduates or as candidates having less than 3 years experience. However, after clearing the examination, they will be mandatory.
Suggesting the best way out.
Yes.
If not in this matter, I will, at least before the meeting office, I will do it.
Right.
All these officers should be attached as law clerks with the sitting judges.
District judge.
District judge.
Correct. Absolutely.
With all district judges, with all high court judges, and in Supreme Court.
Yes, Your Lordships.
That is the best way to teach them.
That will suffice.
That is a proposal made also for the Center for Research.
So that. Yes. My lord, that is in fact contained in suggestion 4, but anyway.
Your Lordships, before.
Just one second, let's just be finished this.
माहौल थोड़ा सा गर्मा गया है ना, और सीजीआई साहब जो है कन्विंस नहीं हो रहे हैं, जो एमिकस क्यूरी जो है यहाँ पे सजेशंस दे रहे हैं उनको लेके जो है कन्विक्शन नहीं शो कर रहे हैं सीजीआई साहब, क्योंकि वो कह रहे हैं रिटेन करो रूल को, इलेक्शन से वुमेन एंड डिसेबल पर्संस को दो, लेकिन अभी देखते हैं क्या होने वाला है। देखिए
हाँ, अभी दोबारा से डिस्कशन शुरू हो रहा है, आपस में डिस्कस करें सीजीआई साहब की जो ये
क्योंकि
बातें कही गई
मैम
हैं।
सीजीआई साहब ने जो पॉइंट रेज किया बहुत जेन्युइन पॉइंट है कि जो एनएलयू में स्टूडेंट जा रहा है बहुत ब्राइट है, बहुत टैलेंटेड स्टूडेंट है, बिकॉज ऑफ दिस 3 ईयर रूल वो सिर्फ कॉर्पोरेट में चला जाएगा, फिर जुडिशरी में नहीं आ पाएंगे अच्छे बच्चे।
डेफिनेटली सर। और
Yes, yes,
एक
yes.
बात ये भी कही गई थी कि इंटर्नशिप हम कर सकते हैं।
MBA and she comes from Guwahati, your lordships. She sat for Guwahati examination in 24, your lordships. She couldn't take the mains. Now she came here. Now she's rejected.
Just let me finish it. Suggestion.
My lord, I'm just placing it so that your lordships may either accept. My lord, so I've read para 6. It is submitted that state bar councils may be directed to facilitate or develop a mechanism for helping such candidates in obtaining requisite experience after clearing civil judge examination. Alternatively, for the said 2 categories alone, women and persons with disabilities, practice period requirement may be reduced from 3 to 2 or any other period as this honorable court finds appropriate. That has come in some of the suggestions. Suggestion 3, my lord, is the staggered implementation in the transition period.
Exactly, I was probably.
So I should have perhaps put that at 1, but I'm sorry, it's in serial 3. Very well. I'm sorry, my lord. While retaining the conditions for recruitment as laid down in All India judges, in the transition period of next 3 years, fresh law graduates may be permitted to appear for civil judge JD examination. Candidates who clear the examination shall undergo the requisite training at State Judicial Academy. After transition period of next 3 years, 3-year experience rule may be made mandatory. That is to say, for
3 and 2
yes,
should be mixed together.
Correct.
That you will not be allowed to hold the court.
Yes.
Until you undergo all these courses.
Right, my lord.
And until the district judge or the high court judge with whom they have worked certify that yes, in terms of the demeanor, conduct, knowledge, practical knowledge, the officer is fit for.
So, my lord, these courses the State Judicial Academy can obviously specify, or as your lordship said, law clerkship. Then, my lord, 10. Alternatively, practice period of 3 years prior experience can be 0 years, 1 year and 2 years respectively for aspirants appearing for the examinations in the next 3 years respectively. So this is another aspect of staggering. Both are staggering aspects. Therefore, 3-year practice, thereafter 3-year practice rule may apply uniformly. So as your lordships, if perhaps suggestion 3 meets with your lordship's approval, is I'd put in all the other suggestions also, because I'd had to put in 3-year rule because all the high courts are saying that their experience over the last 23 years is that they want people with some experience. So, my lord, we can't disregard that also, which is why I put that as 1. But this 3 your lordships may see. And 4 is reasonable accommodation, which in any case should follow, my lord. Whatever steps your lordship takes, that there has to be reasonable accommodation for people who are specially able in terms of infrastructure, in terms of accessibility, in terms of perhaps providing them judicial internships, etc. And those are suggestions of 2, my lord, senior and well-known advocates that I put there. In fact,
can I hand over, my lords, just a small suggestion, my lords, 1-page suggestion within this, my lords, with a small compilation, my lords. I'll only refer to 1 page, my lords. Page 10. I'm not going into, my lords, what the judgment was, my lords, just the suggestions. 4.2, my lords, at page 10. At the bottom of the page, my lords. Post-selection curated training as opposed to license fair practice requirements. Recommended that the practice experience may be incorporated. Page 10. I'm sorry, boss. Para 4.2 at the bottom. It is recommended that the practice experience may be incorporated as part of the training curriculum of selected candidates. Selected. So after that, in the same fashion as the training given to selected IAS candidates at Labasna. This practice experience may be structured in the following manner. Selected candidates undergoing training for civil judge may be attached with district judges for practical training as an apprentice, law clerk, judge in training, whatever your lordship thinks appropriate. In fact, the Center for Research and Planning at the Supreme Court has come out with this report recommending the introduction of LCRAs, that is law clerks, I believe, in district judiciary to further strengthen administration of justice. Selected candidates undergoing training for civil judge may be attached with designated senior counsel, government pleaders, advocate general, standing counsels for a specified period. It is recommended, 4.2.2, it is recommended that certain changes may be made during the law degree at the university level, which provides aspirants with special courses and or experience opportunities which renders them eligible for the examination. The first one, optional structured 6-month practice experience modules during the 3-year/5-year law course. At present, my lords, for example, for the 5-year course, it is 5 months as it stands without specification. The second, my lords, special degree courses designed for aspirants at the college level itself to identify, train and expose aspirants to high quality training fit for purpose. My lords, I was referring to the MNLU course, which is a course, BA LLB honors course for adjudication and judging, my lords, as it's called. And that's, my lords, I think possibly a very popular approach, Milords, because to hone the skills as a judge is possibly slightly different from honing the skills as a counsel, Milords. We take far more liberties, Milords. Your lordships take far lesser, Milords. So to that extent, Milords, and that is the reason, if experience as a judge, Milords, is what is sought, then possibly, Milords, the courses at the initial stages also would be extremely helpful. And Milords, we've been encouraging. We want the younger people, Milords, to go in. Law exams itself, Milords, takes almost a year or two for applying, Milords, for preparing. Secondly, more than one attempt. It is not a single attempt. It's like the AOR examination, Milords. You don't get it on the first attempt necessarily. It goes for 1, 2, 3, whatever the attempts might be. So, Milords, all that period has to be taken into account for purposes of going down the career ladder. So those obstacles, particularly made more vulnerable for women, Milords, is something that has to be, Milords, done away with, and that too, Milords, mid-level. The Constitution mentions these judgments, Milords. Ultimately, we come out, Milords, where people have been waiting for the last 3 years, having tried, not succeeded, or otherwise preparing, not gone in, or possibly not having enough money, going in for coaching, as your lordship said. No, correct. We are all going for coaching in every direction today, even at the school level, Milords, leave aside at a higher level. Be that as it may, not in our times, but that's another story. So, Milords, coming to that, they've been waiting for the last 2, 3 years, Milords, suddenly to make it midstream and say, now you are either out or you're not eligible, Milords, and to put themselves at not, Milords, is something that cannot be done. Finally, Milords, just one last word, Milords. The students, the graduates, have not been taken into account. What has been taken into account in this entire exercise is only, Milords, the high courts, Milords, and now, Milords, the NLUs and other universities, some universities, they've advocated. What about, Milords, management universities, people who are actually involved? Let's let us, some retired judge, Milords, be put in, Milords, control of the situation to see and assess, not control, Milords, I beg your pardon, assess the situation and take all the stakeholders to some extent. In the meantime, Milords, this requires a thing. It cannot be done like this at one level. And if at all, Milords, Bihar exam is down the corner. They come in different, there's no certainty for exams. Every state has its own exams allocated at whatever time. So you don't even know, Milords, what would be ultimately hitting people. They can't just be waiting in the air, Milords, to what will happen. So for the time being, Milords, these are not annual examinations. So your lordships, it happens once in 3 years, Milords. Therefore, Milords, your lordship has to take, Milords, into account for the time being, Milords. To stay this while your lordship considers, Milords, the modalities which might be set in, Milords, something must be done. Understood, Milords. However, what should be done? And within the period, Milords, after selection. My insistence, Milords, is twofold. During the law university stages and, Milords, during the period after selection, which can be whether by way of internship, whether by way of, Milords, training, whether by way of putting in programs anywhere, Milords, that is another matter altogether.
Your lordship.
15 dispensation is required for women, your lordships, for 3 reasons. One, your lordships, is as far as women is concerned, for them, along with their domestic responsibilities, your lordships, for them, when they can take an exam is also not determined. They can take an exam depending on whether at that point of time they are getting married, they are having children and so on. So therefore, the bar acts as something which takes away that entire career opportunity, your lordships. And like your lordships very succinctly put it, your lordships, then they go into different professions whatsoever, and we lose very good and very intelligent people, your lordships, because there's no certainty in this entering the career. So at that entry point, your lordships, when the barrier is there, that is the difficulty which all these girls face, your lordships. Going forward, your lordships, they will definitely be shoulder to shoulder with everyone else. They'll do their suitability test, their career progression, they will appear for all the examinations. There is no difficulty, your lordships. At the entry level itself, when they are put back, your lordships, and that is the crucial time for their lordships, we all have experienced it. That is the time when we are all thinking of setting up families and putting them together, your lordships. If we are set back another 3 years, then your lordships will never be able to move forward in our career. That is facially this appears to be neutral, but substantively it hits us, your lordships. It hits us very, very badly, because none of the young girls, your lordships, are able to, once there is a break, then the family always insists that, all right, now move on to something else. Right after graduating, your lordships, they are taking these exams. They are in that same streamline, your lordships, they can hold back. They can tell their families that this is not the time for me to move on to the other areas, your lordships. So that is a very turbulent time for young girls, your lordships, and that has to be kept in mind, your lordships.
Quickly
because this
telling the
barrier
recent
is what is
joint
hurting us.
viewers कि
And
अब जो
I
है
would
हमारे हित की
definitely
कुछ
say
बात कही जा
that,
रही है। जो लेडी
Dr.
एडवोकेट है
Faizan
उन्होंने बहुत ही शानदार सी एक बात कही है कि
suggestions to
आपको
your
3 साल
lordships
का
with
प्रैक्टिस
regard to
रूल लाना है,
training,
उसको हटा
because
दीजिए।
lordships
अगर रही बात
always has
प्रैक्टिस की, जो
moved
मैंडेटरी
towards
है उसको पोस्ट
inclusivity.
सिलेक्शन
So
कर दीजिए
whatever
ट्रेनिंग में,
allows
कि भैया ट्रेनिंग होगी
people to
सिलेक्शन के
come in
बाद, तब आप अपना
is
ये
what lordships
प्रैक्टिस
wants. The
इंश्योर कर
larger the
लें,
pool,
आपको
the
अच्छे से
better the
प्रैक्टिस आनी
talent we
चाहिए।
will get, your lordship.
यूनिवर्सिटी लेवल पे हम कुछ
So let
इंटर्नशिप
them
मैंडेटरी कर
compete.
सकते हैं कुछ
It's
टाइम
not,
पीरियड के
as my
लिए।
learned
एट द
friend
सेम
said,
टाइम
it's
यहाँ
not
पे
as
कहा
if
जा
they
रहा है
are
महिलाओं के
succeeding
बारे
in the
में कि
first year
उनको
itself.
बहुत ज्यादा
They'll
उन
also
पे
take a
सोसाइटल
couple of
प्रेशर
years
रहता है
to
और कहीं ना
succeed.
कहीं
There'll
उन पे
be
फैमिली
interview,
प्रेशर
there'll
रहता
be
है, जो
written
पिछली बार
tests.
सीजीआई
So
साहब ने
their
कहा था।
suitability
लिसनिंग टू
and
द प्रोसीडिंग नाउ।
excellence is anyway being tested, your lordships. So our respectful submission to your lordships is that for us, the reproductive age is very, very crucial. And that should not be set back because of this professional problem.
Because today,
Your Lordship, we have
100 friends, my lords. At the entry level, my lords, it's the highest for women, my lords. It's a very high level. In fact, it is later retention, which becomes difficult, or escalation, my lords. But at the entry level, the number of women, my lords, in the profession is becoming one of the largest.
Your Lordships, Your Lordships, the
% now there are
That's right.
currently in law.
And it goes down, my lords, as we go ahead. We don't want to give the figures, my lords. Everybody knows them.
What do you say? He wants also.
Yes.
Your Lordships, the submissions that we had made it on the last occasion also, that people with disabilities face 3 kind of barriers. One is the no seniors hire persons with disabilities. One, if we even come up to the 1 year or a 6-month practice period. Second is no client relies on a person with disability and advocate. Third is the structural, infrastructural, and the digital accessibility. Even I would like to quote, your lordships, there was a report by the State of Judiciary report by the Center of Planning and Research by the Supreme Court itself, which says that more than 85% of district court are still not accessible for persons with disabilities. So this is a very important point which needs to be addressed by your lordships. Again, another thing, your lordships, the judgment that we were quoting of the 3rd of March 2025, your lordships, in that there was a judgment regarding an appeal which is titled as Ayush Yardi versus the High Court of Madhya Pradesh. There are certain paragraphs which I quote in paragraph 33 to 41, what the division bench of the Honorable Supreme Court has quoted the views, how it indirectly discriminates people with disabilities, how it also discriminates people with disabilities on the ground of equality doctrine, your lordships. And again, the reasonable accommodation. So the reasonable accommodation principle comes there only. It plays a role there, your lordships. So we are not against the practice. We are saying, your lordships, we are also submitting that we only just want the relaxation in the form that we don't have to run here and there. We just are seeking an accommodation, a reasonable accommodation in form where either we are given an opportunity to, in the law schools, whether it's a 1 year additional to the 3 years, no issues in that, or the training, which is, your lordships, 1 year, can be extended to 2 years. And through that, the young generation lawyers can be placed with the legal aid, which can strengthen our legal aid system also, your lordship. That's the suggestion from our end. And your lordships, we also have compiled a report and submitted before your lordships an additional through an additional affidavit, which was a research kind of we have conducted before after your lordships passed the directions to the NLUs and the high courts on the 15th of January 2026, your lordships. So we conducted two kind of researches. One is with the law students and another is with the law graduates and the enrolled advocates, recent ones. So the highlighting part into that, most of the part of the, whether it's a person with a disability or without disability, everyone is saying this 3 years will anyhow has to be modified or has to be revoked, or it could be in the form of a kind of a mandatory internship or a mandatory law researcher with the attachment in any of the courts, which could suffice and have or give the experience to that law judicial officer, which has to deliver the justice at the end. So, Lordship, those are the submissions from our end. Another thing, your Lordships, at just the last point, we have also moved in IEA, your Lordships, the number is 45820 regarding the Bihar Judicial Services, which has been recently notified, your Lordships. So we are just seeking, your Lordships, if your Lordships appreciate that suggestion, Your Lordships. We're just seeking.
What is
No,
this?
this
This
is
is 18th of March, Your Lordships. So our suggestion is all the candidates, irrespective of the 3 years practice.
Time being, who is representing Bihar High Court, Patna High Court?
no, this is the
Your Lordships,
notification.
the suggestion,
This is the
Your
notification.
Lordship, the suggestion is just that the candidates might be allowed, Your Lordships, provisionally,
Instead of
before we decide, Your Lordships.
maybe creating more complications, we can ask the High Courts and State Police Risk Commission to extend the date.
Yes, Your Lordships.
Meanwhile, we can,
Or the extension can be done, Your Lordships, before Your Lordships decide, or something, a modulation could be there, Your Lordships, which does not impacts the young generation, Your Lordships.
No, this is the notification, my lords, if your lordship wishes.
What is he saying here?
Already come up with an amendment. I think the court is about to come out with an amendment. The lordship, so all the.
Your lordship will have to pass an order, my lords, staying this process, my lords, for the time being. There's no, my lords, other way. Otherwise, they are different dates, my lords.
On 9th of February 26, Delhi High Court has amended its rules.
Yes. You say what? We have. Oh, that is stay.
LLM वाला बताना देते हैं।
So I'm in 301.1.
For Bihar, it is 18th of March in the last date.
My lords, the notification is before your lordship, my lords. Just hand over.
I'm not representing Bihar State, Your Lordship.
I want.
like that may arise, say, since we are seized of the
Right.
matter issues arising out of description of 3 years practice as a precondition for recruitment as judicial officers at the entry level, all the high courts and state police commissions are directed to extend the last date of submission of applications, if they have already advertised the post, up to 30th April 2026. Up to 30th April 2026. The press advertisement that may be issued by any state, High Court or the State Police Commission shall also have a cutoff date, 30th April 2026.
Lordship, for judicial magistrate, it is mostly done by the.
I'm in.
Now we have said both. That's why we said both.
Yes, Lordship.
Yes, High Court or the publicist.
Yes.
My lords, you've handed over the Bihar notification if your lordship wants to, my lords, have.
Now it has to be extended.
Yeah, Your Lordship, just one small submission.
Keep the training.
Mine is
2 साल देना ना, 2 साल तो
336091.
So I'm in 301 point.
IA filed by me for modification and implement. Here concern is acquiring higher qualification. I am a LLM student. I'm just passing out now. And
बताना चाहूंगा बिहार जुडिशरी की डेट एक्सटेंड करने के लिए बोल दिया है और
no, Lordship, with all due respect, it is interlinked. So far as Indian Law Institute, National Law University, Delhi, Rohtak, and many other universities.
He has already.
Just a minute, sir. Just
already approached the High Court.
I approached the High Court. High Court declined to interfere because of the judgment delivered by the Honorable Court, and we were asked to make an application before.
No, you are asking relaxation on the basis of higher qualification.
Your Lordship, what has happened? I am a law LLM student, and it is a bar I cannot practice. So if this embargo of 3 years goes, then ultimately I am on the level playing field, Your Lordship.
Either you have approached the High Court, get the decision from the High Court. If High Court does not accept your claim, you come before us.
That's all.
Your Lordship, the point
And
is, in the meantime, I cannot apply.
Your difficulty is that the period you spend for LLM is not considered as practice.
That's correct, Your Lordship.
The constitution, that bench decision, 3-judge bench decision does not say anything about it. The Bar Council permits it, you go to the High Court.
Your Lordship, the point is, I have to render an affidavit. This will be a false affidavit. I'll be in perjury. That's the point. Why should I mislead any institution? Because, Your Lordship, so far as practice party is concerned, practice party.
Argument, sir, you are dialing wrong number. That's the only thing. You go and argue this point before the High Court. If the High Court
then,
accepts,
then your
High
lordship,
Court doesn't accept.
at this stage, your lordship, I may be permitted to make submissions before the High Court. Then I have more than IEF.
Please go, who is
My-
stopping you?
Your lordship, ultimately the matter is seized by this honorable court. No High Court is going to interfere in. That's quite obvious.
When you will point out to the High Court that on this issue, the Supreme Court judgment is silent and we have not expressed any opinion, we are quite sure the High Court will, High Court, whatever the view High Court may take, but High Court will take a view.
Honorable High Court says, your lordships, this is an academic matter. We are not going to interfere in the academic matter. It is a curriculum defined by the university. And
Let them write it in an order, bring it before us, then.
ultimately, multiplicity of litigation.
Coming to us will be different, then he will come in SL.
Milord, just one small request, Milord. Today, Milord, the advertisements contain the 3-year practice. Milord, it should not be held that that has been given gospel go by, because, your lordship, kindly keep it at abeyance, Milord. It will make far more sense than to, Milord, extend the date.
Today you have given some suggestions, Amicus has also given some suggestions, you have also come. You also revisit, meanwhile, we are also considering it, again next week we will take up.
Very well,
Meanwhile,
very well.
Urgency clause, we have taken care that urgency is not there as of now.
Yes,
My lord,
very
small
well.
indulgence, my lord.
Will your lordship take up,
My lord, I filed a fresh clarification, my lord. My lord, the only point, as my lords were discussing about the age gap, my lord, the 25th of May, the order prescribes a start date for 3-year practice at the day I am enrolled at the bar. My lord, the end date, in the light of the fact that many judicial examinations take 1.5 to 2.5, we have instances where 2.5 years have been taken till the final appointment is done, my lord. In effect, my lord, this will bring that there is 4.5 years of practice from the day I joined.
In prolonging the selection process despite our time-bound direction in Malik Mazhar, that's a different issue, then we will, that aspect we will deal with.
Experience shall be given at a shall be required at a later stage of the examination. For this, my lord, I have filed a fresh clarification that may be listed, my lord.
may
Your
I,
lordship, the practice
lordship,
part is
draw your
required to
lordship's
define
attention to
what will constitute practice.
301.1.
Reason why it should be.
Those issues in Mazhar Malik matter, we are separately monitoring that. There you can apply and you can move an application.
In 301.1, my lord. I want to draw your lordship's attention to 3 things. First is the NLU responses your lordships need to see. I think Amicus covered it partly, but I need to show your lordship. There are 10 NLUs which are very clear in their critique of this 3-year practice rule. I want to read those parts out to your lordship. Second, my lord, I need to read to your lordship the Chanakya University critique and their clear-cut request that this should be kept in abeyance. That's, my lord, authored by Dr. Faizan Mustafa.
That's why
and a very erudite kind of presentation.
pointed out the young man
Yes, ma'am.
that the advertisement is there, and then we can understand that urgency was there. Now we extended that date to 30th April.
Yes.
Not that.
Yes.
So we are also examining you also in the light of today's deliberation and
Yes, sir.
suggestions. Then think of that, what are the modalities? Ultimately, this practice, let's be very clear, the practice condition will have to be there. This is the view taken by a bench, and we should respect that bench. The only issue is the modalities of giving effect to that, number one. Practical difficulties which are right now have arisen or being experienced, how to wriggle out of those, and how smoothly infuse this practical experience into the system, which is for a better qualitative judiciary, which is a very essential component. So that has to be there. So for example, we were just saying that maybe a clerkship with a High Court judge, with a Supreme Court judge is qualitatively better than maybe or may not be. That there's a different perception. Huh? From our side, we might think it's better than practice. From your side, you might think that no practical experience.
Offices.
So these are all aspects we will also consider, you also consider. 3 years should be there, but is it?
It should be structured.
That only as an enrolled an advocate sitting idle in one court or the other and watching the proceeding, will it going to make them eligible, or a platform like
a structured one?
Make them free legal aid counsel. That's a good idea.
Yes.
That's a very good idea. That you 3-year practice means that they have learned something.
Yes.
Not that they have rest of the other wonderful things they have learned, and other than the.
The third point, my lord, I want to make is
Because also after selection, my lords, ultimately your lordship will have to consider that.
We'll circulate one.
the other third point I want to make, my lord, is that, and it's set out in many of the presentations, the massive expansion of judicial academies and judicial trainings in the country, which, my lord, the impugned order doesn't take note of. Now, my lord, across the world, Japan, Germany, and elsewhere, France, the trend is away from practice at the bar and towards very in-depth, very intensive training. And my lord, there are documents on that we want to show your lordship. That is the way to go in terms of training.
We earnestly wish that our judicial officers, high courts and Supreme Court have the same quantity of work as in Japan or in Germany or in other countries.
More than that,
You can also have the luxury of so many things.
That parity is missing. That parity is missing, my lords. I don't think the nature
So the
can be
point I'm
compared.
trying to make, my lord, is that training of judicial officers post-joining is the way to go for India. And I'll show your lordship report after report. Yes.
Understand the value of post-joining.
Yes, my lord.
Capture best of the talent.
Yes, my lord.
It's something like that. You pick up best of the talent, keep it in your kitty, and then you put them training. That is one way of.
Yes.
Other is that for 3 years you abandon them. That unless you go there practice, I'm not going to consider you. And in 3 years, God knows where they will.
Yes.
Also the certification process. It's by anybody.
These are the two. Both institutional interest is the paramount consideration. Nothing
And
else.
it'll be, my lord, interesting to see how many NLUI graduates actually, after the 3-year rule is implemented, how many of them abandon litigation completely? Quite a considerable number. The statistics are there. I want to check. Quite of them abandoned. So you're losing the best brains coming out of NLUI. NLUI was made for that, to make the judiciary rich with.
Those
They're
who
dropping
stayed back,
out of the system.
even in our years, those who stayed back, took the hard way, became very good lawyers, excellent lawyers.
Some, my lord, some.
Many of them.
When you look
many
at,
of them.
my
And
lord,
some
when
of
you
them
look
came
at,
to the bench also.
when you look at, my lord, SC/ST people, they fall out of the system completely.
Completely out
They
of
train to come into the judiciary and they fall
not in
out
this
of the
context at all.
Yes.
That is a different thing. For that, training is conducted by many of the legal service authorities across the country. In Kerala, I know that there is training conducted specifically for scheduled tribes, and now people have come into the judiciary.
But the figures, my lord, are very, very low.
They'll rise.
We have had reservations for
hardly,
so
my
long,
lord,
as the figures improved considerably in the 75 years. So that it will take time.
Well, may I say something? Well, I appear for the Allahabad High Court. While a suggestion has come through that it should be post-appointment that this training takes place, which means 3 years post-appointment. So a person who's being appointed today will start working only 3 years later. So my only concern is, my lord, as the High Court, that it may lead to a vacuum where we may not have enough officers in Civil Judge Junior Division. This has happened in the past in UP, my lord. We had a...
This will happen today. And today what will happen? If you don't pick up the meritorious people,
yes,
God knows in default what kind of officers you will have, then you have a liability for 30 years, 40 years.
No, I agree with that. I'm just saying that this may be borne in mind, that's all.
That
There shouldn't be a vacuum in civil, because junior division then gets promoted to senior division. So it has a cascading effect. I'm just.
No. Once they are in cadre, once they are appointed, then as far as the next senior division part is concerned, wherever they are asked to go for training, that period will be counted.
That's right.
That will not create problem. The only problem is that instead of 1 year,
now it will be 3 years.
1 year mandatory is there.
Yes.
So 2 more years they will be
That's
required.
right. That's right.
That out of 2 years, 1 year can be even a practical training of as presiding judge also. That can also be counted. Probation should start after that. That's also one way of understanding it.
Yes, yes. I'm just saying that this may be just borne in mind while we.
May I mention my IA? This is an IA that I filed on behalf of Milords. I have filed this IA, Milords, with your Lordship's permission, for about 5 law officers, Milords, who are working for a central public sector enterprise. They are working in Milords Power Grid, etc. Milords, these are people who also have their licenses. Now, Milords, under the Delhi Bar Council rules, you don't have to surrender your practice.
So file a separate petition.
That's the constitution bench decision.
Correct. So
not
correct.
Part of this review.
That's right. So my concern today is this, that period of my service, our service, Milords, should also be considered towards the period of training. Which
but this issue we can consider only provided that the bench, 3 judge bench debarred you. This judgment doesn't deal with that.
Constitution bench decided it. 5 bench.
No, he is coming in MA. You are most welcome, provided that the 3-judge bench had done it.
Mullahs,
Not done it.
5-judge bench.
there is a judgment of the Delhi High Court which actually permits that.
Whatever it is, the 5 bench judge did it.
Your IA is dismissed as withdrawn with liberty to have recourse to the appropriate remedy.
I adopt your lordship's submissions on that.
We will come up again maybe after next week or
Very
well.
चलिए जी, जो बड़ी खबर आ रही है सुप्रीम कोर्ट से, नेक्स्ट वीक जो है डेट लगी है हमारी, तो आज से अगला हफ्ता देख लीजिए, 20 मार्च को जो है नेक्स्ट हियरिंग होने जा रही है। बट कुछ चीजें जो है यहाँ पे हमारे लिए आई है। श्रीमी मैम क्या कहना चाहेंगे, क्योंकि पोस्ट सिलेक्शन ट्रेनिंग के ऊपर थोड़ा सा ज्यादा जोर दिया जा रहा है, और सीजीआई साहब ने ये भी कहा कि 3 साल की प्रैक्टिस तो रखेंगे हम लोग, लेकिन चांसेस ये है कि वो सिलेक्शन के बाद हो जुडिशियल ट्रेनिंग वगैरह। यस मैम।
डेफिनेटली सर, जो मैं सीजीआई साहब की बात से समझ पाई वो ये समझ पाई कि कहीं ना कहीं रुख जो है वो है पोस्ट सिलेक्शन ट्रेनिंग का, और पोस्ट सिलेक्शन ट्रेनिंग में भी 1 साल की तो ट्रेनिंग होती ही है अभी के टाइम पे, और 1 साल एज अ प्रिसाइडिंग जज प्रोबेशन पीरियड स्टार्ट होने से पहले उनकी ट्रेनिंग होनी चाहिए, ऐसा सीजीआई साहब का मानना है। इतना ही नहीं, यहाँ पे बहुत अच्छी अच्छी बातें कही गई, स्पेशली बाय द लेडी एडवोकेट। उन्होंने बहुत ही शानदार तरीके से पॉइंट्स रखे थे कि भाई हम जो है यूनिवर्सिटी लेवल पे ऐसा कुछ करिकुलम कर सकते हैं, इंटर्नशिप मैंडेटरी कर सकते हैं कुछ सर्टेन पीरियड ऑफ टाइम के लिए, जिससे हम स्टूडेंट्स को एक कोर्ट रूम एक्सपीरियंस दिला पाए या उनको जो है बार का एक्सपीरियंस हो पाए, राइट। सो सर, मैंने देखा यहाँ पे कि बिहार जुडिशरी का मुद्दा भी उठाया गया, और बिहार जुडिशरी की जो डेट है एग्जाम की, जो डेट है उसको बेसिकली एक्सटेंड कर दिया गया है 30 अप्रैल तक। I believe it is for form filling, right, sir?
Yes, ma'am. Yes, ma'am. 30 अप्रैल तक बिहार जुडिशरी की डेट एक्सटेंड कर दी गई है, और रीजन यही है कि जो फ्रेश लोग ग्रेजुएट्स हैं उनको भी अलाउ किया जाए, और ये एक्सटेंड इसलिए किया है क्योंकि नेक्स्ट वीक जो है सीजीआई साहब पूरे माइंडसेट के साथ आएंगे, जजमेंट देने वाले हैं। उन्होंने सारे सजेशंस जो है कंसीडर किए हैं, एमिकस क्यूरी की भी किए हैं, और हमारी को जो रिप्रेजेंट कर रहे थे एडवोकेट, और जो बहुत बखूबी उन्होंने रिप्रेजेंट किया है। कुछ पॉइंट्स है मैम जो मैंने नोट डाउन किए हैं जो सीजीआई साहब मेंशन कर रहे थे। सो पॉइंट्स ये हैं, पहला, बिहार जुडिशरी की डेट एक्सटेंड कर दी गई है 30 अप्रैल, राइट। रिविजिट करेंगे, नेक्स्ट वीक की हियरिंग लगाई है, और प्रैक्टिस जो है रहेगी 3 साल की प्रैक्टिस रहेगी, लेकिन यहाँ पे डिसाइड ये करना है कि ये आफ्टर सिलेक्शन, पोस्ट सिलेक्शन, जब आप जज बन जाएंगे उसके बाद 3 साल की प्रैक्टिस रहेगी, जो अभी तक समझ में आया, सुनने को आया है, जिसमें 1 साल तो ऑलरेडी हो रहा है, 2 साल और उसको एक्सटेंड कर देंगे, राइट। तो पोस्ट सिलेक्शन प्रैक्टिकल जो है ये करवाएंगे, 3 साल रहेगा। और भी कुछ सजेशंस है, तो भैया पॉजिटिव आया मैम, मैं तो ये कहूंगा, है ना, पॉजिटिव है, बिल्कुल पॉजिटिव है, और नेक्स्ट हियरिंग में हमें श्योरिटी मिल जाएगी, कंफर्मेशन मिल जाएगी कि 3 साल की वकालत तो रहेगी, प्रैक्टिस तो रहेगी, लेकिन वो सिलेक्शन के
से इस पे अपना एक डिटेल्ड व्यू लेकर आएंगे 20 मार्च को। अब तक उनका ये कहना है कि प्रैक्टिस भी इंपॉर्टेंट है, वेयर एज हमें इस वैक्यूम को भी कम करने की जरूरत है। हमें ऐसा भी नहीं करना चाहिए कि हम मेरिटोरियस कैंडिडेट का जो अपॉर्चुनिटी है उनसे छीन लें। तो यहाँ पे समवेयर और दी अदर एक बैलेंसिंग ओपिनियन आने वाला है, और बैलेंसिंग ओपिनियन हम सारे एस्पिरेंट्स के हित में आएगा, बिकॉज पोस्ट सिलेक्शन ट्रेनिंग पे कई बार जोर दिया गया है।
और मैम एक और चीज मैं यहाँ पे ऐड ऑन करना चाहूंगा, ये सिर्फ बिहार के लिए नहीं बोला इन्होंने, बोला जितने भी वैकेंसीज आएंगी सबके लिए जो है लास्ट डेट आप 30 अप्रैल रखे, तब तक हम डिसीजन सुनाएंगे। सो दिस इज नॉट स्पेसिफिकली टू बिहार, जितनी भी अभी अपकमिंग वैकेंसीज आएंगी सबके ऊपर जो है इन्होंने डेट के लिए बोला है कि 30 अप्रैल तक आपको जो है उसको डेट अलाउ रखनी है, एक्सटेंड रखनी है।
डेफिनेटली सर, और इस वाली बात से हमें एक चीज समझ में आती है कि 30 अप्रैल से पहले ये पूरा मामला सुलझ जाएगा कि क्या प्रैक्टिस होगी मैंडेटरी, या फिर आप ऐसे कह सकते हो कि कोई पोस्ट ट्रेनिंग जो है प्रोग्राम लेकर आया जाएगा जिसमें एलिजिबिलिटी सबको दी जाएगी कि सब लोग अपेयर हो सकते हैं एग्जामिनेशन में, लेकिन उसके बाद उनकी ट्रेनिंग जो है वो मैंडेटरी की जाएगी, राइट सर?
बिल्कुल मैम, सबसे इंपॉर्टेंट पॉइंट जो है जिसके ऊपर बार बार सीजीआई साहब कह रहे थे, पोस्ट ट्रेनिंग, वो बहुत इंपॉर्टेंट है। 3 साल की प्रैक्टिस रहेगी, बट वो सिलेक्शन के बाद जो है वो लोग मैनेज करेंगे, चाहे जुडिशियल एकेडमीज में हो, जैसा भी होगा उसका सोल्यूशन जो है प्रोवाइड किया जाएगा। और नेक्स्ट जो है 20 मार्च को हियरिंग होने जा रही है, उस दिन फाइनल वर्डिक्ट आपको देखने को मिलेगा। थैंक यू सो मच फॉर ज्वाइनिंग अस। और आप सबके लिए देखिए गुड न्यूज़ है, मैं तो इसीलिए खुश हो रहा हूँ, मुस्कुरा रहा हूँ, क्योंकि मुझे नजर आ रहा था कि पॉजिटिव चीज़ें निकल के आ रही हैं, और श्रीमी मैम को भी ये चीज़ वहाँ पे क्लियर हो गई थी कि अब पॉजिटिव कुछ ना कुछ होने जा रहा है। सो फ्रेश लो ग्रेजुएट्स जो है आने वाले टाइम में आप देखेंगे आप अप्लाई कर पाएंगे एग्जाम के लिए।
डेफिनेटली सर, मैं बहुत ज्यादा एग्री करती हूँ आपके इस व्यू पॉइंट से। वी आर पॉजिटिव एंड वी विल बी पॉजिटिव। अब हम जो है 20 मार्च को मिलेंगे हम आपको दोबारा से ऐसी प्रोसीडिंग दिखाएंगे कि क्या हुआ, क्या किया गया, और आपको बताएंगे कि क्या रहा फैसला ऑनरेबल सीजीआई का। टिल देन एवरीवन शुड बी होपफुल एंड कीप प्रिपेयरिंग फॉर द एग्जामिनेशन। एग्जामिनेशन की तैयारी नहीं छोड़ना है। जो चीजें पैरेलली चलती जा रही हैं वो चलती रहेंगी, कोई ना कोई नतीजा आएगा ही। आप अपने एग्जाम की तैयारी करें एंड विश यू ऑल द बेस्ट एंड स्पेशल थैंक्स टू ऑल द व्यूअर्स जिन्होंने हमें ज्वाइन किया इस सेशन में। थैंक यू सो मच।
थैंक यू सो मच, थैंक यू सो मच। गुड न्यूज है, प्रिपरेशन नहीं छोड़नी है, तैयारी करते रहो, क्योंकि 20 मार्च को जो है सीजीआई साहब वर्डिक्ट देने वाले हैं। और वर्डिक्ट में जो आज सीजीआई साहब ने थोड़ा सा जोर दिया है वो पोस्ट सिलेक्शन ट्रेनिंग है। बार बार मैं बोल रहा हूँ, पोस्ट सिलेक्शन ट्रेनिंग को पकड़ लीजिए और तैयारी जो है अपनी सुनिश्चित कर लीजिए। बिहार में भी आप लोगों को जो है अलाउ किया जाएगा फॉर्म फिल करने के लिए विदाउट 3 ईयर प्रैक्टिस, राइट। तो अब मिलेंगे 20 मार्च को, तब तक के लिए पढ़ाई करते रहें, आगे बढ़ते रहें और जज बनने का सपना जो है आपका डेफिनेटली साकार होगा, जैसा कि सीजीआई साहब ने बोला है और आप सबने देखा भी है।